All right.
That'll be fine, Your Honor. I'll just let him know if I have any issue with it.
You're an essential part of this litigation. You need to sign off on the order.
All right. Thank you, Your Honor.
2025 CV 47 Whitney Elmore versus John Keeney.
All right, this is an order of protection that Ms. Elmore had brought against Mr. Keeney. We've obtained an ex parte order of protection, and today's hearing is designed for the court to determine whether or not there is basis for extension of that order. First question is, do you want that order of protection extended?
I do.
All right. And do you oppose that extension of that order of protection, Mr. Keeney? You do not oppose it. You understand, or here today as a respondent, you're entitled by law to have a hearing where the state, where the plaintiff would be, a petitioner would be required to put on proof that would justify me in issuing this order of protection for an additional period of time up to 1 year. You can agree that that order of protection can be extended without having to have that hearing. So I'm asking you earlier, and I want to make sure we're clear, do you want to oppose this extension of this order, or do you agree to the extension of the order? You do not agree with this? All right, then have a seat there at that table. Ma'am, if you'll come around, I'm going to ask you, you've already been placed under oath, so you'll need to take the witness stand here, and I need you to testify as to all of the reasons why you feel like your order of protection needs to be extended, and that goes to, in other words, you're going to have to testify about why you sought an order of protection and all of the matters that are set forth in your original petition. Okay? Speak closely into that microphone so it's picked up.
He physically threatened me, put a handgun in my hand, told me he'd shoot me or shoot him, and he violently wouldn't allow me to go get my kids while they were crying in the middle of the night. He's put his hands on me several times. He's thrown me around several of our pregnancies. He's physically, verbally abusive. And I'm scared of him. And I don't know what he would do.
Now, do you have a copy of the petition that you filed?
I do not.
All right. In that petition, you filed that you made the following accusation. It says he's woken me up from bed, grabbing me, slinging me around, throwing things at me, forced a gun in my hand and told me to shoot myself or him. Also said I could leave, but not with my kids, and if I tried, then he would kill me.
Yes.
Now, is that something that you still?
That's all accurate.
Pardon?
That's all accurate. That's all.
Right. All of that is true and correct?
Yes, sir.
And when did those things occur?
I'm not exactly sure on the date. I want to say it was like the end of May or the end of June. No, I'm sorry, the end of April, because I left Ohio May 1st. So it happened that previous Saturday night was when that happened.
You signed this petition on May the 5th, I think it was.
Mm-hmm. I got here in Tennessee on the 1st.
And so you're saying that those things that you described occurred. You also stated that it's got to the point where our own kids are afraid of him. When he yells, raises his voice, they are scared, crying, I'm scared enough to not know what to expect next.
Yes,
Right. And your testimony is that that's the basis for you getting an order of protection.
yes.
And do you want the children to be involved in that order of protection as well, or do you want him to be prohibited from having any contact with you and the children?
I don't mind him being in contact with the children.
And under what circumstances were you and he living together before you got this?
Yes.
And so after you obtained this order of protection, what is your intent? Are you married to Mr. Keeney?
We're not married.
All right. Is there any custody order down between the two?
No, sir.
What are you proposing for him to be able to see these children? First of all, how old are they?
My son will be 3 in September, and then our twin girls will be 2 in November, and then I'm expecting a little girl right now.
So you're pregnant with his child?
Yes, sir.
So again, I can only deal with the children that are live born, but what are you specifically asking the court to do regarding a visitation schedule with him? And the
Well, he
children?
lives out of state, so I don't know how that would work.
He lives in Ohio?
Mhm. But like him communicating on the phone or whatever, I'm okay with that. But I just wouldn't want nothing to jeopardize him trying to take my kids back to Ohio. Because we're here in Tennessee. And we're not going nowhere.
Anything else you want to tell me about this situation?
No. No, sir.
All right, Mr. Kenny, you have questions. You're not required to ask questions, but I'm going to give you a chance to testify. But do you want to question her about anything that she said? All right, he doesn't want to question you, so you may step down. And you have a seat at the opposite table. Do you have any other witnesses, Ms. Elmore?
I have my mother, sister, and brother here.
All right, if you want her to testify?
She can, yes, sir.
Well, now this is your case, so understand what's saying that she can, it doesn't matter to me whether she does or not. It's up to you to put on the proof that you think justifies this. So do you want her to testify?
Yes.
All right, come up, please, ma'am. You're acting as your own attorney, so you're going to have to put her on the stand and question her. Raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Come around, please, ma'am. And I ask you as well to step to get as close to that microphone as you can and testify. Ms. Elmore, she is your witness, so if you will ask her the questions you think are important.
Do I need to stand or am I okay?
At the podium, I'm sorry. First of all, so that the record is clear, you are the mother of Miss Elmore, is that correct?
Yes, sir.
All right. And what is your name?
Patricia Wahardo.
Okay. Now, Ms. Elmore, we've established who she is and what her name is. You may ask any questions about her testimony. Needs to be regarding what this order of protection is about, the allegations of abuse and so forth. So ask her any questions you think is relevant.
On May 1st, the altercation that happened in the parking lot. Will you explain what happened? Okay, so on May 1st, I was in contact with my daughter just about every day. I knew the situation was getting very concerning to me. On Monday prior to May 1st, I actually talked to her, and from the abuse, verbal, mentally, physically, that she was sharing with me, I explained to her that day that if she didn't go to the school or go to the police station, that I was going to call myself. For the simple fact that I did not want to not hear from her one day, and I had to make that call. So on that day, to my knowledge, it was either that Monday prior to May 1st of that week or that Tuesday. I'm not sure. I have notes, but I didn't bring my notes with me. I'm sorry. It was one of them 2 days that she actually went to her oldest daughter's school and reported everything that was going on with her. I felt good in the fact that she did that, for the simple fact that somebody besides her knew what was going on with her. We continued to talk every day. She told me Tuesday night into Wednesday that she had to leave by May 1st is when she got her son's check. And she made the comment to me, "Mama, I will not make it another 30 days if I stay here."
That's when I decided to drive Wednesday night, all night. I met with my daughter that Thursday morning, May 1st. He made contact with me on my phone, begging me to let him see his children before we left.
Where do you live, ma'am? Where do you
I
live?
live in McEwen.
In McEwen, Tennessee?
Yes, sir.
Okay.
So I
Is
let
your
her
daughter,
know.
is your daughter living with you now?
Yes, but
Okay.
she's in a home. She's getting help. I
Okay.
have the children. I have temporary custody of the kids.
You have temporary
Yes,
custody of the
and
kids?
right now, neither one of them can see the children. That's court ordered.
All right. Is the juvenile court involved in this
Correct.
regarding the children? Okay. And so right now you've got temporary custody of the children through juvenile court, and you are following those court rules.
Yes, sir.
All right.
No contact with the dad. Right now I'm scared to even have a family calling because I don't know if he's there.
Right.
But so May 1st, he met us up, he caught up with us at McDonald's. Soon as he seen the van, he jumped out of his car like a madman, ran to the drive-through where she was at trying to get breakfast for the kids. And that woman that's with him there was at the parking, in the parking lot. Me and her were unaware that he had people there with him. He grabbed the keys to the van, threw them. That woman right there in the blue purple hair grabbed the keys, would not give them back to me, and I asked her to give them to me. Then he just went acting like John. Went into the van. Whitney, myself, asked him not to get the kids out of the van. Kids were screaming, crying by that time. He just ignored us to not get the children out of the car. He went to the back of the van, grabbed the 2-year-old, Briar. He was screaming, and he started walking in the parking lot holding his son in his hands. By this time, because of me watching him grabbing her keys, I was scared to was involved. I've been told 2 different police stations, so I'm still kind of working on that to see if anything was reported on that day.
All right. What you know about the physical abuse of your children?
No, not yet. No, they haven't. They suspended everything as far as juvenile court because of this.
Right.
She said we were at a standstill as far as the custody.
Well, juvenile court has priority over this court regarding custody of the children. Once children are taken into the custody of juvenile court, that court controls. Unless and until they conclude the litigation or they relinquish jurisdiction back to this court. But this court can only today issue or not issue an extension of an order of protection. In this case, it won't involve the children because they're under the protection and control of the juvenile court. So that's why that's important. All right. Thank you. Any other questions for her?
Yes.
Mr. Kenny, do you have any questions for this lady? Thank you, ma'am. You may step down and have a seat in the courtroom. So, do you have any other witnesses? No other witnesses. Mr. Kenny, you are not required to put on any proof, but you are given an opportunity, if you wish, to testify yourself or to call witnesses of your own. Do you want to testify in this case? Come on up. I would remind you that you were previously sworn, so you need to have a seat. So. Tell me, this is your opportunity to tell me why you oppose the extension of the order of protection and whether or not you think that there's a basis for that. So.
I wanted to extend it because
Speak up to the microphone.
I wanted to extend it because I'm afraid of the safety of my children.
You understand that the children, according to the proof, the children are under the control and jurisdiction of the juvenile court of Humphrey County and not this court. I don't have anything to do with the children because they're under the juvenile court. You understand that? So go ahead. And the question is having to do with this order of protection. It's only going to be between you and her. Juvenile court's going to control your access to the children. So do you oppose having this order of protection against you to keep you from contacting or being around her?
I don't agree with it.
All right, then tell me why you don't agree with it.
I just don't feel like it should be done like this. I should be able to be a part of my family. It was all false accusations. I mean, I don't know where the bruises have came from, but we had a big red-nosed pit. What? We had kids. She was a stay-at-home mother. I don't understand where any of this is coming from.
Okay. Anything else?
Yes, sir.
Ms. Elmore, you're acting as your own lawyer. You can ask questions if you want. You want to ask him any questions, you have to come to the podium, and it has to be in the form of a question. You've been given your opportunity to give your version of the event, so ask him questions.
So you never put your hands on me or threw me around?
No, ma'am. The only time I got physical is when you was physical. I was trying to get you away from me because I had our kids in my hands.
And when was that?
It was here in Tennessee when you came home drunk, when our oldest daughter said that you was running off the road into the ditches.
I'm talking about in Ohio, the reason why I left. Like, you're, and the gun that you put in my hand?
The gun was in the truck the whole time at Ariel's house in the pickup truck.
Okay. Yeah, I'm done, sir. I have no more questions.
You live in Ohio.
Yes, sir.
All right. You have any witnesses that you want to call?
Yes, sir.
Have a seat. Call your witness.
Ariel.
Raise your right hand. Be placed under oath.
Do you solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come around, have a seat in the witness stand. Mr. Keeney, this is your witness, so you're acting as your own lawyer. You're going to have to ask her the appropriate question. What is your name, ma'am?
Ariel Waller.
Ariel Waller?
Yes, sir.
Okay. Go ahead.
Which one did you see in our relationship physical?
So all of my knowledge has been that Whitney has been the one that's physical. I have recordings of her on my phone screaming and cussing at John. She even got physical with me at the.
What is your relationship with these parties?
So John is by law no blood to me, but he was raised as my brother.
Okay. And you've been around the two of them when they were living in Ohio?
Yes, sir.
Right. Go ahead.
I have recordings of Whitney screaming and cussing at John, and even the day at McDonald's, she grabbed a hold of my arm whenever I picked up her keys that were thrown. I picked them up, and she grabbed a hold of my arm, moved her around my arm. So that is to my knowledge the physical one. She also has like past history of being physical.
What other questions?
What was your story? What happened at McDonald's?
So my husband and John worked together, and they left for work already that day, and I seen John pull in a panic, and I walked outside and he was already gone, and my husband told me that Whitney was taking the kids and leaving the state of Ohio, and John went to go meet them so that he could see his babies, and when we got the word that they were at McDonald's, we went down there and they were already there. Whitney's mom was in John's face when I got there, and I got out of the car, and I told John to go calm down and picked up the keys, and then Whitney grabbed a hold of me, and I saw the keys in my hand. I told her just to wait for the sheriffs because we had already called the sheriffs. We called the sheriffs before we left my salon, which is only about 5 minutes down the road. And then when they went back to arguing, I set the keys on the top of her hood, and her mother and her uncle were there. Her uncle, to my knowledge, is a sex offender who's not supposed to be around children.
he was there and they were cussing me, and my husband told him that he had to leave me alone. The babies were in the car unattended, and John went and picked one of them up, Briar, the oldest. Ainsley, her oldest, was standing over there with me. I was just trying to keep her calm and keep her out of the hustle and bustle of the situation. And then the police got there, and they, the police in Ohio said that they were allowed to go and to take it up with our custody court, which we did. We filed for custody shortly thereafter.
Okay, anything else?
My dually was broke down at your salon, correct?
Yeah, your dually's been at my salon for a while now. He just now got it legal as of last week. We have a gated lot on the back of my salon. That's where it was at.
You what?
We have a gated lot on the back of my salon that my husband does like restorations on cars and stuff, so it's parked out there with it.
That's what I got was that. Because I always kept it in the truck because we
You're
had.
testifying, you can only ask questions.
That's it.
Anything else? All right, thank you. Ms. Emery, do you want to ask questions of this witness? Remind you that they must be in question form.
I just want to say I have nothing because they're under oath and it's nothing but lies. So I'm good.
Have a seat. Thank you, ma'am. You can sit down.
Thank you.
Can you have any other questions? Any other witnesses? I'm sorry. You have any any other proof? All right. What I can tell is very clear from this situation is that the relationship between the two of you is extremely volatile, and I think it's best to try to separate the two of you. Court finds that there should be an extension of this order of protection, but I'm not going to extend it for an entire year. I'm going to extend it for 6 months. And this only applies to the relationship between Ms. Elmore and Mr. Keeney. In other words, I'm not preventing you from having contact with your children, but you're not to come around or threaten or harass or have any contact with Ms. Elmore other than that which is allowed by the court regarding the visitation with your children. You understand all that? All right. It'll be for a 6-month period. If you'll have a seat in the courtroom, a seat out in the hallway, I can give you a copy of this after I'm finished filling it out. Thank you.
Got to initiate this live stream. Okay, looks like it started. So again, I'm Judge Hamilton with the Amarillo Municipal Court. I need to see your face on the camera. So Ms. Garcia, you need to mute yourself. I'll go ahead and do that for you. And we'll unmute you when it's your time. So Ms. Martinez, if we could see you also, that would be great. Ms. Morgan, please don't make me look at your ceiling fan. You'll get the camera on you. Prosecutor's here today. It's Mr. Arthurs. He's in a breakout room. He may have sent you an invitation to go to a breakout room if you qualify to speak with him. If you want to do that, you are welcome to accept his invitation. You never have to speak with the prosecutor. But Jose Reyes, you don't have any audio. Did you talk to him? Caitlin?
I did.
Yeah,
Oh yeah, there you go.
can you hear me? I'm sorry about that.
Where are you? You need to turn your camera on.
Purple shirt.
Miss Garcia, you've got to sit down. Mr. Reyes, I don't see you. You need to turn your camera on.
Camera's on. It is on. It's probably on.
You're not in, your camera is not attached to your Zoom.
Yeah, it's probably because the Wi-Fi. Let me step outside.
For you?
Sure. Okay, he'll be back here in just a minute, and so we'll hear what he says, okay?
Okay.
Has anybody else already spoken with the prosecutor and I haven't spoken with them? Okay, does anybody else want to speak? You've already spoke, thank you, Mr. Frost. Miss Garcia, did you want to speak with the prosecutor? Just, you're muted, so just say yes or no. Okay, thank you. I don't have paperwork for Miss Garcia.
I'll redo it.
Thank you. And then, let's see, who else do I have? Oh, Miss Reynoso, I'm gonna go ahead and mute you. It's just easier on Zoom
Okay.
if everybody stays muted, or else it gets weird. Thank you. So Miss Martinez, can you pay just the first one? Try to pay the first one.
Is it the, give me a,
I'm recapping. For my own sake, Miss Reynoso.
I
Okay.
thought you said that I needed to speak with him, but I already spoke with him.
Oh, that's right. But we're just waiting on him to come
Okay.
back. Okay, thank you. And then I have Miss Garcia, who can't stay by her camera. Miss Garcia, if you can get yourself unmuted now. Let me see if I can send you a prompt. Sometimes it's difficult. There
okay,
you
there you,
Okay, what's going on with your payment plan?
okay, so I was employed at Whataburger. And I have issues, I guess, with my mom. And we were at the domestic violence shelter.
You and your mom were?
No, I was because she kicks us out all the time, so
Oh.
I lost my job because of the whole thing. So I was wanting to see if you could give me some time. I just got another job at a hotel. It's gonna take about a week and a half for them to hire me. But I need to put my kids in daycare.
Do you have CCMS?
I just called today and I left Lorraine a voicemail to see if she could help me get on CCMS. Because I was working overnights at Whataburger and my mom was watching my kids. But since all that stuff happened, now I have to
Actually, you were in a shelter in March.
and then I went back to my mom's and I got a job at Whataburger. So that's what's going on. And I apologize that I don't, uh-huh. I just have my kids. I'm sorry. It's not that I'm trying to move around everywhere. I have them. So what is it that I can get help with?
I don't know. Let me take a look and see.
Mm-hmm. In a minute, I just put them in the microwave and in a second I'll get them, okay? Be careful. Be careful.
You
That-
haven't,
that's
made a-
going to
you
hurt.
haven't made a payment since we reset your payment plan.
Yes, ma'am, I know. My mom ended up going to jail, I guess, for something about last year. A lady threw a cup in her face, and the lady ended up losing her phone and then wanted to press charges on my mom. And then the cops came to my mom's house and they took her to jail. And hey, stop. Okay, in a minute, I said, please.
Do you have anybody who can watch your kids so you can come to an indigency hearing?
I can see.
Are you getting any child support?
I'm not. I'm not. I want to get back on TANF and stuff. That's why I made that appointment with
When were you on
Lorraine.
TANF?
Stop it.
Mr.
Stop.
Mr. Arthurs, Mr. Frost needs to talk to you too.
Yes.
Okay, I'll pull him in.
Thank you. Ms. Garcia, when were you on TANF?
I was on TANF, I want to say, maybe 2023.
Okay.
No, give me that. No.
When are you going to try to get back on TANF?
I just did the appointment with Lorraine. I called her and left her a voicemail. So tomorrow morning, I'm pretty sure she'll get back to me. Please. Please. So as soon as I can get in touch with her, I can get the kids in CCMS. They're already cleared. I got them cleared through their pediatrician to go to daycare.
My
So I'm
number one
trying, ma'am.
question, my number one question is going to be, can you get on TANF? Will you find out tomorrow?
Yes, I will be able to. I just need to get in there and speak with her.
Okay, here's the deal. You're not going to go to Warren. I'm gonna let me think the easiest way to do this.
I have a warrant.
No, I said
Okay.
you're not going to go to Warren.
Okay.
Not yet. Let's hold off. That's
I'm sorry. It's just their dad doesn't help, and
uh-huh. And you know, it doesn't help to get all those tickets. You got like 7 tickets that day, 6 tickets.
I know. I was going to go wash laundry, and
You've
I
had
missed the
30
laundromat.
tickets. You've had 30 tickets.
Yes, I know. I apologize.
I'm just
I'm
saying.
so
to
sorry.
apologize. I just
I
am like,
know.
life is already difficult without tickets,
Right.
you know? So can you come back to this Zoom like on Wednesday?
Yes, I can.
I want to find out if you get TANF or not. That changes everything for me.
Okay.
If you go and talk to Lorraine or whoever it is tomorrow,
Okay.
and you qualify for TANF, I need you to show me proof, not just tell me.
Yes,
But
ma'am.
I need email that you are on TANF.
Okay. I can do that for you.
I want
I'm
you to
trying as fast as I can. It's just
I want you to get a driver's license.
if I didn't have my kids, I could get everything
I know,
done. You know, it's just my
but if
baby.
I
They
know
only have me. I'm sorry.
it's okay. You've got a lot going on. So, you know, I want you to be a legal driver. And it's like you've never actually started from that
Right.
standpoint. So I want things to be better. Okay.
Yes, ma'am.
Okay. I'm going to hold on to this, and Caitlin, have Lori send her a notice to come back on Wednesday.
Yes, ma'am.
And then we're just going to make a note. I'm just going to make a note in the file, that I need to find out what government assistance she qualifies for when she goes tomorrow.
Okay.
Okay. Hey, Miss Garcia, it's okay. You're not going to go to Warren, not yet. So You're doing the right thing by coming in and seeing us, okay?
Right. Okay.
Thank you, ma'am.
All right.
Uh-huh. It'll be okay.
Thank you. Bye-bye.
Bye-bye. And folks, we're gonna wait for Mr. Arthurs. He'll be here in a minute.
Your Honor,
Yes, ma'am.
I just wanted to double check if you were able to see, or if you are able to see that I was able to make the payment.
Let's double check. Looks like it started. So again, I'm Judge Hamilton with the Amarillo Municipal Court. I need to see your face on the camera. So, Ms. Garcia, you need to mute yourself. I'll go ahead and do that for you. And we'll unmute you when it's your time. So Ms. Martinez, if we could see you also, that would be great. Ms. Morgan, please don't make me look at your ceiling fan. You'll get the camera on you. Prosecutor's here today. It's Mr. Arthurs. He's in a breakout room. He may have sent you an invitation to go to a breakout room if you qualify to speak with him. If you want to do that, you are welcome to accept his invitation. You never have to speak with the prosecutor, but you're always welcome to speak with the prosecutor. Prosecutor's the state's attorney. They represent the state only, but sometimes they can explore some of your options and things with you that I cannot. Try to pay the first one.
Is it the, give me a second, the 260 or the one?
Should be the 260.
Okay, and go ahead and just pay that one?
Yeah.
Okay.
If it'll let you.
Okay.
Perfect. Okay, so Miss Smalley speaking with Mr. Arthurs. Ms. Morgan. Did you want to speak with Mr. Arthurs, Miss Morgan? Miss Morgan,
I'm here.
do you want to speak with Mr. Arthurs, the city's prosecutor?
No.
No? Okay. So you have a driving without a license and a failure to control speed citation. So that means by law, you don't qualify for driver safety course. What do you want to do on those? You can plead. Go ahead.
Can my fiance talk to you? Would it be okay if my fiance talked to you about it?
Okay, well, we obviously had an electrical glitch down here because of the storm that's going on. So, Miss Morgan, tell me again what you wanted to do.
Is that right if my fiance talks to you about this?
Is your fiance a lawyer?
No.
Okay, then no. Okay, unless your fiance is an attorney, then you're representing yourself here today. So tell me what you were wanting to do. Are you trying to keep this off of your driving record?
Yes, ma'am.
Okay, so your other option, did you have insurance that covered this accident?
It wasn't my vehicle, it was a friend of mine's vehicle.
And do you know if the insurance covered this accident?
Not that I know of.
Okay, so our position here at our court is if you're going to take responsibility for the citation, then we're not going to let you do deferred disposition for the failure to control speed because you didn't have insurance. So you can plead not guilty, no contest, or guilty.
No
No contest? Okay, on both?
Yes.
Okay, if you plead no contest, I'll find you guilty. I'll assess fine and court cost of $175 on the driving without a license and $245 on the failure to control speed. Can you pay those today?
On the one where it says fail to control speed, I wasn't even speeding.
Not a speeding ticket, ma'am. It's a ticket for getting in an accident.
Oh, okay, okay.
Yeah, it's different. It's if people think, oh, wasn't even speeding. And you're like, you don't have to be speeding to get that ticket. It's just the name of the offense.
Just let her know. I get paid every Wednesday after 5 p.m. So one of the tickets will be paid off this Wednesday. So the last ticket will be paid off next Wednesday after 5 p.m. Let her know.
Here's what you can, I can hear him. Miss Morgan, what you could do is just get both of them paid within the next 30 days.
Oh, yeah.
So that gives you a little bit of flexibility on those payments. Just get the whole thing paid by the 30th day after today. Okay, Miss Morgan? Are you working on getting your driver's license?
Yes, ma'am.
Perfect. Okay. Yeah, try to get that driver's license so that maybe that'll help out next time. Okay? Then you would qualify for some better options. We're going to send you your payment extension agreement. Would you like that by mail or by email? You'll have to be able to print it if I email it to you.
Can you repeat that?
Yes, I can send it by mail or by email. You have to be able to print it if I email it to you.
What is it?
And what is it again?
It's your payment extension agreement. You have to sign that and you have to fill out a contact form.
Do it by mail.
By mail.
Okay. Okay. I'm going to mail it to you at the address you confirmed with Caitlin. Thank you. You're free to leave. Back. Caitlin, are you back?
Finally back.
Yeah. Okay. So I just finished with Miss Morgan.
Yes.
Miss Morgan entered no contest, please. And is going to pay in full within 30 days. And she's a by mail person.
Awesome.
Okay, let's go back to Miss Martinez. So
Yes, ma'am.
Miss Martinez, we had a power outage, so let me look and see what you sent us in the chat.
Okay.
And so I have 0 chat because we had the power outage.
Oh, basically I just paid the 2 that was available to me. Just the warrant issued one is the one that I have remaining.
Okay.
I have the confirmation numbers and everything. I paid $460 in total.
I'm gonna look at, I'm sure I have a warrant for a speeding ticket. You owe $283. I'm not going to discuss it with you over Zoom, especially since I can't see you. So you're welcome to take care of it online or cashier's window. It's $283. You're free to go. Marlene Martinez.
Okay.
Yes.
Ms. Martinez, you have a failure to control speed and a no driver's license. You still owe $450 on those.
And I was trying to pay them online. It just said I just had to talk to you first.
It's because you're a juvenile, or you were a juvenile when you got them.
But, I would,
And I'm still talking, and now you have a warrant because you didn't take care of them and we asked you to come back and you didn't come back. So you have a warrant for the violation of continuing obligation to appear as a juvenile. So on that ticket, you owe $269. You need to get that one paid so that you can get your warrant lifted. Can you pay that today?
yes.
Okay,
Well, to pay them all today?
I need the $269 paid first.
Okay, and then the rest?
So can you pay the $269 right now?
Yes.
Okay, block your audio, block your video, go to the court's website, make the payment. Come back and I'll talk to you about the other two, but you have to pay. Well, Caitlin will let her do that.
You were wanting her to pay on the one that's at warrant?
Uh-huh.
I think it will make her do the oldest one.
But the oldest one's a juvenile one.
Yeah, I have that. I'm not a cashier, so I don't ever do it.
Yeah, try it. Try to go on there and pay the $269. If it won't let you do that, then just pay off the oldest one, and the oldest one is $260.
Okay.
But I want to see a payment and then come back and we'll talk about the others. Thank you. Colin Moon? Or
Yes, ma'am.
the line? Hi, Miss.
Colleen.
Okay, you have a speeding 93 and a 60. That's a Class C misdemeanor, punishable by a fine of $1 to $200. I will tell you, don't by law qualify for a driver safety course. You're going too fast. And we generally will give people deferred disposition who are going that fast. So you can plead not guilty, set your case for trial, or plead guilty or no contest. And then, let's see, who else do I have? Oh, Miss Reynoso, I'm gonna go ahead and mute you. It's just easier on Zoom
Okay.
if everybody stays muted, or else it gets weird. Thank you. So Miss Martinez, can you pay just the first one? Try to pay the first one.
Is it give me a second, the 260 or the one?
Should be the 260.
Okay, and go ahead and just pay that one?
Yeah.
Okay.
If it'll let you.
Okay.
Perfect. Okay, so Miss Smalley speaking with Mr. Arthurs. Ms. Morgan. Did you want to speak with Mr. Arthurs, Miss Morgan? Miss Morgan,
I'm here.
do you want to speak with Mr. Arthurs, the city's prosecutor?
No.
No? Okay. So you have a driving without a license and a failure to control speed citation. So that means by law, you don't qualify for driver safety course. We're just finished with Miss Morgan.
Yes.
Miss Morgan entered no contest, please. And is going to pay in full within 30 days. And she's a by mail person.
Awesome.
Okay, let's go back to Miss Martinez. So
Yes, ma'am.
Miss Martinez, we had a power outage, so let me look and see what you sent us in the chat.
Okay.
And so I have 0 chat because we had the power outage.
Oh, basically I just paid the 2 that was available to me. Just the warrant issued one is the one that I have remaining.
Okay.
I have the confirmation numbers and everything. I paid $460 in total.
I'm gonna look at, I'm sure it shows there. I'm actually surprised. It was crazy with the power going out, so.
No, yes, I understand.
Let me take a look at it for just a second. Mr. Arthurs?
Yes, Your Honor.
I've been speaking with Miss Martinez. She was a juvenile when she received a no driver's license and a failure to control speed ticket. She's just paid both of those. She was at warrant on a violation of continuing obligation to appear. Did you want to talk to her, maybe see if there was something that she's at warrant on the violation, but like I said, she's paid the other 2.
Okay.
Do you want to
Yeah.
possibly talk to her and see if the state's
I'll talk to her.
do anything on those tickets? So Miss Martinez, I'm going to have you speak with Mr. Arthurs.
Okay.
He's the city's prosecutor. I do see those payments were made. Thank you for getting those paid. If you will go into a breakout room with him.
Okay.
But
Does
yes,
it automatically transfer me there or do I have to go like to a separate?
I think he sends you an invitation.
Okay,
And he's actually sent you that, so you just go to that option.
okay, give me just this, okay, okay.
Yeah, but let him, I need to talk to him about these other cases and that'll just take a minute, okay? So, Mr. Arthur's, what else do you have to, oh, he went into that room, so you going in there. I guess they did. Okay, so Ms. Reynoso wants to talk to the prosecutor. Mr. Frost, you want to talk to the prosecutor? You're muted, sir. And folks, we're gonna wait for Mr. Arthur's. He'll be here in a minute.
Your Honor,
Yes, ma'am.
I just wanted to double check if you were able to see, or if you are able to see that I was able to make the payment.
Let's double check. Yep, you did it. Thank you so much.
Perfect. Thank
Okay.
you. And
Bye-bye. Have a good day.
bye-bye. Thank you.
So you filed it, you pled not guilty. You're welcome to look at the evidence in the state's file. You're welcome to set it for trial later by judge or by jury, okay?
Okay.
Okay, thank you, Ms. Reynoso. You're
Thank
free
you.
to leave.
Mhm.
Okay, Mr. Arthur's.
Next, I spoke with Marlene Martinez.
Okay, Ms. Martinez, you can come back with us.
Yes, ma'am.
Okay,
I made her an offer since she took care of the other two, that we can do a change of plea for 200 on this violation. And she
Okay.
said that she didn't pay it today, I believe.
sure. Okay, Ms. Martinez, can you, let's bring you back on camera if we can.
Yeah, I have to flip it. Give me a second. Yes.
Okay, there you go. Do you wish to accept the state's offer?
Yes.
Okay, do you want to plead guilty or no contest?
No contest.
Perfect. Okay, so in exchange for your plea of no contest, you're gonna be found guilty of assessed fine and court cost of $200. And you're gonna pay that today?
Yes, ma'am.
Okay, and then everything's gonna be cleared up, Miss Martinez. Must feel
Okay.
better.
Okay, thank you.
Thank you. Have a good day.
You as well.
And then Mr. Arthur's,
I spoke with Pawnee Smalley.
Tawny Smalley. And Miss Smalley, I am gonna make an order that we fix your name to match your ID and instead of Pawnee, it'll be Tawny.
Oh, yeah.
There you go.
Thank
Okay.
you. I'm gonna figure it out.
Yeah, you have a speeding 70 and a 60 and operating a vehicle with expired. Tap your screen and unmute. There you
This
go.
is she.
Hi, you have a parking in a fire lane citation. How do you want to handle that?
I want to contest it.
Great. Okay. Then I'm going to have you enter a not guilty plea.
And I had sent in the video evidence.
That's a conversation you can have with the prosecutor. I'm going to reset your.
I did speak with the,
You spoke with him today?
if it was the gentleman before you.
Sure. Okay, he'll be back here in just a minute, and so we'll hear what he says, okay?
Okay.
Has anybody else already spoken with the prosecutor and I haven't spoken with them? Okay, does anybody else want to speak? You've already spoken. Thank you, Mr. Frost. Miss Garcia, did you want to speak with the prosecutor? Just, you're muted, so just say yes or no. Okay, thank you. I don't have paperwork from Miss Garcia.
I'll redo it.
Thank you. And then, let's see, who else do I have? Oh, Ms. Reynoso, I'm gonna go ahead and mute you. It's just easier on Zoom
Okay.
if everybody stays muted, or else it gets weird. Thank you. So Ms. Martinez, can you pay just the first one? Try to pay the first one.
Is it give me a second, the 260 or the one?
Should be the 260.
Okay, and go ahead and just pay that one.
Yeah,
Okay,
if it'll let you.
okay.
Perfect. Okay, so Miss Smalley speaking with Mr. Arthurs. Ms. Morgan. Did you want to speak with Mr. Arthurs, Ms. Morgan? Ms. Matt, so you just go to that option.
Okay, give me just this. Okay, okay.
Yeah, but let him, I need to talk to him about these other cases and that'll just take a minute, okay? So, Mr. Arthurs, what else do you have to, oh, he went into that room, so you going in there. I guess they did. Okay, so Ms. Reynoso wants to talk to the prosecutor. Mr. Frost, you want to talk to the prosecutor? You're muted, sir.
Yes, ma'am. I believe I need to.
Okay, and Ms. Smalley's already spoken to the prosecutor. Ms. Reynoso is going to talk to the prosecutor, and then I have,
I already spoke with him.
yeah, I know. I'm recapping. For my own sake, Ms. Reynoso.
Oh, I thought you said that I needed to speak with him, but I already spoke with him.
Oh, that's right. But we're just waiting on him to come back. Okay, thank you. And then I have Miss Garcia, who can't stay by her camera. Miss Garcia, if you can get yourself unmuted now. Okay, Mr. Arthurs.
Okay, let's start with Maria Reynoso.
Okay, Miss Reynoso, if you'll come on back.
Maria's got a parking ticket. I told her what you should do is plead not guilty and file a request for discovery on this.
Okay. Okay, Miss Reynoso, did he explain how you could file that motion for discovery?
I thought just being present and saying that I would like to file that would be the.
No, actually you have to file an actual motion. So we can send you a motion for discovery you can file so that you can then look at the evidence in the state's file if you want. Did you want to do that?
And that's the only option. I just hate to postpone this. I don't want to get into the situation where I forget and then as I've heard, people get warrants. I don't like having this over my head, and I was trying to take care of this today.
Sure, but you can't have a trial today. And if you said, this is.
I was hoping to dismiss it.
Well, he doesn't want to dismiss it, I guess. And that's Mr. Arthur's prerogative. He's the city's prosecutor. So, I mean, were you thinking that somebody else was driving your car or what?
No,
why?
I was saying, as I said to him, that I was in a parking space and I provided the evidence showing that is not a fire lane, it's a parking space. And
well, let me
that's what.
Sure, and I don't want, this is not your trial. I'm not here to dispute it, but this is what the ticket shows.
Yeah, and it's not like I get tickets left and right.
Do you see that, ma'am? Is that your vehicle?
Yes, I'm in a parking space.
No, you're in this is a parking space. This is not a parking space where your vehicle is.
I provided the video that shows.
Okay, so that's between you and Mr. Arthurs. So anyway, okay, well, you can certainly file a motion for discovery. Caitlin, go ahead and mail her a do you, mail or email, ma'am? What's the best way for us to reach you?
Probably, and so I would print it out? Is that what you're
You
saying?
would
I
need
would
to
print it
print
out?
it. You would need
Would-
to print it.
Yeah, just mail it.
Okay, we're gonna mail you a motion for discovery. I have to reset this case. So you're gonna come back to court. Well, you can, today's not your trial day. He doesn't want to dismiss it. So you have to follow the standard court process. So you filed it, you pled not guilty. You're welcome to look at the evidence in the state's file. You're welcome to set it for trial later by judge or by jury, okay?
Okay.
Okay, thank you, Ms. Reynoso. You're
Thank
free
you.
to leave.
Mhm.
Okay, Mr. Arthurs?
Next, I spoke with Marlene Martinez.
Okay, Miss Martinez, you can come back with us.
Yes, ma'am.
Okay,
I made her an offer since she took care of the other two, that we can do a change of plea for 200 on this violation. I think
Okay.
she didn't pay it today, I believe.
sure. Okay, Miss Martinez, can you, let's bring you back on camera if we can.
Yeah, I have to flip it. Give me a second. Yes.
Okay, there you go. Talk to him about these other cases and that'll just take a minute, okay? So, Mr. Arthurs, what else do you have to, oh, he went into that room, so you going in there. I guess they did. Okay, so Ms. Reynoso wants to talk to the prosecutor. Mr. Frost, you want to talk to the prosecutor? You're muted, sir.
Yes, ma'am, I believe I need to.
Okay, and Ms. Smalley's already spoken to the prosecutor. Ms. Reynoso is going to talk to the prosecutor, and then I have,
I already spoke with him.
yeah, I know. I'm recapping. For my own sake, Ms. Reynoso.
Oh, I thought you said that I needed to speak with him, but I already spoke with him.
Oh, that's right. But we're just waiting on him to come back. Okay, thank you. Child support.
I'm not. I want to get back on TANF and stuff. That's why I made that appointment with
When were you on
Rain.
TANF?
Stop it.
Mr.
Stop.
Mr. Arthurs, Mr. Frost needs to talk to you too.
Yes.
Okay, I'll point him in.
Thank you. Ms. Garcia, when were you on TANF?
I was on TANF, I want to say maybe 2023.
Okay.
No, give me that. No.
When are you going to try to get back on TANF?
I just did the appointment with Lorraine. I called her and left her a voicemail. So tomorrow morning, I'm pretty sure she'll get back to me.
Okay. So you would plead no contest and the court would defer or put off that finding for you, it would be 30 days. Okay.
Okay. Okay, perfect. Sounds good.
Thank you.
Thank you.
Thank you. Caitlin, will you ask admin to expedite that name change?
Yes, ma'am.
Thank you. Mr. Frost and Mr. Arthurs.
I talked to Mr. Frost, Your Honor, and apparently he doesn't drive very often, but on this particular day he did. He doesn't want to do a deferred or anything. I took some money off of this and I think he was set on a payment plan.
Okay, so tell me what your fine offers are.
For the first one, I went from 157 to 137. Operation of vehicle with expired license plate.
Okay.
I think, oh wait, did you want, Mr. Frost, did you say you were gonna get that vehicle?
Yes, sir.
Yeah, he's gonna go get it registered.
Yes, sir.
Uncle. So this one, if we can put off this one, the same deal Mr. Frost as the other girl did, so. Make sure you pay the late fee.
Okay.
Whoever does, yeah. The other two, unless you're gonna pay, unless you want to sit on a payment plan, it's up to you. I know we were back and forth on that.
Okay. Yeah, you had said that we could defer it for 30 days and then so that it all be done at the same time.
Oh, you
Yeah,
want to do that?
Yes.
Sure. I can reset them all for about 30 days. Do you want to come back in person or on Zoom?
I'm not sure. It just depends. The reason I set up the Zoom is because I had planned on being at work today and we work out on ranches, so we're not able to be here. That's the reason I set it up. But then I had paperwork that I needed to bring in and file, so I just went ahead and took the day off. But I already had the Zoom set up. I'm actually here in the courthouse. At the
I
moment.
know you're in the courthouse. I saw my bailiffs helping you get your Zoom going.
Yeah, yes.
So here's what you're gonna do. I'm gonna send you to window number 5 right now. Do they
Okay.
have you sitting in our jury room? Where are
What's
you,
that?
where are you sitting right now?
No, ma'am, I'm in the hallway.
Oh, bless your heart. Okay, so go to window number 5. They're going to
Okay.
reset your court date.
Okay.
Get the registration updated, pay the late fee, then you're gonna come back with $20 on that. So instead of 157, it'll be 20, but you have to pay the registration, which should be about $85.
Okay.
You need to go get your driver's license renewed if you can. Can you do that?
There's no reason I can't. I just haven't had the time to. I
Well, see,
work
you
Monday
took-
through Friday, so
You
when
took today off, so.
I did, and I can't even afford that. It's
I know.
like,
But you gotta get you gotta get your new driver's license, and you're there, if it's really expired, like if it's like
10
been a
years.
long time, oh my goodness. Well, they may make you retake the test, so just go find out, okay?
Yes, ma'am.
And it's 4:30, darn, I was gonna say do it right now, but I think it's probably too late. And
Yes,
then,
ma'am.
on your insurance, if you can come back with the proof of insurance and the $315, like showing you have insurance now, you can defer that case. And that keeps it off of your driving record. You don't want to have no insurance tickets on your driving record. Makes your insurance more expensive, number one. But number two, it could eventually lead to a driving license suspension and just get you, it like starts you in this hole that it's really hard to get out of.
Yes, ma'am. It's expired already. I don't know if you could suspend an expired one, but yes, I do understand.
You can suspend an expired one. We suspend driver's license of minors and they don't even have a driver's license yet. But so that impedes their ability to eventually get
To
one.
get it. Yes, ma'am.
So I mean, I think you might have heard me say to somebody else, life is already hard. So don't make it any harder not following these pretty simple rules, right?
Yes, ma'am.
Okay, so go to the docket desk, window 5. So you're in the hallway. So you probably need to go down the hall, probably to your left, and go to window 5.
Okay.
Okay?
Yes, ma'am.
Are you right by the clipboards?
I can
Do you
barely
see
hear you.
clipboards in the hall?
What's that?
Do you see clipboards in that hallway?
I do not see any clipboards, no,
In
ma'am.
the
He is. He's down there by y'all's door.
Oh, he's down here. Okay,
Yeah.
then go to your right. Why do you know that, Caitlin? That's
Whenever I
She
was
walked
waiting for
past
the
it.
computers to reset, I had to run out in the hall real quick.
Oh,
Yeah.
yeah. So go to your right and then it's the first hall on the left.
Yes,
Okay?
ma'am. Okay.
Okay, thanks, Mr. Frost. We'll see you
Thank you.
in person in about 30 days. Thank you.
Okay.
Okay, Mr. Arthurs,
Every day in the USA, people find themselves in court.
Good morning.
Good morning. Mr. Bankstein, if you could join us also.
Thank you. I'm having a little trouble with the video, but I can hear you.
All right, very good.
I'd like to know if we could go into a breakout room briefly to try and explore settlement or payment arrangement.
Certainly, that's fine. Let me call the case. This is entitled LVNV Funding LLC versus Justin Pratt. Attorney Michael Bankstein is here on behalf of the plaintiff from somewhere. Attorney Jocelyn Oy is here at 7:10 a.m. from Las Vegas, Nevada. And she's representing this defendant. It's a claim for $4,640.88 plus cost, interest, and attorney fees. And we're always amenable to a breakout room and discussion. Is that agreeable to you, Ms. Oy?
That's fine.
All right. Let me set this up. I'll just wait here and work on some other matters. And I'll be here when you get back.
Thank you.
Thank you, Your Honor.
We tend to take for granted how convenient this is, particularly in civil matters. About 10 years ago, there were some applications or some companies that were marketing themselves as go to court or other things where you could set up virtual video conferencing. When COVID hit, Zoom became the answer to everybody's question. One of those attorneys is in the Detroit area. The other was in Las Vegas. I try to start exactly on time in these matters so the lawyers don't have to wait in a queue. Ms. Oy is in Las Vegas, represents clients all over the country. Mr. Bankstein and LVNV Funding also have cases all over the place. So our little cases here in Centerville, we try to start on time. Within 30 seconds, we've set up a conference and an opportunity for the parties to talk. And they talk for about a minute. So let's see where we are. What's our status here?
Your Honor, we're asking for a 60-day adjournment. There is a settlement offer, but there's I don't know, maybe an attorney for a defendant is in a better position to explain those details, or you might not need those details.
Well, let's hear it. What's the status, Ms. Oy?
Your Honor, plaintiff's counsel gave us a settlement offer. I presented that to the debt settlement company that's working with this particular client and the client. I'm in the process of trying to remove myself from all of the debt settlement company's cases. And so the client was informed that there should be a new attorney subbing in for me. But to this point, I have not received any notification regarding that sub of attorney. That conversation last took place on May 23rd.
I saw your notice. I wasn't quite sure what it meant. Defense counsel law firm has changed. You were with another company. Now you're just going to be on your own LLC.
Yeah, Your Honor, so I took all the files with me when I went on my own, but what happened is I work as a contract attorney for a large debt settlement company, and they have not paid my bill. So I'm in the process of trying to withdraw from all their cases. They asked me to hold off so they could do a sub of counsel instead. So I'm just waiting for them to provide me with that documentation so that I can go ahead and sub out for that reason.
Well, that sounds like an attractive job to take on a company who doesn't pay their.
It's a mess.
All right. On the legal definition, if we look it up in Black's Law Dictionary, it says this is a big mess. Yes. All right. Well, Mr. Bankstein, I appreciate your understanding here. I'm not sure where we are. This debt isn't outrageous, and I don't know what else this defendant has, but may have new counsel.
Yeah, I'm fine with the adjournment because I want everybody to kind of be on the same page and for it to work for everybody.
Very good. What's the name of the debt consolidation company?
It goes by either guardian is who I report to directly, but the client says that he signed with alleviant or alleviate.
Well, today is June 2nd. Let's adjourn this to August 4th.
Okay. And Your Honor, in the meantime, if I'm able to get this settled with plaintiff's counsel, I'll certainly continue to work on that so that we can get it off your calendar. Again, it's not a big debt. The offer to settle is reasonable. My hands are just tied because of who they're working with.
All right. Continued August 4th, 2025 at 9 a.m. Parties will continue to work on settlement. Ms. Oy, until somebody else does appear, all the notices are going to go to your office.
I understand that, Your Honor. That's fine. I provide that to the company as I receive them.
Very good. All right. Thank you both. You can get on with your morning and we'll continue with ours. Thank you.
Thank you, Your Honor.
Have a great
day.
All right. We're working on it. Pretty good so far. All right. Our next matter is at 9:30. And frankly, I had expected an order of dismissal in this case. Jefferson, I have two at 9:30 because I thought one was going to dismiss.
It's Lo didn't even do anything. Put her name on nothing.
She was here representing.
I just. Oh, you're just gonna stick up for her like that? Really? Okay. Court does call the case. People versus, is it Jamoya Byers? This is an arraignment. Hello, what's your name?
Jamoya Byers.
Okay. And you are before the court on a complaint that alleges that on or about May 2nd, 2025, at the location of 3000 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of domestic violence on Narnell Lincoln. Do you understand the nature of that charge, ma'am?
Yeah.
That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
All right. This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Byers. We'd waive any further reading, stand mute to the charges, Your Honor, and request an additional pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to June 16th, 2025, 9 a.m. I need a DD bound form. Anything you want to say regarding bond?
Your Honor, I do ask for standard conditions and a personal bond. I did have a chance to briefly speak with Ms. Byers out in the hallway. She indicated that her and the complainant in this case are married. They do not live together, however. So I would ask for a no go to in this case.
Say that again, that last part you said.
Well, since they're not living together, I'm asking for that the court do not enter a no go to. I would ask for.
Carpenter Road is, it's a business, isn't it?
2000 Carpenter Road. Do you know where that is?
You know what that is?
Is that the store?
3000 Carpenter Road.
Okay. given that they are married, Your Honor, I don't know any of the facts of this case. I would ask the court consider no non-consensual contact.
And Your Honor,
Yes.
on behalf of people, on the police report, it has her address as one in Ann Arbor. His address is a location in Taylor, Michigan. So I
Don't believe that there. That's like Kroger, isn't it?
It's the gas station, at the corner of Packard and Carpenter.
It's the Speedway.
Correct, Your Honor.
Okay. All right. All right, what I will do is I'll set the defendant's bond at $10,000 personal recognizance bond. I will order standard conditions, including no assault behavior or any possession of any weapons. There is also to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand all that, ma'am?
Yes.
I'm also going to indicate that you are to submit to random drug testing. You're not, as indicated, to possess any alcohol or illegal drugs or recreational marijuana. You're not to leave the state of Michigan without permission of the court. I will indicate also that you are not to possess, as I've indicated, any firearm, ammunition, or other dangerous weapon or anything fashioned to be a weapon. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. I'm not going to order no non-consensual contact. I'm going to indicate that I'll order no contact with Arnell Lincoln, except with a civil standby with the police. You're not to have or attempt to have any direct or indirect contact with that named individual in person or through others. You understand that, ma'am?
Yes.
You also cannot have contact by electronic communication, including but not limited to phone, email, texting, internet, or social media, or refer to that person listed, which is Arnell Lincoln, online in any form. You understand that?
Yes.
I think that no contact is going to have to be his address. I will order no contact, so.
Your Honor, would that be a no-go too?
I mean, no go to, I'm sorry.
Can you write down your phone number? That's what her name. Anywhere is fine.
Do you have that address or?
Yes, sir.
Go ahead.
23570 Clinton Street in Taylor, Michigan.
Said Clinton.
Correct.
That's my phone.
Ma'am, I'm going to prohibit you from going to that location. You understand that?
Okay.
That is not your home address. I don't need to give you that. You're not to violate any criminal law. You're to personally appear at all court hearings or other places as directed by the court. You understand all of that, ma'am?
Yes.
I need her to sign off on bond conditions.
Sign right there. It is June 2nd. I can get you a copy of this as well.
Okay. Thank you.
Thank you.
Thank you.
Does call the case versus Mark Juan. Is it Gracie?
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Grace. Mr. Grace, please state your name for the record.
Mark Juan Q Gracie.
Grace. We are requesting an adjournment. We're doing a little bit of investigation. The 16th should be okay.
The day before trial? Yeah, but that other case, I haven't got one dime, zero. So when did I become the collections agent? No, I thought I was elected criminal district court judge. No.
That's y'all's issue, not mine, Mr.
So that's why I was.
We're talking about 460 days.
Judge, I have no objection to it being reset.
A year.
The state is ready if we proceed on the first offense, but I don't have any problems with giving Mr. Adams time to take care of that.
Here you go. Okay, so here we go. On this. Stephen Adams is going to be one, of course. Everybody understand? That's Mr. Burbank.
Some issues, Judge.
Yeah.
He wants to come out and address the issue.
Who does?
Mr. Adams.
To me?
Yes, Your Honor.
What am I going to do?
That's his issues?
Okay, he's set number one nonetheless.
Yes.
Stephanie Watkins, we're going to do that plea. It's John West.
Yes, sir.
On
He's number one over there, Judge.
Gabriel Jones and Ronald LeBeau. That was Kingston.
That was dismissed.
Michael Mitchell. And I've got a Nestor Roque with Marvin Lewis. I don't know what that's here for.
We may have pulled the wrong file, Judge.
Marvin's not here this week.
Okay.
Yeah, I think we pulled the wrong file.
Back to the case you especially said, Stephen Adams. What is this?
If we can have him sworn in, Judge.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer.
If I may, please, the court.
Go ahead.
Mr. Adams,
And it's Mr. Burbank is here representing you and the state's attorney. Go ahead, Mr.
Mr.
Burbank.
Adams, we have now been picked number one for trial. You understand that?
Yes, sir. I'm not ready for
Hold on, let me go through it and then you can. And you understand that you're currently under indictment for aggravated kidnapping and aggravated robbery, correct?
Yes,
and what I want to get on the record is the plea offer that you've rejected, okay? After much negotiation and going back and forth with you and the state has agreed to settle this case for a lesser included aggravated assault. You understand that? That he has?
I'm understanding this, sir.
And that they would dismiss the aggravating kidnapping, aggravated robbery. You understand that? Good. And that also that we would go unagreed to the judge with a cap of 15 years, which means that the judge would have the full range of punishment. Could be probation, could be 2 years up to 15 years. You understand that?
Yes, sir.
You understand that by rejecting this, you are looking at first-degree felonies? You understand that, right? Okay. And that after much thought and going back and forth, do you want to accept or reject that offer?
Not accepting it.
Okay. All right. Is your decision based as freely and voluntarily done?
Yes, sir.
And that no one's made any threats or promises against you, correct?
Yes, sir.
Okay. I have nothing further, Judge.
All right. Anything else?
I'm not ready for trial. I wanted to move forward as pro se. I wanted motions that I filed ruled on before trial, so I have a fair trial. And there's other motions that I wanted to file prior to trial. I never got to file. And I'm just not ready yet. So I got the motions right here for continuance and to move forward as pro se. And that's what I would like to do. I'm aware of the risk and everything.
What do you need a delay for?
So I can get some motions filed.
So what? What did the motion say that need a delay?
The motion say that I wanted to file?
Yeah. What are you asking for?
One of them, I wanted to file for recusal because there's bias in this courtroom. I'm not gonna have a fair trial at all. And the other one, I wanted to challenge the grand jury proceedings to make sure due process was followed.
Well, what's your complaint about the grand jury?
I don't think due process was followed. Like this.
For what reason?
That's a common thing in this county. It's very common. I read case law and everything where people have had their grand jury stuff pushed through and there was steps skipped and everything and case has been dismissed. And I would just
What
rather.
case are you citing?
There was one with Hartman where the guy was falsely accused of interrupting their courtroom or whatever. And because the guy named Alfred wasn't sworn into the district attorney's office or whatever, they dismissed his case. Like I got them all wrote down and everything. There's probably a few of them.
I'm familiar with it, but you're wrong on the facts. But what else do you have? What else?
I got the motion right here. I'm not happy with how my attorney's been doing stuff for me. Like,
Okay. You want to represent yourself? Okay, you can do that.
I want my pre-trial motion.
Do you understand all the consequences that are part of representing yourself? You have to know the rules of evidence. You have to know the procedure. You're going to be, and if you keep interrupting me, I'll hold you in contempt. Only one of us can speak at a time. This lady next to me has to put everything down. And if two people are speaking over each other, she can't do it.
Yes, sir.
I'm not going to be the one to trouble you on. All right. Seems like you want to control proceedings, and that's not the way it works. But you can represent yourself. This case is over 2 years old. How long have you been thinking about representing yourself?
Since John West wasn't doing anything for me at all.
How long is, I'm asking time.
I wanted to do it April 21st, but y'all convinced me to take an attorney. And I didn't get to do anything I wanted to.
No, you can do anything you want, sir. The fact that Tom Burbank, an experienced attorney, is helping you is to help you, not to dictate anything. It's your life. You get to make the call. You want to represent yourself, then you're entitled to do that. But in 20 years here, a defendant has never been successful, but that's your choice.
Then why did he tell me that I couldn't have any of my motions that I filed before he was appointed to be ruled on?
Well, if I could read his mind, I guess I would know, but how would I know what's on his mind on those? I don't know why he would say that. That's why you were supposed to be work. Why didn't you ask him that?
I did.
But what did he say? I'm not going to answer you?
He said I'm going to get ruled on.
Sir?
At all. Like, I got certain motions that I filed that I wanted ruled on.
Okay, what?
The motion for dismiss, I wanted ruled on.
It's denied. I've read that. It is denied. It doesn't have a legal basis. What's next?
And then I'm going to ask why I filed a habeas corpus and was never brought to court for the bond reduction. My bond was changed from 400,000 to no bond without me being present in the courtroom without my knowledge.
All right, that it won't hold up this trial. A fact of a bond. We're moving forward. You're set for trial today. What's next?
That ruled on my speedy trial.
It's denied. What's next?
My speedy trial motion is.
It's denied. You're getting a speedy trial. Here we are.
I filed it over a year ago.
It's being granted today. We're moving forward.
All right.
We're going to try the case today. This is what you want. This is your time, and make it wisely.
Fair trial in this courtroom, but we need to go forward, and that's fine.
Thank you. Okay. Yeah, well, anything else?
No, Your Honor, I will stay on if he needs any assistance.
Neil, stand by. You want to represent yourself. All right. You understand and appreciate how these procedures work, the rules of evidence you're going to be held to. And if you don't have adequate legal counsel, like Mr. Burbank is more than adequate, a very competent man, then you understand you're a layman, and you're going to be starting with about a 3-touchdown lead for the defense, for the prosecution, because you don't know these rules. And it's just like in a ball game, they have to be followed, or else you are going to be are not going to be on the same level. And that's what competent lawyers do, is make sure that your rights and the laws are followed, the rights are given to you and allowed, and that both sides receive a fair trial. When you're not capable of knowing that, I've been doing this for 40 some odd years in prosecuting, in defense work, judge, and defendants never come out ahead in that regard. Do you understand? Knowing all, just as long as you know that, you're grown up. You can make your choice, but it's a foolish choice to make if you don't want him to handle the case. What I'm going to do, right? You don't want it.
I just want
All
to
right.
question my rights and reserves. So.
You've made your decision voluntarily, knowingly, intelligently, and that's what you insist on.
Your Honor, I have all my trial notebooks. I'll bring that so that he may have. I'll have the law books that I use, so that he has everything provided to him. And we'll be here if he has any questions.
All right, he'll be standby. He won't be representing you. He'll be standby. If you need to get some advice from him, he'll be close by. You ask for that and I will decide how much time but we're not going to delay the case. We're not going to delay on you going and talking to him over and over and over again. You want to represent yourself. That's the way to do it, or else it would take months to try cases. If you went and asked him every question on every question asked and every issue, but he'll be standing by. The court will allow you, if it's proper. And that is the way it is done.
Dude, can I say something, please?
Yes.
So I had, I think 3 weeks he's been appointed to me. I mean, that's not a whole lot of time to even really officially get stuff ready at all. Like for over 2 years, I had no representation whatsoever, nobody helping me, no nothing. So I mean, that's how I'm saying this is not fair. And
why is that, do you think?
3 weeks.
No. How long have you been in custody?
I've been in custody for 27 months now.
27 months.
Yeah.
$219.13. Okay. Do you understand what has happened today, sir?
Yes, sir.
All right. Good luck to you. Thank you.
Thank you.
Thank you, Judge.
Yes, ma'am. Stephanie Watkins, you ready? Who's that?
Ms. Peralta, up to another court, she'll be back.
Who else do we have on, please? Anybody else?
Dana Gay.
Dana Gay. Come forward. That's yours, John? That's right.
Sure.
I already got one. Here you got one. Great.
Dana Gay.
This is a probation plea with pleas of true to the enhancements, making it a habitual offender probation.
Come forward. You're Dana Gay?
Yes, sir.
240510.
Raise your right hand. Start walking on it. Yourself, you got this. Okay. Need you to come up here. Hold up your right hand.
3 in Jefferson County, Texas, you committed the 2nd-degree felony of fraudulent use of identifying information. Do you understand what you're charged with here?
Yes, sir.
Paragraph 2 goes on to allege that prior to that, in 1992, you were convicted in the 252nd District Court of Jefferson County, Texas, for burglary of a habitation, a 1st-degree felony. After that was final, it is alleged in this indictment that, according to paragraph 3, you committed the offense of aggravated assault, family violence, a 2nd-degree felony, and were convicted of that in 2018 in this criminal district court of Jefferson County, Texas, in 18-29448. Paragraphs 1, 2, and 3 constitute habitual felony. Do you understand? So you're looking at no less than 25 years up to 99 years imprisonment or life imprisonment. Do you understand the punishment range?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And there is no fine, there's no restitution or anything like that.
Correct, Judge.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to paragraphs 1, 2, and 3? Guilty or not guilty? Are you pleading guilty voluntarily? And because you are indeed guilty in these cases? In this case, alleging these three offenses, the one you're accused of now and these two prior convictions. And in paragraphs 2 and 3, those prior convictions that we read to you, are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily because those allegations are all true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes,
Understand it, discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read here. You've read them. You were guilty of the crimes charged in any lesser included offense. You were giving up your rights to a jury trial, the rights to appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true. So help you God. Is that true? State's Exhibit 1, part of the record. For all purposes, pre-sentence report is waived.
Please, Your Honor.
If nothing further, I'm going to find, ma'am, that you are pleading guilty and true to paragraphs 1, 2, and 3 respectively of the allegations in this indictment voluntarily, knowingly, or intelligently. This constitutes a state jail, a second-degree felony, though enhanced to habitual felon status. You are facing no less than 25 up to life imprisonment, 25 years up to life imprisonment. In this case, there is sufficient evidence supporting the guilty plea and pleas of proof from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Be careful.
Yes, sir.
If your probation is revoked, you can then be found guilty and sentenced up to life imprisonment. Do you understand?
Yes, sir.
All right. Please see the probation officer. You're going to do well?
Yes.
Yes, sir. All right. But it's not.
All right. Just don't talk about it. Do it.
I understand.
Thank you. Any other pleas off the trial docket?
It's.
Here, thanks.
Yes, sir.
Okay, Christopher Watson, please. What are we gonna do on Mr. Watson here?
He had signed up last time we were here, but,
What was the date?
we come forward on Watson last 3/31/25.
Never come today on Watson.
Did you have something today?
Yeah.
Yeah, I had something today, which I think it was something that we had signed previously. So I said,
That was for the 18-month state jail. That's what we signed up last time when we were here.
I need him to swear in front of me if he's gonna play.
Are you gonna be pleading guilty today, sir? And this is 100, no, it's not 18 months.
Yeah.
180 days.
it shows 180 days, I think.
That's just 6 months.
What is?
Whatever it was they signed up for last time is what I
How
signed
much
today.
time does he have credit?
Yeah.
He's gotta have that kind of credit.
He got
He's
more-
ready to go.
He can get out of jail today.
He won't get out today, thank you, but get out in a few business days.
How much time does he have credit for? Do you know?
2 years.
2 years.
2 years.
He got,
He's getting closer.
last time we checked, I think it was
He was-
approximately 85 days, something like that. But he has more than enough time on 180 days to get done.
Okay.
Yeah, 586 days. Is that right, sir?
I don't know. I know.
But I mean, that sounds about right.
It's a long time.
It's a long time. I mean,
Hey, I'm ready.
are you, okay, this says you're gonna be pleading guilty, sentenced to 180 days, which means you'd be getting out. Is that what you're gonna do? Is that your plan?
No, you told me, you said that I had to be guilty.
Well, you're gonna be, you have to be found guilty. You don't have to plead guilty. You can plead no contest if you want.
I already pled no contest.
No, that's not the way I do things here. I've done this for 19 years. If you plead no contest,
Well,
that's
look,
fine,
if I-
but you have to, hold on. Sometimes people plead no.
Will you release? Will you let me out of jail?
You get credit. I can't do that. I
What?
can't do that, but you're credited. There's no reason for you to be staying in jail in
Yeah, can I
another
go?
moment.
Can I go? Because you offered me time served last time I
So
was
once
here.
again, sir, I can't do that. The people make the deal and then I approve it. Then I send it you, then it goes through the processing. And if you've completed time, I've tried 600 jury trials. I only tried one at a time. You don't have to plead guilty. You can plead no contest.
No, you told me that I was guilty and that I had to
You
be.
have to be found guilty and no contest has to be supported by independent proof. And then I make a finding of guilt. Yeah.
Well, what do you suppose now? What are you changing to?
Anything else you want to say? I'm not changing anything, sir. Do you want to plead or not today?
This is communicating. We're communicating.
All right, it's set for trial.
Today.
It's set for trial.
And,
That's all.
when-
That's all.
When people come.
We're set for
you let me
trial.
in?
It's set for trial. If you're not going to plead guilty, it's not a debate and it's not a time to grandstand, sir.
This is your fault.
Golly.
I told you.
It's only about the 10th time this is falling apart.
It's a political thing or something. All right, who's next? This set for trial.
Yes.
Keith DeJean, come on up. 23-313. Weird.
He's got two cases.
I understand that. I still didn't understand that one. That's okay. Some people, I guess, love to be in the jail. But I don't understand. It's like whatever it takes for me to stay in jail, that's what I'll do, which is odd. All I can do is now set it for trial.
I don't understand.
Thank you.
Two files.
I got two files, two motions to revoke probation.
Yes.
Is it one deal?
Yes.
One.
It's
I'm working.
one deal.
What part, sir? Are you Keith Patrick DeJean or DeJean? We call 23 CR 313 and 314. There are two motions to revoke probation. You were here with your attorney, Mr. Dusler. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes, sir.
Raise your right hand, sir.
Every day in the USA, people find themselves in court.
Morning.
Morning.
Morning. Clock. Okay, so I'm just gonna do a quick rundown and see who shows up. So you're Wayne Simmons?
That's correct.
Okay, is there an Andrew Simmons here?
He's not. He's been notified.
Okay, so you spoke with Mr. Andrew Simmons?
He lives in my house.
Okay, well, I didn't know that, so do you know why he's not here?
Because of dysfunction.
Okay, is anyone here for Bayview of Traverse City? Mr. Gromer, are you here? Jose Espinoza, Lindsay Espinoza. Same case, Bayview of Traverse City, but different defendants, Ricardo Lore and all other occupants. Anybody here for that case? Pardon me, ma'am?
can you hear, can you hear us?
I can hear you. Can you not hear me? Can you hear
No,
me?
I can hear you. This is our first time doing this, so I didn't know if.
Oh,
you
yeah.
could- That's good.
Okay.
That's good.
Okay, and then Bayview again versus John Waters and Zoe Payson. Okay, and you're James Boutwell and you're Ms. Boutwell.
Yes.
Christy Boutwell.
Yes.
Okay, fantastic. Landon Thompson, are you here? How about Ashley Foster? Okay, we're gonna sit for a few minutes and see if anybody shows up. Okay, so Mr. Simmons and the Boutwells, I'm gonna play a video about your rights. Let me know on Zoom if you can't hear this, and if you can't, then I'll read them. This is about rights that you have.
Welcome to the 86th District Court. Please listen
Can you hear that?
Yes.
Okay.
carefully for information about your rights and resources that may be available to assist you. Please have paper and pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, You may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the county in which the complaint was filed, you have a right to ask the court to transfer the case to the court where the property is located. You have the right to a jury trial. If you want a jury trial, you must request one orally in court today, or you may file a written demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Northwest Michigan Community Action Agency at 844-900-0500. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. Who have served in our armed forces, assistance may also be available from the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit proof to the clerk within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program, or CRS. If the court determines your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, Judge Cooney will be in just a second. testing to see whether I can join this.
All rise, please.
Morning, please be seated. All right, we'll start with your case, Mr. Simmons. That is file 9271 of 2025. If you want to come on up to the table, sir.
You want me here, Your Honor?
Actually, that seat right there, where the plaintiff usually sits. And Let's see, so is Andrew Simmons present? No. Looking at my screen here. Okay, who do I have at the phone number ending in 8819?
It's Esmeralda Howell, Your Honor.
Can you repeat that one more time?
Esmeralda Howell, Howell.
She's on at 9:30, Your Honor.
Oh, the 9:30, okay. Okay, thank you, Ms. Howell.
You're welcome.
Okay, so So on my docket, it lists Andrew Simmons as the defendant, but when I look at the summons, it says Arthur Simmons. Well, that's what you filled out, was Arthur Simmons was the defendant. Is
I
that?
can't imagine, I mean,
That's inaccurate. It is, in fact, Andrew Simmons. Okay. Well, I don't know you or Andrew or any of the.
we've been in front of you, Your Honor. I'm a local psychologist. You've dealt with him as a juvenile. I don't expect you to understand or remember everybody you've seen.
Okay, I'm just trying to figure out who the parties are, so. Okay, and it appears there was personal service on him, and so have you resolved anything or?
No. Do you want me to give you a narrative about what's happening?
Sure, go ahead.
Andrew's a 23-year-old man who's profoundly immature, developmentally delayed, disabled according to Social Security. He's had a lot of behavior problems throughout his life. A year and a half ago, we were able to purchase a home on 8th Street with 3 apartments so he could live in one, allowed us to afford it. It became a drug house. We needed to shut that down, have him move back home with us because there was no other alternative. It's nearly intolerable to live with him. Comes and goes at all hours of the night. But the biggest issue is that about 14 months ago, as a result of not intravenous, but some drug use, he developed a condition called dermatillomania, which means picking at the skin. He has created in his body a hole in his back, which originally threatened to paralyze him. We've managed to get that somewhat healed. He has one on his leg now, which if you look at it, you can watch the tendon move within the wound. He's being treated at the wound clinic through Munson Medical Center, being seen at Traverse City Health Clinic. He has an appointment this week with Dr. Miller at the infectious disease specialty. Tomorrow morning, he is due to start hyperbaric oxygen chamber treatment 5 days a week for 4 to 6 weeks. He has an infection in his bone, which has been confirmed by 2 MRIs and an X-ray. If that isn't healed, it likely will at least cost him his leg. I have taken him everywhere in town. The emergency room at Munson Medical Center had been an insult.
I've been insulted by physicians there. I've petitioned, I'll make this as brief as I can. I've petitioned through probate court to have him involuntarily committed. He was held for 3 days, released on Monday by a psychiatrist in a paper shirt and booties in a snowstorm. It's that bad. We have no control over him, and we have no options left. We can either live the rest of our lives. I mean, I've had the police there. When he digs at his wounds, he usually goes to his bathroom where he either uses or whatever he's doing, but there's a compulsion to dig. His bathroom looks like a murder scene. There's blood sprayed everywhere. I went in to try and get him to stop. He slammed the door on me. I called the police. When they came, they said, the young lady said, if he doesn't want to leave, we're not going to make him. I spoke to the chief of police. He was compassionate, talked about the kinds of regulations they have for taking him in. There are no options for him. The chief said, if he's taken to the jail, they likely would think he can't be treated there. If he sent him months and months and said doesn't qualify for inpatient treatment. And so what we're left with is, if he doesn't succeed in this treatment, we can either live the rest of our lives with this nightmare in our house, or we can put him out and wait for him to die in the street. There are no options. And I understand that you probably don't have within your purview options that are going to remedy this circumstance. I'm beyond heartbroken and exasperated. I'm a psychologist with 50 years experience, and there's nothing I can do to help my son now.
Okay, so let me ask you some questions. You mentioned these apartments on 8th Street, but this is your own home that you're talking
In
about.
our home now, he lives. 8th Street was a unit that we bought.
Okay, so you're just trying to have him evicted from your own home?
From
is
our
that-
own home,
Okay.
where he lives.
All right, and so there's no rental agreement, there's no, I mean, he doesn't pay rent, I'm assuming, none of that.
We manage his social security disability. I talked to all the attorneys that have probate experience. They described to me that a conservancy or any kind of legal control for him gains us nothing in terms of controlling him. It would formally allow me to control his money. He doesn't protest about that. I provide him what he needs.
Yeah.
It covers, expenses within our
But
home.
you've essentially allowed him to live there, but not with any formal agreement of any sort, as far as paying rent or a
There's
lease
nothing written.
agreement or anything like that.
No.
Okay. So, and he's currently residing there, right?
Yes.
So, okay. So, this is a thing, there's a legal requirement that I allow him one more opportunity to appear. And because there was no second mailing in this case, and that's something I wouldn't expect you to know about, but I have to schedule this for another hearing in 2 weeks, giving him an opportunity to appear at that time. If he fails to appear, then I can grant the relief that you're requesting. If he does appear, we'll need to take up the matter and have a trial, okay? So that's pretty much where we're at. The next hearing date is when?
The 30th.
Okay, so June 30th. That must be because we've got a gap in the middle of the month. Are you sure?
Maybe I'm mistaken here. Hang on.
Yeah, I don't know why we wouldn't be
I
back in 2
probably
weeks.
was thinking something else. Give me a minute.
Did you describe June 30th, Your Honor?
We're checking to see, it should be 2 weeks out, not 4 weeks.
So here's a dilemma. He has to be at the wound clinic at 8 o'clock every morning, 5 days a week. If he succeeds, the issue is resolved. I'm desperate and not optimistic that that will occur. He has very little control over himself. If he uses, they won't continue to treat him because it's dangerous to go in a hyperbaric chamber if you have certain drugs in your system. I'm hopeful and praying that he will cooperate. We're doing everything we can. But the point is, if he's still in that treatment, I can't come to court then. I have to be there to get his treatment.
Okay, if you can just contact the court, our clerk Haley, who you've probably spoken to, and let her know what the circumstances are, we'll know why both of you are unable to appear, and we can reschedule at that point. And if you're able to dismiss the complaint also at any time if those circumstances occur, and so. Does that make sense?
June 16th is the next one.
Okay, so we'll be back on June 16th if things don't go the way you're hoping, I guess. And what time was that?
We'll do 8:45.
8:45.
If he's still in treatment, we won't be able to appear. Yeah, I understand that you have formalities that you're obligated to follow. He won't participate. He's sleeping right now. If I'd woken him up, he wouldn't participate and it'd be a fight.
Okay, so you're correct about that. There are certain requirements I have to follow, and whether they make sense in every case or not. So, okay, so we'll be back at 8:45 on the 16th. And like I say, if you could just be in contact with Haley, our landlord tenant clerk, if for some reason you're not able to be there, and we'll deal with that situation. Okay?
Can I communicate her via telephone?
Yeah.
Or does that need to be in writing?
Usually telephone works the best. So
I'll keep you posted.
okay, she's at the other end of the hallway also. If you wanted to talk to her this morning, she's.
One of the questions I have, Your Honor, when we get to that point was my understanding from her, I believe, that if the requirements were met, he had 10 days, and after that, he can be served, and then the police can remove him if necessary.
That's correct.
If that were to occur, I'm not trying to use the court to manipulate him in any way. I'm trying to save his life. What I tried to describe to the insulting ER doctor, Brandon Peters, I'm trying to save this young man's life. If, let's say that we get back here, the order is put in place that he has to leave. My understanding was he has 10 days after that to respond, then the police can put him out. He will return to our home like a raccoon. He is beyond attached to us.
At that point, it would be a trespass, and then actually, it's not the police that would remove him; it's a court officer. So we have a civil process server who works with the court and does those removals. Okay, and after that, if he's been removed and he's not able to come back, then it would become a criminal matter, a trespass. He could be arrested if he appeared at the home.
So with the civil process server simply serves him that he has to leave?
No, the process server actually effectuates the eviction, the removal.
Physically?
If necessary, so.
It likely would be.
Okay.
I'm devastated. I mean, I'm left to leave my son die in the street with no options if he doesn't cooperate now.
It sounds like a very difficult situation, and I'm sorry for everything you're going through. So.
Broken system.
In a lot of ways. Okay.
We'll stay in touch.
Okay, thank you, Dr. Simmons. All right, next we have file 9275 of 2025, James and Christy Boutwell, I'm sorry, versus Landon Thompson and Ashley Foster. And can you hear me okay, Mr. and Mrs. Boutwell?
Yes.
Okay, very good. And how about Landon Thompson and Ashley Foster? Are you there? Doesn't appear so. Have you had any discussions with them recently, Mr. and Mrs. Boutwell?
No.
Are they still residing at 10825 Cedar Hedge Trail?
Yes.
Okay. And how did they get served with this?
James delivered it to him, and he
Okay, so
signed the bottom.
all right, so there was personal service and well, it says posted, so it was posted on the door, is that right?
No, I actually went there and served him the 7-day quit notice on the 12th of May. And he signed the bottom of it. So we have a copy of that. And then I also texted her a copy of that signed quit notice. And then I left.
What about the service of the summons to appear today?
That's out of our hands. That would be Rick Robbins, I think it was.
Okay, so that's the service that I'm talking about, was served by posting on the door.
Oh, yeah, I don't know anything about that.
Yeah, because we got our info.
Yeah, that.
When did we get this?
In the mail.
When did we get it?
I can't remember the date.
It's dated May 19th.
Excuse me, if you're not muted and you're talking, we can hear you. So if you could please mute yourself until your hearing is called, I would appreciate that. Okay, so this is the thing, as I explained to Dr. Simmons a moment ago, I'm required to give them an opportunity to appear a second time. Since there was no second mailing in this case, that's a second mailing of the summons directly from the court. And that's something I don't have any control over. So what we're going to have to do is schedule this hearing out to June 16th. Is that going to be 8:45 as well? Okay, at 8:45. And if they fail to appear at that time, then if you're still requesting a possession judgment and everything else appears to be in order, then I could grant that relief at that time. Okay, otherwise, if they appear, I'll have to go through their rights with them, and we'll go from there or have a trial. Okay.
So they can totally for this one.
What, say that again, please?
So they can totally disregard this whole, I mean, I take this as a big deal, so they cannot show up and then they get rewarded an extra 2 weeks living there for free.
Well, you should talk to your legislature about that, because they're the ones that pass the law that requires me to adjourn this out. And So I don't have any control over that, but I do have to follow the law, ma'am.
So then would they be responsible for like payment then for this next month that they're living there?
Yes, they would be responsible if that's the case.
Okay, I guess that's all we can do.
Okay, so we'll see you back here on the 16th at 8:45, and we'll see if they show up.
Right.
You'll get a new notice of that in the mail as well.
Okay, it just shows their character. I would hope that, you know, it just shows their character. It doesn't surprise me they didn't show up actually. So,
okay.
All right. Well, thank you.
All right. Okay, thank you.
Thank you.
Yep.
Bye-bye.
Judge, all your Bay Hill cases for the morning have been taken off the docket.
The what cases?
Bay Hill.
Oh, is that why nobody's here for
Yeah,
Bay?
Mr. Gann canceled them. 'cause he had a short
Did you
notice.
say you have cases for gay on that can? I'm here for Attorney Gann is why I was asking.
That's what I was just told, that Mr. Gann called and canceled them. Do you know otherwise?
So the ones I know I have today are East Bay Flat, so.
All right, next we'll take up file 9278 of 2025, Brian Mack versus Esmeralda Howell. And good morning, Mr. Mack. Are you able to hear okay?
Yes, Your Honor.
Very good. And Ms. Howell, can you hear me okay?
Yes, I can, Your Honor.
Very good. Do you have video availability?
I can probably do a Zoom, but that's the only way that I could probably do it.
Okay, you're just on your phone. Is that what you're doing?
Yeah, I'm just on my phone right now. I do
Okay.
have access to Zoom if that's what you would prefer.
Well, we'll just go ahead the way you are right now. It's a little easier when I can see people, but
Okay.
but we'll see where you folks are at anyway. So this is a complaint for possession and a money judgment, and this is the first hearing on that. And it says here the total rent that was owed as of April 28th was $47.78. Mr. Mack, I want to hear from you first. Has anything been resolved there? Have you gotten paid or otherwise?
Well, Your Honor, she did pay $1,400 on 5/5 of 25. And as of now, obviously June rent is due, so that kind of negates most of that. She had I received a last minute text from her, from the defendant last night, and I guess what I want to do is ask, because I want to set a time limit, because I know that she's stating that she can get this money and that money and this money and that money, but I want to set a time limit on it because I know that she's going to go ask for assistance, and this has been a few months in the process, Your Honor. I've been trying to speak with her via text, via phone call, which her phone has been, I believe, out of order for a while until she texted me last night. So, but I would like to set a time limit on this if I could, Your Honor, so that way then I can ensure that either A, she is going to follow through, or B, we need to move in different directions.
Okay, so Ms. Howell, is that correct? You are hoping to pursue rental assistance?
Yes, I got my letter from Department of Health and Human Services already for the denial. I've already started the process for Father Fred and Salvation Army. And then I had to call St. Vincent de Paul, but they're only open on Wednesdays apparently. So I've got all the numbers of everyone that I've had to call and the appointments that I have set up.
Okay. All
So
right,
I do
so,
have a today and then tomorrow and Wednesday, and so just as I go along.
okay, so, did you hear all of the rights that were read earlier, Ms. Howell?
Yes, yes,
Did you understand those?
I did, yes, Your Honor.
And do you have any questions about them?
Nope, I don't have any questions. I got all the numbers of everything that I need to look into and get a hold of anyone I need to get a hold of.
Okay, so it sounds like you've gotten a good start on things anyhow. And now to address Mr. Mack's concern about timelines, this is the way these cases proceed. I'm required to give Ms. Howell a 2-week adjournment so that she can pursue her rights that were read earlier. And so that means we're going to schedule the next hearing for June 16th. And hopefully that rental assistance will come through, because it sounds like Mr. Mack just wants to get paid.
Yep, absolutely.
Okay, so sometimes it helps to have a definite date for when you've got to get that money, and that would be June 16th. Now, if that does come through and we've got a hearing scheduled and you've worked things out, then you don't necessarily have to appear on that date if we get something in writing from both of you that it's been resolved. But otherwise, we'll be here on June 16th at 9:30 a.m. And then the way this works is if the complaint is otherwise valid and there are no defenses, we could hold a trial if there are issues about whether the complaint is accurate or not, but it doesn't sound like, it sounds like a simple case of not paying. But anyhow, we'll hold the trial on the 16th. If I find in favor of Mr. Mack at that time, then the defendant would have 10 days to move out before an eviction would occur. Okay, you'd get what's called a possession judgment, Mr. Mack. That means you're entitled to possession, but by law, I have to give another 10 days for the defendant to move out. Okay, again,
Yes, Your
Ms.
Honor.
Howell, I'm hoping it doesn't come to that and you're able to get some assistance for this. So those are the timelines that are important. But as I stressed to the last person, make sure that you stay on top of this, because we will have a hearing on the 16th, and that's the time that you're going to need to let these agencies know that that's the hearing. Okay.
Absolutely.
All right, then. Is there anything else for you then, Ms. Howell, before I let you go?
No, Your Honor, I am all set. I got everything I need.
Okay, or for you, Mr. Mack?
No, Your Honor, I'm all set. Thank you.
Okay, thank you both, and feel free to sign out.
Thank you.
All right. Mr. Watts, do you have the client that's at the detention facility's camera location at this time?
No, Your Honor. I have Ms. Swan here in the office and Mr. Moore is on video. And I think I can take up either one, whichever the court would prefer.
I think this may be Mr. Pate's case. Chris?
We're talking about the one at the jail?
Yes, Mr. Nunez?
Yes, that's my case.
All right, then I'll call State of Kansas versus Eduardo Rafael Nunez, case number 2025 CR 205. with the defendant appearing from the jail Zoom location, Amber Norris for the state, and Chris Pate appearing separately from his client by Zoom. What announcement is made regarding preliminary hearing right in this case, Mr. Pate?
Your Honor, we'd request a preliminary hearing setting.
If you look at July 30, Mr. Pate, I am proposing 10 o'clock a.m.
I am scheduled to be out that week, Your Honor. Is there anything the following week?
Does Mr. Nunez have other holds on him other than this?
He's got a parole hold
Yeah.
that I'm aware of.
All right. Tuesday, August 5. Mr. Pate,
I am available at any time.
10 o'clock a.m. So Nunez preliminary hearing is set to begin 10 o'clock a.m. on Tuesday, August the 5th. I'll look this case over for a moment, counsel. I think we can probably get this done in an hour. All right, I'm currently contemplating that the Nunez case would be handled by Zoom, counsel. At 10 o'clock a.m. Tuesday, August the 5th. With that setting now made, does the state have anything else to address the court about?
No, Your Honor, thank you.
Do you, Mr. Pate?
Your Honor, would just ask the court review bond in this matter. My understanding, Mr. Nunez is in custody right now on a $10,000 cash or surety bond. Would ask the court consider a reduction to 2,500 cash or surety or another reasonable amount. If Mr. Nunez were to be released, he reports to me he would live with his brother over in Wichita. He does have a job working as an independent contractor and remodeling. I believe he's on some type of supervision in Sedgwick County right now. I don't have all the details, but he would be on that supervision. I think at least initially, even if he could make bond, he'd still have to deal with the parole hold. But if that was resolved to his favor and he was released on that, he'd also be on parole supervision. So I think if the court reduced his bond, there would be a number of agencies supervising him to ensure that he was getting to where he needed to go and complying with the law.
What's the state's position regarding bond reduction here, Ms. Norris?
Your Honor, state would request that the motion for reduction in bond to be denied. Your Honor, defendant has significant criminal history, and as previously noted, is on supervision for at least a minimum for parole, if not something else in Sedgwick County. He has previous failure to appear issues. This incident happened in Rose Hill, and involves people that live around where he was living in Rose Hill. Certainly safety concerns.
Right.
There were several witnesses to this. Your Honor, a lot of his history is from either Barton or Reno County. So Your Honor, state does not think that anything less than a 10,000 cash or surety would be appropriate. And also it sounds like he has that parole hold still. So we would be requesting that the court deny the request at this point in time.
Thank you, Ms. Norris. It does appear that due to this defendant's previous criminal history, the fact that he's being charged with a presumptive prison offense, and there appears, at least on its face, to be a relatively strong case in this case against this defendant on a crime of violence, the court will leave bond where it is, a $10,000 cash or professional surety required. with, he's not to have any weapons, no contact with alleged victims, and cannot be in the city of Rose Hill, Kansas for any reason. If he does make that bond, he needs to either appear in his attorney's office or the Butler County Judicial Center for all future court proceedings. So Mr. Pate's bond reduction request again is denied. If there's nothing further then, the Eduardo Rafael Nunez matter will currently be in recess. We'll move on to another case. Mr. Pate, I think I can release you from the meeting at this time.
Your Honor, I think I have one more on the docket for Austin Stuber.
All right. Is he on this meeting?
Yes, we got him. Yes.
Okay. I'll call State of Kansas versus Austin Van Stuber, case number 2025 CR 201. Mr. Stuber appears at the court security Zoom location at the judicial.
Every day in the USA, people find themselves in court.
Issued because the defendant failed to appear for a random alcohol test as ordered on or about April 16th and April 26th of this year. Mr. Thompson, that was a term or condition of your bond. That would be based upon the fact that the amended information involved controlled substances, so therefore the courts would have been concerned about substance use. You have the right to challenge those allegations, to say that no, you didn't, or yes, you did violate your bond. At the hearing, the prosecutor would present some evidence. It's not a full trial. He can present it through a witness. He can present it through a police report, or a report from the community corrections office. Or you can make an admission at the hearing. You can call witnesses if you choose, present evidence or testimony if you chose, or remain silent and have the right to not have silence used against you. The key here issue is if the court were to find you in violation of your bond, the court could continue it and just admonish you and wave his magic finger, or two, revoke it, remand you to custody of the jail, or three, modify it. I don't know how, but we could modify it. I kind of have an idea what I would do, but modifications such as enhanced outpatient treatment programming or something like that. Mr. Champion, how would your client wish to respond?
Your Honor, my client would admit that he missed the testing. He's not disputing.
All right, thank you. Mr. Thompson, could you please raise your right hand for me, sir? Do you swear or affirm the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Absolutely, yes, sir.
Thank you, sir. You may take a seat. Mr. Thompson, is it true that you failed to appear for testing on a couple of days?
To my knowledge, it was only one. If it was two, I humbly apologize. I do have extenuating circumstances regarding the May 3rd.
All right.
I have two half German Shepherd girl dogs. One was at heat.
Okay.
I let them out and one of them was off. And I've got a copy of the text messages. It took 3 days. I finally found her.
Okay.
And I also would like to let the court know that 53 years ago today, I took my first breath.
And happy birthday.
Friday and Saturday, I had back-to-back urine tests, and to be honest, Friday, I actually felt the tears leaving. The first time in completely clean.
Good, good.
Sliding on me.
So here's what the court's going to
plead no contesto that I'm getting back, healing relationships. I talked that day, I had a,
Here's what the court's gonna do, and I appreciate that. And Mr. Thompson, what I'm seeing from you today is what I expect, having seen you in another file. The court finds a defendant in violation of this bond. The court's gonna continue the bond. However, the court's gonna add to the bond enhanced outpatient treatment program through community corrections, which is actually operated by Catholic Human Services. The concern here that I obviously have is making sure that you have some kind of support system. All right, I take what the people do at Catholic Human Services very seriously, and I appreciate the services they're there to provide. So when you leave court, you're going to want to contact Community Corrections, which, as you know, is over in Cadillac in the Washford County Courthouse, and they'll set you up with an enhanced outpatient treatment program. Now, that phrase sounds really, really intense. I don't know how intense it really is, but it's enhanced outpatient. They'll set you up with some classes. It's not like it's 24 hours a day or even 8 hours a day or even every day, but they'll put you into a program. And again, the objective here isn't to punish you. It's just to help you in case you've got some substance use issues. Okay.
Your Honor, may I also ask, during sentencing, we had talked about cannabis use. And when I received the order.
What issues?
Cannabis.
Oh, yeah.
On sentencing, that I was able to use it. When I got the order, it says I cannot.
It should say you cannot use it recreationally. If you have a medical card, nothing I can do can stop that prescription.
I understand that. I believe that was one of the things that was checked off, that I was allowed to use it. Now, when I met with the probation officer, did do an in-house visit, and I refrained in honor to.
Okay, hold on. Mr. Thompson, I'm not feeling well today. Take care of this with your probation officer. And if she needs to come and ask me to modify some paperwork, we'll do so.
Okay.
All right, thank you.
All right, thank you.
On this file today, we're adjourned. We'll take a recess. Thank you.
Mr. Cooper are excused at this time.
Thank you, Your Honor.
Thank you, gentlemen. Any availability of Attorney Patterson? Mr. Patterson, could we take up your jail case?
Yes, Your Honor.
We are on the record in Stewart, case number 2020 TR 639, State of Kansas versus Shakila D. Stewart. Please announce appearances.
Jeremy Gear on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Shakila Stewart, who does appear from the Butler County Jail. And I did want to inquire of Mr. Regier if he's received my summary and if the request on Shakila Stewart is acceptable.
Your Honor, if I may request 1 minute of the court's time.
Yes, but I would note it looks like a second chance bail bondsman has a representative here today as well. For the record, sir, your name?
Philip Webb.
Philip Webb. All right, now you may have your moment.
Thank you, Your Honor.
You're welcome.
Your Honor, the state is prepared to proceed in this matter at this time. I would also tell the court, for the court's edification, it would appear that a motion for judgment on bond was filed by the state in February of 2025 with an attached notice of hearing of today's date and time. More recently, it is the state's understanding that an order withdrawing the same was filed with the court within the last week.
And that was concerning the $8,000 bond. For the record, correct, Mr. Regier?
That does appear to be an accurate summation of paragraph 2 of the motion, Your Honor.
I bring that up because I believe that she has had a previous judgment on bond. That would have been back March 28th to 23. That judgment was in the amount of $2,000, and it was concerning Tania of assurance bail bonds. That was taken against 2,000. That bond remains, and I'm curious how that works. I'll address the clerk first. It shows the $2,000 balance against her, but should we not have collected against assurance by now?
One moment, Your Honor. Let me do some checking.
Thank you.
I know that you see that it says her name, but it's the bonding agency is the tab that it's under.
But we haven't collected from them.
It does not appear so.
Who does our bond collections for Butler County? Is it the county counselor or the county attorney?
I cannot speak to that, Your Honor. I'm not sure.
Okay, well, I would ask that you talk to the clerk and find out who's going to get that money, because that was 2023, 2 years, and we haven't collected. So I don't know if you know the answer to that, Mr. Regier, who's responsible in our county for collecting judgments.
Unfortunately, Your Honor, I am not in a position as to that. What I would tell the court is that page 2 of the journal entry from judgment on bond does appear to refer to both the defendant and the bonding agent. So this would appear to be a case, if the court is prepared to accept a speculation on my part, where joint and several liability would potentially apply.
Well, that's the way I believe it to be, but Assurance has been making a lot of bonds in this county in the last 2 years, to the best of my belief, and we need to collect that. I wonder if we have others sitting around there that nobody's collecting on. So, Jen, would you make a note to check on that?
Certainly.
I appreciate it. Thank you. All right, now back to the case. Apparently, you're off the hook as far as the bond, the motion, Mr. Webb, but let's address the case.
Thank you, Your Honor.
Thank you. Do we have, gentlemen, any plea agreement? I'm sorry, did you tell me we did or did not?
We do, Your Honor. I would announce at this time, Ms. Stewart will be entering a plea of guilty to count 1, driving while suspended, Class B, non-person misdemeanor. States agreed to dismiss count 2.
Okay. Any agreement for plea or sentencing?
Judge, just a standard agreement of 120-day controlling sentence, a $100 fine, plus court costs for the court to determine court-appointed attorney fees, and then a 6-month non-reporting probation.
Thank you. That's your agreement, Mr. Regier?
Your Honor, in this particular case, the state is prepared to proceed in the fashion iterated by counsel for the defense.
Very well. Then, Ms. Stewart, do you agree with everything we've been talking about so far?
Yes, ma'am.
How do you plead then to count 1, driving while suspended? Wait, let me see. Yes, count 1, driving while suspended in Butler County, Kansas on March 24th of 2020.
Guilty.
Are you pleading guilty to take advantage of the plea agreement? and because you believe you are in fact guilty?
Yes, ma'am.
Do you understand that with this plea, you're giving up your right to trial? You'll be found guilty and unable to appeal that conviction.
Yes, ma'am.
Where have you been the last 5 years?
Last 5 in Topeka.
DOC?
I had pushed it. I wasn't really taking it serious until like a couple years ago, and then I was trying to get my license back. That's why the last one that you could, like the last couple of court dates you see, we continued it because I was trying to get them back. And then the last court date, my daughter had got admitted. She has a bunch of health problems. She had got admitted to Children's Mercy. So that's why I had missed the last court date. So now we're here.
All right. When you say you were in Topeka, were you just a citizen there or were you in DOC custody?
No, I was a citizen. I was.
Okay. All right. And I don't know if you remember where you were doing this driving while you're telling me your license was suspended on that date of March 24th, 2020?
You said, did I know?
What was your license suspended?
Yes, I wasn't aware until I had got pulled over and he told me, because I had paid a bunch of money to get my license back. I had just got my license back, but Topeka failed to tell me that I was supposed to hold a SR22. So when I got pulled over, that's when I found out that I was driving on a suspended. I was coming back from Wichita, picking my sister up on the highway.
Were you on the Kansas Turnpike, I-35?
I believe so.
The turnpike from Wichita to Topeka?
Yes, yes, ma'am.
All right. And the officer says mile marker 75.6. You wouldn't argue with that?
No, because it was a construction zone.
All right. Well, that would be inside of Butler County. And I will find your plea as freely and knowingly entered with a factual basis. I find you guilty of. You have that filed as count 1, Mr. The citation had driving while suspended as count 2, I believe. But you have it as count 1. Yes, this document does have count 1. So I will find you guilty of count 1, driving while suspended on March 24th of 2020, and I will dismiss count 2, speeding. I will find you guilty with a sentence of 120 days in jail, but you will be given 6 months non-reporting probation. Your fine will be $100. Court costs $108. Now, you told me that you weren't in custody. Were you working or what were you doing these last 5 years as far as financial?
Yeah, I was working. I'm part of the time I was working, but my husband does all the working. I'm my daughter's primary, caregiver. She has special needs, but she has a bunch of medical problems too. So I mostly take care of her and my other 2 kids.
What kind of work do you do when you work?
Manufacturing.
Are you working at the moment?
No, I lost it due to coming here.
All right, well, I'm going to have you pay $250 in court costs.
I can pay that today before I leave, but if I get out today.
All right, well, your total will be $250 for the attorney, $100 for fines, $108 court costs. So can you pay the total $458 today?
Yes, ma'am.
All right, I will order that be paid by 5 o'clock today with the clerk of the district court downstairs. Well, no, you're not downstairs, but you know where the courthouse is, and if you don't, the jailer can tell you. It's just down the road from you. All right, anything else we need to address, Mr. Regier?
Not on this matter, Judge.
Mr. Patterson?
Nothing further, Judge.
All right. Butler County Sheriff's Deputy, can you tell her where the courthouse is so she can go pay that on her way out?
Yes, ma'am.
Thank you, sir. Appreciate it. All right, we'll be in recess on Stewart. Ms. Stewart is excused, remanded to the sheriff. And Deputy, do you have anyone else in custody today?
Thank you.
For us? You're welcome.
No, we don't.
All right, then. Thank you, sir. You're excused as well.
Thank you, Your Honor.
All right, Mr. Wagle, let's take up your case next.
Morning.
Good morning. We're on the record in 2025, TR 138, State of Kansas versus George Galagos. Please announce appearances.
Jared Revere on behalf of the state.
George Jorge Gallegos appears.
I'm sorry, what did you say this lady's name was?
Mandy Bell, Bell.
Oh, okay. We are on, well, give me just a moment. we are on the record in Bell 2024 TR 1857, State of Kansas versus Lindsay Danae Baker. No, you said Bell. I'm sorry, strike that. We're on the record in 2024 TR 3525, State of Kansas versus Mandy Michelle Bell. Jared Regier for the state, the defendant in person and pro se. Ms. Bell, you are here on one Class A misdemeanor violation of ignition interlock requirements. You do not have an attorney. You said you could hire an attorney, so where's your attorney?
I want to get a court-appointed attorney here today, while I'm in El Dorado, if that's okay.
Well, I tend to really emphasize that if you're going to hire your attorney and you decide you need a court appointed, don't wait till court, because now we have exhausted at least another 60 days without doing a thing to lead us closer to resolution.
And we'll do that today.
Have you turned in an application for court appointed attorney?
I've never done that before, and I will do that today.
All right.
Yes.
I'm going to recess your case. Well, strike that. Are you employed?
Yes, I am.
Where do you work?
Plenty Bloom.
What does that do? What kind of company is it?
It's hospitality. It's brand new opening with so the big building downtown Wichita with all the lawyers and attorneys, and it's at 100 North Market.
Very well. And how much do you make per month with that?
I'm not exactly sure yet. We're working on that. I'm moving higher up. So.
Well, how long have you been with the company?
I have been there for 3 weeks now. We're about to have our grand opening.
So you've been working for free?
No, right now I am making $20 an hour.
Working how many hours?
This week will be 45.
Are you married or single?
Single.
So you're going to be making about $900 a week or $3,600 a month. Does that sound right?
About right. Without taxes.
And you're single?
I am.
Do you have children?
I do not.
Well, I don't see you likely qualifying for counsel, but go ahead and fill out the application.
Okay.
Jen, when's the next available court date on a Monday for her in case she does qualify or does hire?
That would be July 28th.
I'm going to order that you reappear July 28th at 9 a.m. Why did you tell the court you were going to hire an attorney and then you didn't do that?
I apologize. I ran out of time, but I will do it today.
All right. You fill out your application before you leave today.
I will.
And then I don't think you're going to qualify. So I'll let you know as soon as possible. And then you need to hire your attorney and don't wait. Put it off. But if you're making that kind of money, and you're single, I don't see you qualifying. But anyway, you do have to be back here. I'm going to continue the bond. Did you go out and get your picture and prints taken like I told you to?
I'm sorry?
Did you go out and get your picture and prints taken like I told you to?
The picture and prints? No, I have not yet. Where shall I get that done at?
Your Honor, may I interject for a moment?
Yes.
Your Honor, it would appear that at the last hearing, the court did make certain orders concerning booking and bond. More recently, it would, later on during the same docket, it would appear based off my notes that the court did find the defendant in contempt after it was reported that the defendant failed to report to the breakout room as ordered by the court in this matter. So I'm not sure what the court wants to do as far as that is concerned.
I'm gonna order that she be taken into custody right now. Have her fill out that application and then have them drive her to the jail. Take care.
Is there anything else I can do? I need to go
given
back
it-
to work.
Nope.
I will do anything.
Oh, I've told you to get your picture and prints done and you didn't do it. You told me you were gonna hire an attorney, so I gave you time to do it. You didn't do it. I'm sorry.
Your Honor, the state is prepared to proceed at this time in this case.
Very well, we are on the record in 2025 TR 223, State of Kansas versus Trevor Nathaniel Talbert with Jared Regier for the state and Darren Patterson for the defendant, who also appears in person. Mr. Patterson, how do you wish to proceed?
Your Honor, would announce at this time that Mr. Talbert will be entering plea of guilty to count 1, which is fleeing and attempting to elude an officer. State's agreed to dismiss count 2.
That's your agreement, Mr. Regier?
That is the state's understanding, Your Honor.
All right. Mr. Talbert, is that your agreement?
Yes, ma'am.
Anyone forcing you to make this a plea today by any threats or promises other than the plea agreement?
No.
You understand if I accept your plea, you will have given up your right to a trial, been found guilty?
Yes, ma'am.
You won't be able to appeal that conviction. Do you understand that?
Correct.
All right. Tell me, you said you're pleading guilty. You're admitting the charge?
I'm agreeing to the probation, ma'am.
Well, you understand I don't have to accept the recommendations for probation. I usually do, but you understand that if that's the reason you're pleading, just understand the court doesn't have to accept the recommendations.
I totally understand.
All right. But are you pleading guilty or no contest, as in you don't admit the charge, but you don't deny it?
I'm pleading guilty.
Okay, so you're taking responsibility and admitting that you were attempting to flee, that you were fleeing or attempting to elude a police officer?
Yes, ma'am.
And did this happen on Southeast? Oh, let's see. Was that out on the Kansas Turnpike?
Yes,
I-35 in Butler County?
correct.
Looks like you were mile post 80 southbound.
That's correct.
Okay. And it was October 12th, 2024, about 3:41 in the morning.
That is correct.
Okay, and tell me, sir, what you did that would constitute fleeing or attempting to elude an officer. In your own words, instead of the
My
legal.
own words, I'll be honest with you, I was just scared at the time, Your Honor.
Did the officer have his license something? And he was in a marked vehicle? That was highway patrol?
Correct.
Okay, but you got scared and didn't pull over for him?
Correct.
Did you at some point decide to pull over?
Yes, fine. I finally pulled over.
How long did it take you to pull over, or how many miles, or how much time?
Say roughly 15 miles.
All right, well, I will accept your plea as knowingly and voluntarily made with a factual basis and find you guilty of count 1 and dismiss for your plea agreement counts 2 and 3.
And Your Honor, forgive me, there does appear to be an information on file with the court as of January 21st, 2025. It appears to refer to 2 counts.
Yes. Okay, so I will dismiss count 2. The county attorney elected not to file 3. Okay, so you are found guilty. And is there a recommendation for sentence, counsel?
Yes, Your Honor. Count 1 of the information does appear to charge a violation of case 8-1568, fleeing or attempting to elude an officer as a Class B non-person misdemeanor. State is recommending pursuant to plea negotiations, a $100 fine, court cost that the court make a determination on the issue of attorney's fees, and 120 days underlying sentence subject to a 6-month non-reporting probationary period. This is a case which would appear to be subject to certain administrative penalties that are outside the jurisdiction of this court, if the court will pardon me for saying so, pursuant to KSA 8254, and that is at least partially the basis for the state's recommendation.
Mr. Patterson, anything further?
Judge, I would tell the court, we're asking the court to adopt the recommendations partially. This is because of his current driving record, which is basically he's valid. He has 1 speeding ticket on it, no other violations on the record that I can see. This is a case where he is subject, though, because of the charge to being suspended, which he is aware of. I've discussed that with him. There, a lot of times the court can issue a restricted license instead of being suspended under that statute, but that is not available to him because he was in a commercial vehicle at this time when it happened, so that he will just face a mandatory suspension, which I think has also wreaked havoc with his employment. He no longer has that type of employment. But in this case, Judge, we're asking the court to adopt the recommendations.
So Talbert, first of all, I'm impressed by the level of responsibility you've taken on this charge. You admitted it as opposed to no contest, and you were specific in telling me what you did. And I see a lot of people kind of dance around that these days, trying, I think, not to take responsibility. And I'm sure they have their reasons, but you certainly did take responsibility, and that impresses the court. It's a shame that your record isn't one where it would tell me you should be scared, because you do have a pretty clean record from what I can just see pulling up the Kansas court records. And you were looking at maybe some infractions. Now you've got this to deal with. I will go with your recommendations of $100 fine and court costs, which will be $108. Now, I heard you lost the job. Are you unemployed at this time?
Yes, ma'am.
All right, I'm going to waive your attorney fees. So that'll leave you owing $208. Your controlling sentence is 120 days. I'll give you 6 months. Non-reporting probation. Your non-reporting probation means for 6 months from today, you're on probation, but you don't see a probation officer. You have 2 requirements. Don't violate any laws during the 6 months and pay the $208, and I can give you some time to pay that. How much do you need?
I'd say about 60 days.
I'll give you 60 days to pay. And you can stop by the clerk's office and they can give you the website and the other different options for making that payment. But make sure you get that done.
Okay.
All right. And then the rest of that, as counsel said, that's outside of my authority to deal with that. So You are excused at this time unless, Mr. Regier, there's anything further from the state.
Not on this matter, Judge.
Mr. Patterson?
Nothing further, Judge.
All right, thank you. You are excused,
you, Honor.
Mr. Talbert.
Last one I have, Yoakum, is Sean Yoakum. Yoakum with a Y.
Come on in, Mr. Yocum.
Sorry.
We are on the record in 2024 TR 3103, State of Kansas versus Sean Dean Yocum, Jared Regier for the state, Darren Patterson for the defendant, who also appears personally. We'll now take up the Cowan matter. If Christy Cowan would start her audio and video. We are on the record in 2024 2429, State of Kansas versus Christy Irene Cowan, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person and pro se. When we were here March 31st, 2025, the defendant did not obtain her drug and alcohol evaluation as ordered in January of this year. And we set the matter over with an order that the evaluation fees be counted as probation fees. The matter was set over one final time at the request of the defendant until today with the evaluation to be completed. But Mr. Patterson, as I went through my emails, I didn't find that. Did you
Judge,
send
you
it?
should have one from this morning.
Okay, well, let me look again.
And I sent it out this morning, Judge, but I do need to have a brief breakout with Miss Cowan again.
That'd be fine, Jen, if you would, but I'll look again. Ah, didn't look in the right place. Thank you, Mr. Patterson. Ah, he sent it upside down. Jen, where's the button to flip this thing around so it's not upside down?
Are you looking at something in a case or are you looking at an email?
I'm looking at an email. Can I turn that upside down or upside right?
I'm looking, Your Honor. Do you see over in the lower right-hand corner of that document?
Document itself or down below it?
Just, it should just be on the right-hand panel towards the bottom.
Okay.
Do you see the curly line with an arrow?
I do.
Push that. Did that work for you?
I'm pushing the one, I clicked on it, I brought up rotation lock. I want rotation unlocked. Oh, that's something I don't want it to do. Line that looks like a kind of an arrow, right?
Yeah, it's a circle with an arrow at the end of it.
Yeah, I see it. And then when I click on that, I get airplane mode, accessibility, and rotation lock.
Let me see if I can save this and send it to you again.
That'd be great.
Okay, Your Honor, it should be coming to you.
Thank you.
Thank you, Judge.
All right, thank you. We are back on the record in 24 TR 2429, State of Kansas versus Christy Irene Cowan. Begin with Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Now, gentlemen, from looking at my notes, I am not clear on whether we just put the plea agreement on the record or she did actually enter the plea to the DUI. What do you show?
Judge, on January 27, I do show that she did enter a plea of guilty, or no, I'm sorry, no contest to the DUI charge pursuant to plea negotiations at a time when she was in Greenwood County District or Greenwood County Jail.
All right.
And Your Honor,
Jen?
forgive me, Your Honor, that would appear an accurate reflection of my notes from the January 27th hearing as well, Your Honor.
Jen, could you add in those January 27 notes that she did enter a plea of no contest to that DUI? It implies it, but I think it doesn't quite outright say it. That she pled to the DUI. We set the sentencing, everything else is fine. All right, so at this time, the matter does come on for sentencing. And I have received the alcohol and drug evaluation. Mr. Regier, recommendations?
Yes, Your Honor. The state is recommending the statutory minimum fine of $1,250. It would appear that this is a case where count one is charged as a Class A driving while suspended. So the state would be recommending the statutory minimum fine on that front. State would further be recommending court costs, that the court make a determination on the issue of attorney's fees, a year underlying sentence with a year of reporting probation, subject to all standard conditions, including a $6 probation fee. Follow the recommendations of the drug and alcohol evaluation, a DUI victim panel, and any other orders the court may deem appropriate.
Excuse me, I thought that everything else was dropped other than the DUI.
That's what I thought too.
Yes.
That's what my notes show. Okay, so Mr. Regier, would you say the fines and costs again, please?
Yes, Your Honor. The state is recommending the statutory minimum fine of $1,250 as the DUI in this matter does appear to be charged pursuant to the amended information as a Class A. The state would further be recommending court costs. The court make a determination on the issue of attorney's fees. Suspended jail sentence of 1 year, subject to a year of reporting probation, all standard conditions, including a $6 probation fee, that the defendant be ordered to complete a DUI victim panel and comply with the recommendations of the drug and alcohol evaluation.
All right. I was like the defendant. I thought I heard an extra fine in there, but I must not have. All right, Mr. Patterson, anything else?
Judge, we are asking the court to adopt a recommendation of the state. Judge, this is, as has been noted, a DUI second Class A non-person misdemeanor. Because of that, there is a 5-day period. And we are asking the court to allow her to serve 48 hours in jail, followed by 3 days house arrest. We're asking the court to consider allowing her to begin that 48 hours on June 27 at 7 p.m. The extended period to begin that is because she has a trip that she has scheduled to help a person who has cancer, and she is trying to help that person out so that She is scheduled to be gone to help them until June 24. She'd asked the court to consider allowing her to continue to do that and then report in June 27 for the jail.
Very well.
And Your Honor,
Yes.
on the issue of the 5 days as required by statute, counsel for the defense does appear to be referring to the statutory provisions about 48 hours of imprisonment as provided for in KSA 8-1567 subsection B1 lowercase I. The state has no objection and is not aware of any statutory provisions which would require the court not to follow the statute in this matter.
Ms. Cowan, where do you work?
I'm self-employed.
And what kind of work do you do?
I rent out my residence as an Airbnb.
Okay. At this time, I'm going to follow the plea agreement. Your fine is $1,250. Your court costs are $108. You will pay $250 towards court-appointed attorney fee and $60 towards supervised probation fees. Your controlling sentence will be 12 months. That is 1 year from today. If you do not want to serve that, you must be successful on a 1-year reporting probation to be supervised by court services. Your first order will be to report to them immediately after this hearing. Their number is 316-322-4153. Again, call them immediately.
4153.
4153.
Thank you.
You're welcome. Call them immediately after court. You will be required to comply with the recommendations of your alcohol and drug evaluation, which focuses on mental health therapy to address mental health and substance abuse. You are required to get the first appointment set up for that. Call within 14 days if you're not already enrolled. You must sign any releases between your provider, your treatment provider, and court services so they can be advised of any and all attendance, participation, progress, and the like. You will also be required to complete the alcohol victims impact program. You are to call and have that set up within 14 days, and your probation officer can tell you where to do that. You are to not use any alcohol or illegal drugs on this probation. You are to report to them at all times and places as they tell you. You are to respond promptly when they tell you they need an alcohol or drug test, such as a UA or a hair follicle. Now, this 5 days is mandatory. You can either go and serve 5 days directly in jail, or I will allow you to go in June 27th. I'm going to order that you go in no later. Well, I'm just order that you do it on June 27th, 2025. You must report to the jail at 7 p.m. Take a photo ID and be prompt. Don't be late. After you've served 48 hours in jail, you can go immediately onto electronic monitoring for house arrest. 3 days or 72 hours house arrest. You are to have that set up so they can come to the jail when you're released and put that monitor on you. You can only be released for work, and it may just be that there is no work because you're going to have to be at home and you can't rent out your house as an Airbnb while you're doing house arrests, as I would assume.
That's
so So you may just have to sit there in your house for 72 hours, no releases at all. I think that's the way I'm going to work that. It's going to be jail. It's meant to be jail, and maybe it'll feel like jail. The idea is to get the impression that you don't want to go through this again.
Right.
So no releases, no house arrest releases. Just sit there for house arrest.
I do have a question
Yes.
on the victim panel and then the
That's right.
therapist that I
Mhm.
see. You had said the therapist is listed for trauma. It's not alcohol. I wasn't ever.
I think I saw something about alcohol and substance abuse.
That's what it's listed as. That's not, I mean, I went to the trauma center. It was for trauma, a dual diagnosis listed under PTSD and severe depression. But yet
Well,
alcohol
it-
was the cause.
you did have a DUI. The report I read said you should take treatment for trauma and substance abuse, and that's what I'm ordering.
Okay, just wondering.
You need a substance abuse program, it sounds like.
Well, I've already been through the 30-day. I went to a rehab on my own. That was a substance abuse and trauma.
Well, I will let you present what you have done to court services and let them decide if it suffices, if it meets what your evaluation recommends. And they may have to talk to the evaluator to determine that.
Okay.
So as I said, make sure you sign your release. You may not have to do any more other than the mental health.
Okay.
But that's, court, you're on probation and you're kind of at their mercy. Whatever they think you need to do to be successful, you need to do it.
Okay.
All right, thank you. You do have a hefty amount of money owed. So I can give you a couple of different options. You can either pay it all up front, which is about $1,668, or you can tell me how soon you can pay it. Or usually what I do for this amount is just say pay 1/12 of it each month. Which of those do you prefer?
The 1/12.
All right, you're ordered to pay 1/12 of the total amount due each month. Your first payment of 1/12 will be due July 2nd of 2025. And then on the second day of each month thereafter, 1/12 will be due until paid in full. Anything
Okay.
else, Mr. Regier?
Not from the state, Your Honor.
Mr. Patterson?
Your Honor, I did want to make sure Ms. Cowan had the phone number for electronic monitoring. Ma'am, please write this down. Phone number is 316-322-0021. Make sure and contact them before you start your jail time. They may want you to come in before you go to jail, have it put on so that you're immediately on it at the end of your 48 hours.
Okay. Okay.
Nothing further.
All right, then we'll be in recess and Ms. Cowan is excused to call her probation officer. You may go.
Thank you.
You're welcome. Now, folks, on the screen, there is a Lindsay Baker, and on my printout, there is a Lindsay Baker. But on the computer screen, I am not finding Lindsay Baker. Can someone help me out as to whether...
I have it as the first case on the docket, Judge. Lindsay Danae Baker. Nothing further, Judge.
We'll be in recess, and Ms. Ramirez, you are excused. You may leave at this time.
Thank you.
You're welcome. We will now be on the record in 24 TR 3329, State of Kansas versus Gabriel Daniel Casanova Simmons. Jared Regier appears for the state. Darren Patterson appears for the defendant, who also appears personally. Mr. Patterson, have you any announcements for Mr. Simmons?
You mind if I had a chat from Mr. Simmons that he wanted to have another breakout room. So if I could have a breakout room with him. Also, I just wanted to have Mr. Regier look at my summary. So when I get back, he can tell me if that's acceptable.
Your Honor, am I to send them to the breakout room?
Yes, I'm sorry. Yes, Mr. Simmons and Mr. Patterson.
Judge, could I have a brief breakout room with Mr. Regier?
Yes,
Yeah.
you're welcome. Then would you please put the attorneys in a breakout room? Yeah, Hey, Jen, would you look in that Priscilla Ersley file 22 TR 182. I went to file up the motion for judgment and it looks like Miss Stewart from this morning is in there instead of who I'm looking for.
Your Honor, will you please give me the case number one more time?
So 22 TR 1821. If you look at the April 8th return of service,
Return of service on the motion for judgment on bond.
right, isn't that in the wrong file? Isn't that Miss Stewart from this morning?
That absolutely is in the wrong file, Your Honor.
Okay. When you see a return on, looks like, let's see if we've got the right motion in February. Looks like we have the right motion, but no return in this one.
So honestly, Your Honor, if you look at the Shockley case and you motion for judgment on bond, that is a different name as well.
Okay, so did we just get the two documents mixed up?
Well, this is a completely different person. Open up the
the Stewart?
5:30, yeah. Document on 20 TR 639.
Judge, I will need a breakout room with Mr. Simmons one more time, then we can ready for a plea.
Okay, Jen, will you please accommodate them, accompany them to a breakout room? Well, Jen, I was hoping that if I looked in that file, the Stewart file, I'd find Ursley's return, but I'm not seeing it. Are you finding it? Ursley accident? It just doesn't look like there is one for Ursley.
I found one for Kingsley.
Kingsley, whose file is that in?
That's in the Shakla file.
Oh, my word.
Yeah, there's some things we need to look into.
Yeah, okay. Well, we'll take it all up and we'll get on the record.
Thank you, Judge.
You're welcome. We are back on the record in 24 TR 3329, State of Kansas versus Gabriel Daniel Casanova Simmons, all parties as before. Mr. Patterson, Mr. Regier, any announcements?
Yes, Your Honor, I would announce this time as to on the amended information filed March 25th, my client would be entering a plea of guilty to count 1, speeding. And then the states agreed to amend count 3 to no valid driver's license, KSA 8235. My client would plead guilty to amended count 3. States agreed to dismiss count 2, and 4 and 5 were previously dismissed.
Very well. That's your agreement, Mr. Regier?
It is the state's understanding, Your Honor. Additionally, as a preliminary matter, although this was not specifically discussed during the context of plea negotiations, the state's understanding is that at the March 26th hearing in this matter, the court did enter certain orders concerning booking and bond. I do have an affidavit from the jail in my file, which would appear to indicate that as of approximately 10 days ago, May 21st, 2025, the defendant has failed to report to the Butler County Detention Facility as directed by the court to be processed and released.
Judge, he did bring that up to me. He is aware that he did miss and is wanting to get that resolved as quickly as possible.
I can go up there today and get that knocked out as soon as possible. Like, I do apologize. The day that I had came up to the court to fill out the information for a court-appointed attorney, I had even asked the clerk and the security at the front desk if there's any way that they can get me to just go ahead and knock that out the way, since I'm already up there in El Dorado. And they both they clerk to send me to the security desk, and they told me that they don't do it that way. I'd have to book it. And but since that time that I went up there, I had forgotten to go back because I had already went up there trying to get everything completed. But I swear I had no malicious intent or nothing like that. I can go up there and get everything knocked out as soon as possible, like right after this.
You have a job?
I do.
Where do you work?
I work at Amazon.
How many days a week?
Approximately 3 to 3.5.
You work at least 40 hours a week?
Not necessarily. So a lot of the time we have downtime and they send people home, and that's been happening recently. So I wouldn't say 40 hours would be the appropriate number, but some weeks for since I've been there in January, I've maybe had 2 full weeks that I've actually worked 40 hours.
All right. say you're on the schedule and you just forget to go to work that day. What are they going to do?
I will get punished, but whether it be a write-up or a coaching or possibly even a walkout if I don't have the time saved up to miss that day.
How many times have you forgotten to go to work?
Only once.
Hmm. What do you think I should do since you violated a court order?
I understand you have to do what you have to do, but all I can do is I can assure you on my end that if the court lets me, I can literally go up there right after this and get everything knocked out the way. I did not miss it intentionally, and I'm doing my best to get this knocked out the way. Like with the situation that happened, I got my license. I paid for my license to be reinstated that same night because it was a Sunday night. It didn't
Stop,
get.
please. Stop,
Okay,
please.
I do
Stop,
apologize.
please. You started out with speeding 83 and a 55, operating a vehicle without a registration, driving while suspended, displaying a fictitious revoked or suspended license, and failing to yield to an emergency vehicle or approaching vehicle. Now you've managed to get this plea agreement.
And I'm not going against that at all.
Stop, please. You have managed to get this plea agreement where all you plead to is speeding and no driver's license in possession. Now, why should I go along with recommending, giving you the benefit of any recommendations your counsel may have worked for you to get, when you couldn't even take seriously enough my first order to you to even remember it?
I do apologize, as previously stated. I did go up there and I did try to get a hold of someone to let me to do it that same day. I don't necessarily have the gas to go to and from every day, and I understand it's not every day. It was a one-time thing.
Officer can give you I can order the officer to go pick you up, and you probably won't get charged for the gas.
I I can go today. Like I said,
You could have gone the day you were told to go too.
and I do apologize. I did not skip it maliciously.
Well, my experience generally is if I can't trust somebody to go out and vote and get their picture and prints taken and sign a bond, I can't trust them to do anything. They may not.
I understand that.
And this was an arrest. Stop, please. Don't interrupt. This was these are a series of arrestable offenses. You could have been taken into jail by the officer, and he gave you the courtesy of just letting you come to court without having to be arrested. I give you the courtesy of having you get to go out there on your own to do it, and you don't do it. Let me look at your Kansas record, what I have here in Odyssey. Where are you right this moment?
I'm in Wichita.
At home?
Yes.
When are you supposed to go to work next?
My next work is Wednesday at 6 p.m.
Do you have a valid driver's license now?
I do.
You have a car that's tagged, insured, and has working lights, brakes, etc.
I do.
Do you have gas in your tank?
I do.
You have enough to get to El Dorado?
Yes, sir. Yes, ma'am. Or yes, Your Honor.
Well, I just don't come into this plea agreement trusting you very much. I'll just be honest with you. You might just forget what I tell you to do today.
I can assure you, I will make it literally right. Once this call ends, I'll get in the car and head that way instantaneously.
Well, if they want to take you now. All right. Well, we will come back to that, and I'm going to go out and take a chance that you won't forget what I'm going to tell you. All right. You're alleged to have been speeding 83 miles per hour in a 55-mile-per-hour zone. How do you plead to that?
Guilty.
'83 and a 55. Why were you in such a need to go 83 and a 55?
At the time, I wasn't working with the company. I was doing deliveries, and it was just real late, and I had a screaming baby in the back, and I was just trying to make my way home. It wasn't intentional. I just, it was one of those things where you kind of zone out because you have so much noise around you, and the
So you
moment
had your baby with you making Amazon deliveries?
I wasn't working for Amazon at the time. I was just doing deliveries for like Grubhub.
All right. You married?
No,
The mother of the baby live with you?
no,
You're raising a baby by yourself, or who's helping you?
no. We kind of like we try to co-parent, but we're not together.
All right. And what about this? The state's amended your driving while suspended to no driver's license in possession. Were you driving without a valid license?
Respectfully, Your Honor.
Did I say it wrong?
Your Honor, the state's understanding of the plea negotiation is count 3 would be at least contemplate to be amended to no valid driver's license under KSA 8235.
Ah, thank you. Yeah. Okay. So you were driving without a valid license back there when they said you were? Are you admitting that?
Yes, Your Honor.
Well, you're pleading guilty to the amended charge, a Class B misdemeanor. And are you pleading guilty because you are in fact guilty of speeding 83 and a 55 and driving without a license?
Yes, Your Honor.
Was that May 4th of 2024 in Butler County?
I believe it was. I thought it wasn't. My tickets for December 14th or December 15th of 2024.
Look a little further. So where were you driving?
I was driving back home from I don't know the address. It was
From making a delivery, though. Were you on Highway 54 that links Andover and Wichita?
I do believe I was on a highway. I cannot quite recall exactly where I was, but yes, I was on a highway.
If the officer said you were traveling on US 54 highway at mile marker 228 west, would you take any issue with that?
I would not. I would agree.
And this was December 15th of 2024, about what, 6:59 p.m.?
Yes, Your Honor.
And is anyone making you enter this plea or take advantage of this plea offer today?
No, Your Honor.
You understand that if I accept your plea, you will be giving up your right to a trial, will be found guilty and unable to appeal your conviction.
Yes, Your Honor.
So you were going 83 and a 55 with your baby in the back. Where is that location, Mr. Regier, if you have that handy? If not, don't worry about it, but somewhere there on 54, 400, I presume.
Forgive me, Your Honor, I appear to have been previously muted. The ticket in this matter appears to refer to a stop occurred on US 54 at milepost 228. The state's understanding is that is within Butler County boundaries on the southeast side of Andover city limits.
Okay. Well, I accept your plea. I find that you do know what you're doing and that you're doing it voluntarily and that you've given me a factual basis. That is, you're saying your license was not legal at the time.
Yes, Your Honor.
You have a license that's legal now? You said you do?
Yes, I got it reinstated the same night. Or
How
what?
many days a week do you have care of your baby?
Just sometimes on the weekends. It's not very much other than that though. It's because I tend to work during the week, and so I can't really help too much on the week, but I do try to help.
All right. I find again, the defendant is guilty. Recommendations for sentencing, Mr. Regier?
Your Honor, the state's understanding is that specific disposition was not discussed during the context of negotiations. The state is not opposed to the scheduled fine, court costs, and the court determined attorney fees on count 1. On amended count 3, the state would be recommending a $100 fine, underlying sentence of 120 days, subject to a 6-month non-reporting probationary period. The state does recognize that final discretion of the sentence does fall within the court's purview in this matter. And again, I believe the state has already addressed the issue of the jail affidavit on the record.
Mr. Patterson, anything further?
Judge would ask the court to adopt the recommendation of the state. Nothing further.
Okay, I am going to go with the recommendations of, on count 1 speeding, your fine is $177. On count 3 as amended, $100. Court costs $108. What do you pay in child support, or what do you pay for this baby?
I mainly just get formulas and diapers, and I don't pay child support at the moment.
All right, I'm gonna have you pay $250 towards your court-appointed attorney fees.
Okay.
Looks like that's somewhere in the neighborhood of $635. Also on amended count 3, you're gonna have 120 days in jail. I will grant you a 6-month non-reporting probation. Boy, I hope you don't forget this, because if you forget it, you're gonna get your probation revoked and you're gonna serve 120 days in jail.
No, I promise I'm writing everything down as you say it. It's fine.
The first condition of your probation is to violate no laws. Don't speed, don't jaywalk, don't rob a bank, pay your taxes, don't violate any laws. Keep the baby in the car seat. Don't violate any laws. Wear your seatbelt. Don't violate any laws. Number 2, you need to pay that $635. How soon can you pay that? I can give you some time.
Let's see what if you can give me till the end of July, I can have it all paid off.
I'm going to give you 90 days. That's going to be past the end of July. 90 days from today.
Okay.
It's going to be about September 2nd approximately. But you make monthly payments on that.
Okay.
And I'm not going to set up any specific monthly payments, just that you make at least something every month on it by the 2nd day of each month, so that the whole thing is paid by 90 days or within 90 days. Now, what to do about you violating a direct order given to you from the bench here in court? I am going to give you this benefit that you're going to go out there and do that. But Deputy Caulfield, or deputy on duty, do you want to Can they take him if I send him straight out, or do you need to set an appointment with him?
He will just need to call 316 322
1-6-3-2-2
4160
4160
and schedule with Amanda.
Now, I need to give him something so that they can let me know if he doesn't do it. Do you think if I give it order that it no later than 1 week, they'll be able to get him in within the week, Deputy?
Yeah. Yes, Your Honor.
So I'm going to order you to call that number as soon as we're out of court and get a time set up within the week, within
Yes.
the next 7 days.
I'll get it done the soonest time I have available.
All right. If I get a notice within 7 days that you haven't been out there, that's a violation of your probation.
Yes, Your Honor.
And what happens if you violate your probation?
If I violate my probation, I get 120 days in jail.
Yeah. Okay. And contact the clerk of the district court to find out how you can make your payments. And that number is 316-322-4370. Any questions about any of this, Mr. Simmons?
I'm sorry, what was those last four numbers?
For the clerk?
Yes.
4370.
316-322-4370.
Correct.
All right, I got it all. Thank you so much.
All right. And I'm going to make you sit and watch this video back if you don't do it.
I promise it'll get done today.
All right. I'm going to trust you for it. All right. You're on probation. Counsel, anything else?
Not on this matter, Judge.
All right. Thank you all. We'll be in recess. Mr. Simmons is excused. At this time, let's go take up Simpson on the record in 2024 TR 1783, State of Kansas versus Sean Stephen Simpson. Jared Regier for the state, Mr. Patterson for the defendant. Simpson, who fails to appear for motion for judgment on bond concerning 1 count of driving while habitual violator. Checking the court file, it looks like certified mail notice went out to
Every day in the USA, people find themselves in court.
The court will call the case of the state of Michigan versus Samuel Dobrowolski, case number 21-0010-190. Sorry.
Tiffany Woods for the people.
Okay, now Mr. Lebo's in the breakout room.
Sorry, Your Honor. Allison Muller stepping in here for Mr. Dobrowolski. Sorry if I'm mispronouncing your name, sir. Can you go ahead and state your name?
Samuel Joseph Dobrowolski.
Thank you. We're here for a review in this case. Mr. Dobrowolski is reporting like he's supposed to. He appears to be attending his counseling, but is resistant to any type of medication, apparently. He wants his tether off. But that is likely not going to happen. So, Ms. Woods? Well, first of all, Ms. Muller, is there anything you want to say on behalf of your
Notes are just about the tether, but if the court is not inclined to do that, then I think that's all that we wanted to talk about.
Thank you.
Or Your Honor, sir, I'm sorry. I think the note was just regarding the conditions of the tether. He does work as a driver And so the hotspot was, I think, just to allow him to continue or go back to work as a driver until he can find other work.
You said hotspot?
I think that was the request to switch from he's on the home confinement tether now and to have it switch to a hotspot tether so that he would be able to leave
I
his
see.
home.
Judge, I know that when we had our hearing back in March, the defendant made some unsettling comments to the court about he believed him and the victim had a cure for cancer, and the world needs to work with the victim, and the Green Party needs to have contact with her as soon as possible. He made a bunch of comments like that that alarmed the court and the victim. So I believe that's why you had and you had ordered a drug and alcohol test within 24 hours, and then the home confinement tether within 24 hours. I don't know, has he been drug and alcohol testing? I haven't received any kind of report. So that I do have concerns with his mental health. And I did receive that medical documentation as well, but that's why we were so concerned with where he was and what was going on with this defendant because of those comments he made at the April hearing, Judge.
Thank you. Ms. Johnson, is he testing? Good morning, first of all.
Good morning, Your Honor. We don't have him on a set testing schedule. The last test that we sent him for back in March was negative for all substances.
I see. Thank you.
You're welcome, Your Honor.
He was not set for testing overall, just a one-time test so that we could see if there were any drugs involved. So that was sufficient for me and still remains so.
Thank you, Judge.
Mr. Dobrowolski, is there anything you want to say, sir?
No, there's not.
Okay. Is there an ability to give him a hotspot tether as opposed to a general home confinement? Do we need to talk in a breakout room about that?
I believe we can do a hotspot. I would just need to confirm with Ms. Woods victim's information so we can provide that to community corrections.
Okay. I would consider that unless there's some objection from the prosecutor's office.
Judge, I would leave it up to your discretion. I just want to make sure that, he stays away from where she lives and where she works with that GPS tether. If we can work something out like that.
Can I see everyone in a breakout room, please? All right, we're back on the record in the Dobrowolski matter. I'm gonna have the prosecutor's office provide any updated information to the probation department, and then I will assess whether or not I think that a zoned hotspot tether is appropriate, and make a decision in the interim time period so that Mr. Dobrowolski won't have to wait and he can return to work. I think it's important for him to return to work. I think sitting around the house is not healthy for him either. I think working would be good, but I also want to make sure that he has no contact and does not come into contact with the complaining witness, the victim in this case. So I'm very concerned about that as well. So once I get the information, I will assess whether or not I think it's appropriate. If I deem that it is inappropriate, then I may reset another court date sooner than the date that I'm about to give now. Otherwise, I will probably just issue the hotspot if it is a feasible situation. It may not be feasible to do so. All right, I'm gonna schedule a review, in this case, in 60 days in any event, on August 11th at 10:00 a.m. So we'll see you back then, Mr. Dobrowolski, okay?
Goodbye.
Goodbye.
Thank you.
You're welcome. Court will call the matter of the state of Michigan versus Alexander Cronon, case number 23S00315.
Tiffany Woods for the people.
Assistant Blood Defender Davi Luba for Mr. Cronin. Mr. Cronin, could you state your name, sir?
Alexander Cronin.
Thank you. We're here for sentencing today.
Yes, Your Honor, I have
Anything-
not received a report.
There is no report to be made. I had indicated on the record, and to everyone at the last hearing that I didn't need a report. I just needed to look at his prior history and give the complainant an opportunity to give her a victim impact statement today.
Thank you.
Anything from the people?
Judge, we do have the victim here, Miss Fink, who would like to give a statement to the court.
Thank you. Ms. Wilson, is there something you wanted to say before him? Or okay, thank you. All right, Ms. Fink, you may proceed.
Dear Judge Washington, thank you for letting me speak my truth. The incident occurred over a 3-day span of verbal, physical, and emotional abuse. The defendant had complete control over me and manipulated me to the point that I felt isolated and alone. I felt I couldn't reach out to my family and my friends due to embarrassment. I woke up on the morning at 6 p.m. The defendant was choking me until I could not breathe. Then the defendant jumped on top of me and started beating me, which resulted in a concussion and a broken rib. I ended up in the ER for treatment. The second day, I ended up trying to walk around the home, and the defendant then slapped me in the head again. With shame and fear, I went back to my room and stayed in my room. The third day, I got up to make breakfast. The defendant entered the kitchen, slapped me with a spatula, and in the behind. The defendant told me, as long as we do what I say, then everything's going to be everything's going to be okay. Throughout the entire relationship, The situation only escalated to a toxic environment, and I didn't know where to turn. The defendant would take my car, preventing me from leaving the home without him. He would also hide my prescription bottles and instead offer me lavender. Calming would work, he said. Throughout the entirety of our relationship, the situated into a toxic environment. I didn't know how to turn. The defendant, I'm sorry, I read that twice. I'm sorry.
Okay.
The defendant's abuse caused and continuing caused both physical and mental trauma to my body and mind. He focused me to create 2 large board signs listing the rules that I should follow in my home. These signs were, sorry, these signs were served as constant reminders of the power and the control he exerted over me when I was supposed to be in my own safe place. The relationship had a lasting impact on my life. I worked every day to heal, but the defendant's actions has left me. I'm sorry.
Okay. Take your time.
Living in constant fear. Because of the abuse I endured, I didn't believe I'd ever feel safe enough to date again. When I'm out in public, I am constantly looking over my shoulder, always hyper aware of my situations. I sought medical help, including counseling and medications. As the trauma and the cope happened on this day, I have to get my groceries. I'm sorry. I have to get my groceries and my prescriptions delivered and attend medical appointments online. Choice driven in fear, I still carry knowing that the defendant is free and living in the community. The trauma I experienced in the abusive relationship has deeply affected me. My ability to trust, connect, and feel safe, both personal and social settings. I become hypervigilant, constantly scanning the environment for danger, which makes it difficult to relax and engage in everyday activities like grocery shopping and attending medical appointments. This constant fear has strained my relationships with friends and family, as I often isolate myself to struggle, questioning my self-worth and feeling unworthy to love and support, making the idea of entertaining a new romantic relationship feel impossible. Even when surrounded by people I care, I find it hard to believe I'm truly safe and understood. This trauma continues to shape my daily life, keeping me in a state of survival rather than allowing me to truly heal and rebuild. Sorry. The defendant has yet to take genuine accountability for the harm and trauma he inflicted on me. The lack of remorse speaks volumes of his character and raises serious concerns about the likelihood of violent behavior. I fear for my safety or others in my community. I have not received justice in my case, and deep down, I know the defendant poses an ongoing threat and will likely offend and harm more women. Throughout my process, I believe increasingly aware that the defendant remains active threat to the community. He has already demonstrated and regret disregard the court orders of the judge, has witnessed firsthand during these proceedings. I strongly believe the defendant should not receive credit for time served and should be instead sentenced to probation. The defendant is a predator who deliberately seeks out control to harm women. I urgently ask the court to reconsider the plea that was offered. It is critical that the defendant is closely monitored by the justice system to prevent him from inflicting further harm on others as he did me. My safety to other women in our community depends on it. And to you, Alexander, I sincerely hope you choose to seek treatment because of your behavior, both during our relationship and throughout this case. Has been deeply concerning. It's clear to me that you have not changed and have shown no remorse for the harm you caused. I came to realize that I didn't need your knowledge, that I need your acknowledgement and behavior. While I continue to work on healing and bettering myself, you remain a danger to others. The entire process does not appear to have impacted you, but I hope that one day you're forced to confront the pain and damage you've inflicted, not just to me, but to potentials on others. Thank you.
You're welcome, ma'am. Thank you. Anything else from the people?
Judge, he pled to the DV4A because we assumed he was getting, some probation time. And, it's, the court is looking at giving him time served, which it's in the discretion to do that. We would have liked to have seen him get placed on probation because we feel that the programs would have, been beneficial to the defendant. And as you can tell, the victim is upset that he's going to walk away with time served. But he's not going to be able to get the DV4A if he doesn't complete some sort of probation. So that's all I'd like to say. Thank you, Judge.
My notes didn't write down the 4A. Is the defense under the impression that he pled under a 4A?
No, Your Honor.
Okay, I was not either.
Then my notes must be mistaken then, Judge. Okay, if he's not getting the 4A, then I would strike those comments, Judge. Thank you.
Thank you. Mr. Cronin, what would you like to say, sir?
I have nothing to say other than that I did not violate the court's orders. I've been very compliant, and I'm looking forward to moving on with my life.
Thank you. Anything else, Ms. Lebo?
No, Your Honor. Thank you.
All right. I do intend to give him the 93 days credit time, sirs. This is a 93-day offense. 93 days in a Washtenaw County jail, credit time served, fines and costs to wait. We're done with this case.
Thank you, Your Honor.
The court will call the case of the State of Michigan versus Sherelle Parker, case number 20S00534.
Tiffany Woods for the people.
Allison Muller here on behalf of Sherelle Parker. Ms. Parker, can you please state your name?
Credit time, sirs. This is a 93-day offense. 93 days in a Washtenaw County jail, credit time served, fines and costs to wait. We're done with this case.
Thank you, Your Honor.
The court will call the case of the State of Michigan versus Sherelle Parker, case number 20S00534.
Tiffany Woods for the people.
Allison Muller here on behalf of Sherelle Parker. Ms. Parker, can you please state your name?
Sherelle Parker.
Thank you. We're here for a review today.
Yes, Your Honor. We have gone over the report and recommendation with Ms. Parker. We are asking the court to follow the recommendation.
So it appears that Ms. Parker has not completed any of the terms of her probation. And the only reason why she's asking me to follow is because the probation agent is willing to give her one more chance. This will be the final chance. Ms. Parker, if you don't complete the terms of your probation, then what's going to happen is you're going to get violated and you can do jail time. Okay?
Okay.
Thank you, Your Honor. We understand.
Anything from the people on this?
Nothing.
Can I
Judge.
say something?
Yes.
I know that he wants me to do the MAD victim program
He
in the
doesn't
next
want to, I sent you to it.
14 days. I believe it costs like $65. I will not have that in the next 14 days. So I'm asking, can you give me like maybe 3 weeks to do that instead of the 2?
You think you can get it done in 3 weeks, ma'am?
Yes. I just won't be able to do it in the 14 days.
Okay. All right. Anything else you want to say, ma'am?
I was wondering, is there a somewhere closer that maybe I could go and report to? My transportation was down. It's not reliable.
When you say report to, what are you referring to? I'm sorry. Are you talking about?
To drop because I stay in Detroit.
Yeah, we can give you a closer place to go to instead of coming way back to Washington County. Absolutely.
Okay,
Yeah.
that will work better for me.
Yeah, you just need to talk to your probation agent. He can help you find the closest testing site so you can test there. Okay. Anything else, Ms. Parker?
Yeah, and can you tell me how much it costs to do these things? I mean, to go drop?
No, I can't. I don't know. Depending on which place you go to, the drop-in costs are different at various places. So you'd have to call and talk to them about that.
Okay, that'll be it.
Okay. All right. So we're going to give you another chance. You need to test and check in with probation within 24 hours. So I would call your probation agent first so you can set up your testing site. So you should do that as soon as you get off the phone, actually. So Mr. Pappenhagen, I hope you can take her call. I know we're in the middle of court, but hopefully you can take it today so she can figure out where to test at and maybe get that set up as quickly as possible. You must complete the victim impact panel within 21 days, ma'am. We'll do a review of the case in 30 days still, because you should have it done by then. Well, you say you can pay in 3 weeks. I'm gonna put it out for 45 days. I'll give you to July 21st to get back on track. Right, you're gonna come back in 45 days on July 21st, 2025. We'll see you at 10 a.m. and hopefully you're in compliance at that time, ma'am. Make sure you, do you have the probation agent?
No, I do not.
I'm gonna give it to you now and you should write it down.
Okay, 1 second. Oh.
It's no rush because we're in the middle of this one still. Here's heads up.
Okay.
734.
Mhm.
I should write down the number in case you get referred to probation. 734 48. What is it? 483? Just forgot it. I had a blank. 483-7336, or is it 484-7336? It's 483. Okay, 483-7336.
Okay.
So please call them today as soon as possible to talk to Mr. Pappenhagen, okay?
Okay, thank you.
You're welcome. Have a good day.
You too.
Bye-bye. Roll call the matters of Ozell Hyman, case numbers 25 FB 1007, 25 FB 1036, and 25. No, those are the two.
Tiffany Woods for the people.
Allison Muller here on behalf of Ozell Hyman. Ozell, can you go ahead and state your name, please?
Ozell Hyman.
Thank you. We're here for sentencing and a pretrial.
Yes, Your Honor. And I can address whichever one the court would like to start with, the sentencing or the pretrial.
Let's start with the pretrial first.
Okay, Your Honor, we would like to set the pretrial for final settlement conference. I believe we're also here today to address the bond and the hearing regarding the bond violation.
So, we're supposed to have a hearing today on the strap tether alert, is that correct?
That's correct, Judge. I'm just seeing if my witness is here. Mr. Chris Davis. He's the operations supervisor from JSG Monitoring.
He's just present.
That he is present, Judge.
Yes. So we're ready to proceed on the hearing.
Yes, Judge.
And Your Honor, defense would have 2 witnesses logging in. I don't know if they're in the waiting room. I think I just missed a call from one of the witnesses, Mr. Hartman.
Nobody is in the waiting room.
Okay, I'll call him back and see what the login issue is.
Hold on one moment, please. All right. The court's gonna be on a brief recess for about 5 minutes. Do you need to speak with your witness, Ms. Woods? I'm sorry, you're muted.
I'm sorry. Yes, Judge.
All right, we'll put you in a breakout room with your witness. Ms. Muller, hopefully your witness signs in. If we're not ready to go when we return, then what we're gonna do next is the failure to appears.
Okay, thanks, Your Honor.
Do you need to go in with the defendant, Ms. Muller?
If I could, Your Honor, thank you.
Thank you. All right, the 14B District Court is now back in session. The court will recall the Ozell Hyman matters, 25 FB 1036 and 25 FB 1007.
Tiffany Woods for the people.
Allison Muller here on behalf of Ozell Hyman. Ozell, can you go ahead and state your name again, please?
Ozell Hyman.
Thank you. All right. It appears that we're ready to start the hearing. Is that correct?
The people are ready, Judge.
Defense is ready as well, Your Honor.
All right, thank you. All right, you may begin the bond violation hearing, Ms. Woods, and you can call your first witness.
Thank you, Judge. The people call Chris Davis.
Thank you. Mr. Davis, please unmute your device and state your name.
Chris Davis.
Thank you. And do you swear or affirm that the testimony you're about to provide would be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. All right. Can you spell your name for the record, please?
First name's Chris, Chris. Last name Davis, Davis.
Thank you. Your witness, Ms. Woods.
Thank you, Judge. Mr. Davis, could you please state your name again for the record?
Chris Davis,
And where are you currently employed?
JSG Monitoring.
And what do you do at JSG Monitoring?
I am the operations supervisor.
Okay. And how long have you been the operations supervisor?
I've been in this position just a little over a year now.
And what do you do in that position?
I oversee a team of monitoring agents and work with different contracted positions.
So I'm going to take you back to March 23rd of 2025. What happened that day?
That morning, I received a phone call from our on-call agent saying that there was a client in Washtenaw that we needed to meet with because of a strap tamper on the device.
Okay. And what did you do? Did you meet with the client?
Yep, I contacted Mr. Hyman and scheduled a time to meet with him at the Community Corrections Building.
And are you referring to Ozell Hyman?
Yes.
Okay. Do you see Ozell Hyman on your Zoom up at the top?
I do.
Could you just describe the clothing he's wearing?
Looks like he has a green jail suit on.
Judge, may the record reflect that the witness has identified Mr. Hyman.
Any objection? Ms. Mueller, any objection?
I'm sorry, Your Honor. I didn't realize I muted myself. No objection. Thank you.
All right, thank you. The record shall reflect.
So, you met with Mr. Hyman at Community Corrections?
That is correct.
And what happened when you first met with Mr. Hyman?
I inspected the device.
Did you notice anything? What did you notice about the device?
There was a cut on the strap.
And did you discuss the cut on the strap with Mr. Hyman?
I did.
And what did he tell you?
I asked him what happened to the device, and he stated that he did not know there was a cut on the device.
Did he tell you how he thought the device was damaged?
Please stop.
Testing. I apologize, Your Honor. We're back up and running on the record.
All right, you may proceed.
Thank you, Judge. Mr. Davis, did Mr. Hyman tell you how he believed that strap was damaged?
He stated that he did not realize or know that it was damaged, and that he suggested it may have been due to the cold weather.
Is it possible for the cold weather to damage a strap in that manner?
No, it is not.
Okay. And from your training and experience, what did it appear had happened to the strap?
The clean slice in the strap, in my experience, indicated a cut.
When you met with Mr. Hyman, did he tell you at any time that he cut that strap?
No.
Did he tell you at any time that someone else cut that strap?
No.
Okay. And so when a strap is cut like that, what do you do next?
In this instance, I replaced the device with a brand new functioning device.
Judge, I have no further questions.
Thank you. Your witness.
Thank you, Your Honor. So Mr. Davis, I just really have a few questions here for you. So I understand it's correct that on the morning of the 23rd, someone from your company contacted Mr. Hyman about the tether alert. Is that correct?
Yes, I believe our on-call agent did try to make contact with Mr. Hyman.
Okay, and they made successful contact with him?
I am not unsure of that. I was not on call. I was just contacted to meet with him.
Okay, but he did come in the morning of the 23rd there to corrections to have his tether replaced, correct?
Correct.
Okay, and he came there on his own accord. You're not aware that he was brought into corrections by anyone?
Correct.
Okay. And I know you said this, I just want to make sure I'm understanding. So when you asked him how was the tether damaged, his first response was, I do not know. Correct?
Yep.
And so when he mentioned the cold weather, it seemed your impression was that he was speculating how this could have been damaged, correct?
That is correct, yes.
No further questions. Thank you.
Any further questions from you, Ms. Woods?
No, Judge.
Thank you. You may be excused, sir. You're welcome to stay or leave. It's up to you.
Thank you.
Thank you. Any further witnesses on behalf of the people?
None from the people, Judge.
Your witnesses from the defense, Ms. Mullen.
Thanks, Your Honor. Your Honor, defense would call Shanta Hyman, who's here on Zoom. Ms. Hyman, if you could go ahead and state your full name, please.
Shanta Hyman.
All right. We're gonna ask that, is there gonna be a second witness?
Your Honor, there may be, I do likely plan on calling Mr. Eddie Hartman. He is there on the device with Ms. Hyman.
All right, I'm gonna ask that he goes to a different room and come back after her testimony.
Mr. Hyman or Mr. Hartman, do you understand? Can you please go in a separate room and have the door closed, okay?
Yes, I will.
Thank you so much.
All
Okay,
right.
he's left.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Hyman, can you explain your relationship to Ozell?
He's my brother.
Did she spell her name?
Oh, I'm sorry. No. Ms. Hyman, can you spell your name?
S-H-A-W-N-T-A. Last name Hyman. I'm sorry about that. That's H-I-M-O-N.
Thank you. Please raise your right hand and be sworn. Do you swear or affirm that you promise to tell the truth, the whole truth, and nothing but the truth under penalties of perjury, ma'am?
Yes.
All right, thank you. You may proceed.
Thank you, Your Honor. Ms. Hyman, can you explain your relationship to Ozell, please?
He is my brother.
And you are now familiar with the fact that Ozell does or did back in March have a GPS tether on his ankle. Is that correct?
Yes.
And before we proceed, if she cut a tether, that is a felony. So, ma'am, you understand that if you cut a tether, you could be charged with a felony in this particular case, and that anything you say today can and will be used against you.
Yes.
And that does she need counsel if she plans to cut this tether?
Your Honor, she did not cut the
Okay.
tether, and that will
All right.
not be her testimony today.
All right, thank you. Then you may proceed.
Thank you. Ms. Hyman, can you, on the evening of March 22nd, was there another person in the home with Ozell and your dad, Eddie?
Yes.
Okay. And at some point, did that person indicate to you anything relating to the tether on Ozell's ankle?
I'd object to hearsay.
Your Honor, if my response would be, as far as I know, hearsay is allowed in a bond violation hearing, according to MRE 1101B3.
That is correct. You may proceed. It is allowed.
Thank you, Your Honor. Ms. Hyman, if you could go ahead and relay the information that you heard from this individual who was also in the home with your dad and Ozell.
My sister told me that she cut his tether because he wouldn't go to the store for her and he was asleep. She was trying to wake him up.
And how did she tell you this information? Was this an in-person conversation or?
It was in person.
Okay. Did your sister indicate after doing that she was fearful of what might happen?
Yes, after she did that, she was very fearful. She's very young. She just had a baby and she was scared to go to jail.
How old is she?
21.
Your Honor, I have no further questions for Ms. Hyman.
What day did she tell you this, ma'am?
She told me this maybe about a month ago
Do you know
when
the
she was
exact
still in the
date?
home. I don't know the exact date because soon after she moved out.
What's your sister's name?
Ariana Hartman. And can I please correct the court? I was just told she's 22, not 21. I just want to make sure that we have it right.
Who told you that?
My sister, she's over there.
She's there today?
No, not the same sister.
Oh, okay. Ms. Woods, your witness.
So your sister told you that she cut the tether. Is that that's what you said, testified to today?
Yes.
And you love your brother?
Yes.
You have a good relationship with your brother?
Yes.
And you don't want to see your brother sitting in jail over this, is that correct?
Yes.
I have no further questions.
Thank you. Any further questions, Ms. Mueller?
No, Your Honor.
All right. May this witness be excused.
Yes.
Thank you. You may be excused, ma'am. If you could swap rooms with your brother,
my dad.
Your father, please.
Okay, thank you. That
Yes, hello?
Yes. Good afternoon, sir. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand.
Mhm.
Could you state and spell your name for the record, please, sir?
Yes, Eddie Hartman, EDDIEHARTMAN.
Thank you. Ms. Woods, we already know what his name is, so you don't have to ask him what his name is again.
Okay, thank you, Your Honor. I can go ahead with questioning at this
Yes,
time.
you may. Sorry,
Thank
no
you. Thank you. Mr. Hartman, can you explain your relationship to Ozell?
Yes, well, he's my son.
And I understand that in March of this year, specifically March 22nd and March 23rd, Ozell was living with you at that time.
Correct.
Okay. Was another one of your children also living with you in your home at that
Yes.
time or staying with you?
Yes, I have a few of my children living with me.
Okay. Was your daughter Ariana staying with you at that time?
Yes, she was.
At any point after March 22nd, did Ariana express anything to you related to the GPS tether on Ozell's leg?
No, not at that specific time. Can I illustrate my knowledge of the situation?
Absolutely, yeah.
Yeah. Well, I have a garage attached to my house, which I call it my man cave, where I have my friends over, and my son was he had come to my garage. Matter of fact, he fell asleep in my garage. It's my understanding that my daughter
Can you ask the
Ariana
person
was
in the
mad
back
at my.
to stop talking, please? Can you ask the person in the back to please stop talking? Is that the jail? Okay. All right. Try it again. I'm sorry, sir. I thought that was your background noise. You can go ahead.
Yes. Well, it's my understanding that my daughter and my son, he was in my daughter's bedroom, and she was mad at him for some reason. I'm not quite sure, but she didn't want him in her bedroom. He fell asleep in her bedroom, and it was an officer come. Matter of fact, I don't know if it was Washington now. No, it wasn't Washington County. It was Inkster police come and addressed my garage at the time that he had made it to my garage and he was sleeping in my garage, and they were saying it was something going on with his tether, and they said that they thought at that particular time they even said that his cutter is something going on with his tether, and I say, well, I invited them in. The officer come in and we looked at his tether and they didn't see nothing wrong with it, you know, and they told him that he is to come to I think the correction officer there where he was next to the jail there, and to come in there so they can observe what's going on with his tether. And that's what he did, you know. My son had been very much in compliance with everything that was been asked of him. And when we found out later, when he well after the police left, he found it was the next day. The next day, my son, I asked him about it, and he said he didn't do anything to his tether, and I believe him. It's nothing that I saw him trying to do. They were saying he was trying to run away or escape or something, which that was a thing from my son's mind. Matter of fact, I've been with him all the time. I've been bringing him to the jailhouse for all of his court dates, and you know, he's been compliant. Matter of fact, it's been a few times that he's been asked to go for me to take him so he could be tested for alcohol, surveillance. I took him that. He's been compliant for everything that they was
So
asking him to do.
Mr.
Later
Hyman, if I
on,
could just cut in for just a minute. So I think you've given a good explanation leading up to the event. So then, like you said, he went into corrections, he had his tether replaced.
Yeah.
And so, and Ozell indicated to you was your testimony that he didn't know how it was cut. So at what point did you learn?
Say that.
Sorry, Your Honor.
I did not hear him say that.
I thought he said that he was talking to Ozell and he didn't know how it was cut.
Oh yes, my son said that to me. I asked him. I asked my son. I said, "Do you know anything about this?" And he said, "No, he didn't know."
Know
And
anything about what, sir?
we
Know
did not
anything,
know at that time what.
Mr. Hertman, just slow down. Just
know
you answer.
anything about what?
Beg your pardon?
You asked him if he knew anything about what?
About his tether.
What
Was,
about?
you know, because when I took him, and when we come from the officer, when he came out, and he was shocked, and I was shocked. And he said his tether was cut, and I said, "How tether cut?" I said, "You know, what's this?" He said he didn't know what had happened. We found later when we got back that my daughter, she didn't tell me, you know, and he said it must have been his sister. He told me, he said it must have been Ariana because she was mad at him for not leaving out of her bedroom. And he also said that she did some other things to him while he was asleep. My son was asleep in her bedroom. And he also burned his trousers that he had on, trying to wake him up. So she was
Mr.
very.
Hertman, who burned the trousers?
Say it again.
Who burned the trousers?
My daughter, Ariana.
Okay. And did Ariana, so I understand Ozell believed it to be her. Did Ariana ever tell
Yeah.
you directly that she had messed with his tether?
No, she did not. She never told me directly, but I asked her, did she do it? And she never said that she didn't. She never said that she didn't, but it
So
was my
she didn't, let me
understanding.
just understand that point. So she,
Please slow down until the question comes to you, okay?
Well, no, she never, my daughter never told me, but I asked her and she said that her son, she said my son wouldn't leave out of her room and she was mad at him. And I think it was something else that was going on with them. They was, you know, back and forth, and they was together earlier, and then later on, for whatever reason, they wasn't speaking to each other and back and forth. And my son believed that it must have been her that did that.
okay.
And later on, also later on that day, my daughter Shanta told me that Ariana told her that she did it, but she didn't.
Sir, you can't say that. That's double hearsay. We can have
Oh,
hearsay.
okay,
double
okay,
hearsay.
but okay, well, I understand. Okay, well, but that's
Thank you,
that's
Mr.
what my.
Hartman. Thank you for
Mhm.
explaining. I think I have no further questions for you at this time, okay?
Yes, okay.
Ms. Woods?
Yes, where's your daughter? You're Mr. Hartman, correct?
Yes.
Where's your daughter Ariana today?
Well, she's with her mother in Detroit.
Okay, why is she not testifying?
Well, I think that she's very scared. She's thinking that she's going to have to go to jail for what she did, and she's worried about her baby. She don't want to leave her baby, and I explained to her that she needs to be honest if she know anything to tell the truth. And rather than to admit something that she might have did, she went to her mother, and
How do you
she's
spell
there
your
now.
last name, sir?
Hartman,
How do you spell,
Hartman,
how do you spell Ariana's first name?
Arrianna,
Spell it again.
Arrianna,
Does she have a
Ariana,
middle name?
Marie.
I have no further questions.
Yes.
Thank you. So I have one question. When you asked her if she cut the tether, did you see any indications that would lead you to think she did?
Yes. Yes. She looked nervous and she looked angry. Like she's mad at him. Because I asked her, and I told her, say, if you had a problem with him being in your room, you should have come and let me know what if I would have helped. Otherwise I would have made him leave out of the room. I really think.
When you asked her, sir, did she, how long did it take her a while to respond, or did she have an initial response? What was her initial response?
Well, initial response was she never said that she did it. She just started telling me the things that he was doing to her and saying to her. Yes, she never did. She was mad at him. She was angry at him.
Thank you. I have no further questions. Any questions from you, Ms. Mueller?
Nothing further. Thank you.
Ms. Wood?
No, Judge.
Thank you. All right, you may be excused, sir. Any further witnesses, Ms. Mueller?
Your Honor, if I could, I don't mind saying this just here on the record, but Ozell, I don't think anything further is needed from your testimony. So if you feel comfortable, I think we should rest there. Is that okay? Your Honor, then nothing for.
He's muted.
Okay. Ozell, can you just confirm audibly? I did see your head nod.
I'm okay to proceed.
To rest there without your testimony, is that correct?
Yes, that's correct.
Thank you. Arguments?
Judge, the defendant, there was a cut on his tether. He went to community corrections. He said he had no idea how it happened. He believed that the cold weather caused it. We heard testimony from his sister that's blaming it on another sister. Then we heard testimony from a father who says that she never admitted to him that she did it. And it's just all hearsay, Judge. I mean, where's the sister? I find it extremely hard to believe that while Mr. Hyman was sleeping, that his sister got a knife, got into his bed, lifted up the sheets, lifted up his pant leg, and got in there and started cutting his tether. And why did she stop? She didn't cut it all off. Mr. Hyman never woke up. He didn't even know. He's saying he had no idea. So what made her stop if she was so upset? She wanted him to go to the store to get him to get her something from the store. And she's 22 years old. She can't go to the store herself. And why would she stop? Makes no sense. This whole entire story makes no sense. And the fact that this whole family is putting someone at that now I'm going to research into charging a felony for. It's a little bit concerning, all the testimony all around, Judge. Thank you.
Thank you. Ms. Muller?
Your Honor, what I find to be more questionable is that Ozell would have this cutting, if the prosecution story is the correct one, and he had this attempt to cut his tether. Ozell came to corrections the very next morning. As soon as he was alerted, he had a new tether put directly on. In addition to that, when the warrant was issued, he called me frequently the whole time the bench warrant was in place, just advising. He was helping his dad at the time, so he didn't turn himself in directly, but he was planning the whole time to turn himself in, which he ultimately did. So for someone who was allegedly planning an escape attempt, he really didn't try very hard to flee from the court. Ozell has always maintained that he did not cut the tether. That's what we heard from Chris Davis. His first answer is, I have no idea how this cut was in place. When he was asked to speculate how it might have gotten there, he came up with the first answer that popped in his head. Maybe it was from the cold, it snapped. We have credible testimony today from Miss Hyman, and I find it more credible that this does involve another sibling. They understand that there's some risk to Ariana by giving this testimony today, but I think for the family, it's important that the truth comes out. It sounds like for Shonda Hyman, that truth was told to her. That was her testimony today, is that her sister admitted to messing with the tether. While Ariana didn't say that directly to Mr. Hartman, and he doesn't have firsthand knowledge of her admission, we did hear that there was a fight. She was angry that night. We don't understand the full details. It sounds like she requested Ozell to go to a store. He didn't. He crashed and fell asleep in her room. She was upset. She's a young person. I think we heard testimony, 22 years old. She made a mistake. That was the testimony we hear today. And of the two versions, this aligns better with Ozell's actions than him cutting the tether. So for that reason, Your Honor, we do ask the court to find that he's not responsible for this bond violation based on the testimony that we presented today and based on Ozell's actions and behavior before the violation and after.
Thank you. The court obviously wasn't there and can't end up being charged with a felony. I'm sure he wouldn't want that if he suspected that she didn't do it. And I agree with the defense that Mr. Hyman's actions more align with him just not knowing how he admitted cutting it to her is credible. Her demeanor appeared as if she was telling the truth about that. And as much as Mr. Hartman talks, I find it difficult that he could say so much and not get caught in some misstep along the way. He likes to talk a lot, apparently. So I'm gonna accept what they're saying as truth and find that Mr. Hyman did not try to, well, the prosecution hasn't proven that Mr. Hyman was the one who actually attempted to cut his tether under this particular scenario. And Mr. Hyman is very aware that I have a whole lot of concerns about this situation. I wouldn't be finding that unless I felt that it was the position that and the impression I was left with at this time. So I find that there was no bond violation with respect to the tether cut that could be proven.
Thank you.
So that leaves us with the complication that when Mr. Hyman was set to be interviewed on by the probation department, he decided that he didn't want to be interviewed and didn't speak with the probation agent and asked to have the remainder of his jail time served.
And Your Honor, if I can speak to that, Ozell and I had shortly before Agent Pappenhagen came to see him at the jail, him and I had a conversation, and I did advise him that I believed he was likely close to maxing out his time on the OWI if the court is willing to grant the time for that. My according to adding up his time that he previously served plus the full time, I believe as of today, he has 65 days credit on his operating while intoxication. So I had just advised him that from my standpoint, it made sense to probably ask for the time instead of going on probation. So when Agent Pappenhagen came to see him, I think Ozell was confused. He thought by signing that he was somehow signing up for probation. Ozell did try to call me several times from the jail, I think right as Agent Pappenhagen was there. Agent Pappenhagen reached out to me as well. Unfortunately, I did not see these calls. I think that was on a Friday. I would think I was in a meeting. I missed the calls. I did go see Ozell later that day, and understandably, Agent Pappenhagen did not have time to see him after that point. So I just wanted to let the court know that that's what happened with the sentencing. But I do believe that our request is the same. We would be asking for the court to sentence him to the 93 days jail for the
Well, there
operating.
are different pages about how much credit he's entitled to.
Okay.
It says in here 51 days.
51. Okay. Your Honor, I was counting from January 7th to the 17th, and then he served from February 11th to March 17th, and then the current 19 days that he served.
Okay, wait, can you slow down, please?
Yeah.
What is the January date? He wasn't arraigned on this until February 11th. So he can't get credit for time that he wasn't actually already arraigned on the case.
Okay, Your Honor, sorry. I apologize then. That was my mistake of not, that was when he was being held on the other matter. So I understand.
Does he want to do the 42 days still?
Your Honor, I would either ask to speak briefly with Ozell in a breakout room, or if the court would like, and he could complete his sentencing interview with probation. If the court would consider amending bond, he could do that out of probation, and then we could adjourn this to a later sentencing date after he's met with probation to see what he might prefer after meeting with Agent Pappenhagen.
Anything from prosecutor on what you'd like to see happen at this time?
Judge, I would like to see him placed on probation. He had a BAC of 225. He has an old OWI, so technically this is a second OWI for him. So I would like him to do the PSIR, see what their recommendation is. I think he needs some counseling and some help in that area.
Mr. Pappenhagen, would you be able to interview him between now and June 16th? He would be out of custody. I'm reinstating his bond on the other case.
Yes, Your Honor, I'll be able to interview him.
I'm gonna put them both. So do you know what you want to do on the pretrial today, Ms. Mueller?
Yes, Your Honor, we'd like to set that for final settlement conference.
The next final settlement conference is not until August, as you are aware, correct? Final settlement conference will be August 28th, 2025 at 9:30 a.m. Jury selection September 5th, 2025 at 8:30 a.m. I'm sorry.
August 28th date is our normal Thursday. It's a normal Thursday docket, which would mean that our final settlement would be an 11 a.m. start time, not 9:30, unless you want me to move it to the August 29th, Friday, August 29th. At 9:30.
I think so.
Just to be safe.
Yeah.
Well,
So I'm sorry. August 29th, 2025 at 9:30 and September 5th, 2025 at 8:30 a.m. for the jury selection. Bond is reinstated on that case. We'll come back for sentencing on the operating while intoxicated matter. On June 16th, 2025 at 10:00 a.m. I think he did you post a $100 bond on the OWI case at some point, Mr. Hyman?
Yes, ma'am.
All right. The bond of $100 is reinstated. We'll see you back here first on June 16th, and then after that, sir, we won't see you back until August, unless something happens, which you should probably make sure it doesn't happen again, okay?
Yes, Your Honor. Thank you.
Thank you.
Thank you, Your Honor. So I'll give you a call later today, okay?
Okay, excuse me, am I getting another tether or no?
Yes, it will be reinstated with the tether.
Okay.
Okay. All right.
Okay.
State of Michigan versus Kerry Jones, case number 23 FB 1544.
Tiffany Woods for the people.
Allison Muller here on behalf of Kerry Jones. Mr. Jones, can you go ahead and state, or sorry, Mr. Jones, can you state your name?
Kerry Jones.
Thank you. We're here for a review in this case. It looks like Mr. Jones is doing all that is asked of him at this time, except for oversleeping in the morning. All right. District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Please make sure your devices are muted until your case is called. Once your case is called, please unmute your device and state your name, but only do that after the attorneys have placed their appearances on the record. The court will call the case of the state of Michigan versus Christopher Fleming, 25S00001.
Tiffany Woods for the people.
Good morning, Your Honor. May it please the court, I'm Roderick K. Green, P33837, on behalf of the defendant, Mr. Christopher Fleming, who appears by Zoom, as well as myself.
Thank you. Mr. Fleming, please unmute and state your name.
Christopher Fleming.
Thank you. All right, we're here for an adjourned pretrial in this case.
Yes, Your Honor. We're prepared to enter a plea, Your Honor.
What is the plea, please?
The plea is well, may I go into counsel? I'm sorry. May I go into a meeting room with Ms. Woods for just a few moments, Your Honor?
No, we don't typically do that. Do we have a township thing that's ready for chance?
State. And one.
Okay, I'll do that. So you are aware, Mr. Green, we don't typically do that because it stops my entire docket. And if we did,
I understand. I understand.
But I'm gonna do it just this one time because of the serious nature of this particular offense. And then I will recall you guys in a few minutes.
All right, thank you very much, Your Honor. Thank you.
Ypsilanti Township versus Ryan Brown, case number 25T00151.
Paul Barnett.
You got cut off, Mr. Barnett.
Oh, Paul Barnett on behalf of the township.
Good morning, Your Honors. Good morning, Your Honor. Assistant Public Defender Davi Lebo on behalf of Mr. Brown. Mr. Brown, can you state your name, sir?
Thank you. You said what? Yes, please. Court will recall the matter of the state of Michigan versus Christopher Fleming, case number 25F00001.
Thank you very much, Your Honor. Again, for the record, I'm Roger K. Green, P33837, on behalf of the defendant who appears by Zoom.
Tiffany Woods for the people.
Yes, Your Honor, we're prepared to enter a plea of guilty to the charge, 1 count of moving violation causing death.
Thank you. Any other agreements between the parties?
No, Judge.
No.
All right, sir, it's my understanding you're going to be pleading guilty as charged to 1 count of a moving violation causing death. That is a misdemeanor, and it has a maximum penalty of up to 1 year in the Washtenaw County Jail and or a $2,000 fine plus court costs. Do you understand that, sir?
Yes, Your Honor.
And is that what you want? You can get an order signed by this court to require that those witnesses come to court. You have the right to hear, see, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself. Or, you could choose to remain silent. If you chose to remain silent, the prosecution couldn't comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
Do you understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
Yes, Your Honor.
Do you also understand that there's no automatic right to appeal this decision? So the decision that you're making today, in all likelihood, is going to stick with you.
Yes, Your Honor.
And if you were on probation, parole, or bond at the time that this happened, which was on June 6th of 2024, you could be in violation of that probation, parole, or bond. Do you understand that?
It was June 3rd, and yes, Your Honor.
It was June 3rd. That is correct. That is exactly what it says here, but I read it wrong. So you were not. And if you're not a U.S. citizen, you understand there could be immigration consequences, correct?
Yes, Your Honor.
All right. To the charge of moving violation causing death, how do you plead?
Guilty.
Anyone promise you anything other than what we put on the record today?
No, Your Honor.
Any threats that gets you to make you plead today?
No, Your Honor.
All right. So on June 3rd, 2024, were you at the vicinity of US 12 and Dorset Ave here in Ypsilanti Township, sir?
Yes, Your Honor.
And does Mr. Green, do you want to voir dire, or Ms. Woods, who would like to establish the factual basis? You guys are much more familiar with the facts.
I can do it, Your Honor.
Thank you. You may proceed.
Yes, sir. Mr. Fleming, at the time you were in the area on June 3rd of 2024, did you go past a red light?
Yes.
And did that moving violation cause the death of an individual?
Yes.
I'm satisfied, Your Honor.
Thank you. When you say you went past a red light, you meant you went through the red light without stopping, sir?
Yes, Your Honor.
All right, thank you. I'm satisfied that there's a factual basis for the plea and it's been knowingly and willingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Thank you. Sentencing in this matter on July 7th. Does that work with your calendars?
What?
One moment, Your Honor. Your Honor, is there any possibility that it could be heard on the 21st of July?
No, that's 45 days out.
I'm just asking. I understand if you can't.
Um, why do you need that far out, Mr. Gray?
Well, my client, I have some parenting time with his daughter, and he's asking the court to allow him to see his daughter. His daughter lives in North Carolina, so they've made some arrangements. And it's
Virginia.
my understanding that's his only time that he can see his daughter, because his daughter does not live with him.
Virginia.
I'm sorry, Virginia.
So when is the time that he can see his daughter? I'm sorry, what?
I pick her up on next Friday, and then her mom comes and get her July 20th.
Let's see.
And we will be asking for an initial jail term, Judge, so I understand why they're asking for a little bit longer sentencing time, or to allow for sentencing.
Well, even if I decide that I'm going to do jail time, it doesn't have to start at the time of sentencing. I can give additional time after that. So I would prefer that we do it on July 7th and figure it out afterwards. I'm not saying you're gonna go if I do choose to do that during that time period. Mr. Fleming, okay?
That's
yes.
fine, Your Honor. Thank you very much.
Take into consideration. July 7th, 2025 at 10 o'clock a.m. I prefer to have the report in and everybody have an opportunity to, any objection to them.
Judge, I would leave it up to the court's discretion.
I will allow him to go to medical appointments.
Thank you very much, Your Honor. Thank you.
He has to have proof that that's where he's going, obviously.
I understand.
And Judge, I anticipate that several people will want to speak at the sentencing, so I just wanted to give the court heads up that sentencing in this case may take a little bit longer than our normal sentencing.
Thank you for that. I'm gonna move it to 11 o'clock and not the 10 o'clock time then.
Thank you, Judge.
Right, so you're gonna need to contact the probation department. I'm gonna give you and everybody else on the call the phone number, so everyone should write down this phone number, please. Everyone should write down this phone number.
I'm ready, Your Honor.
734-483-7336.
Thank you.
Thank you. We'll see you back here on July the 7th, sir. Please contact the probation department tomorrow after 9 o'clock. They have to have a probation interview so that they can make their recommendation. You should call them tomorrow after 9 o'clock. If you miss that appointment, sir, it will not be in your best interest to do so.
Appointment tomorrow at 9 o'clock. Yes, ma'am.
To call them tomorrow. They'll schedule the appointment once you call them.
Oh, okay.
Okay. Thank you.
Thank you, Your Honor.
You're welcome.
Take care.
You too. We'll call the case of the state of Michigan versus Corey Mitchell Lucas, case number 25S00175.
Tiffany Woods for the people.
Hi, Roberto, on behalf of Mr. Mitchell Lucas. Corey, please state your name for the record.
Every day in the USA, people find themselves in court.
There, I think we're all set. Alrighty.
Good afternoon. Are you Reuben Haywood
Sure.
and Eva Haywood?
Yes.
All right, Mr. Haywood, could I ask you to remove your hat?
Yes, sir. I'm sorry.
All right. I've got you in the Zoom room rather than in the courtroom in case we need a consultation or anything with legal aid who should be joining us here shortly. This is Judge Middleton. I'm just down the hall here in the courtroom. With us is the esteemed Ryan Buckland, who is representing Sturgis Housing Commission. And he's here on this matter, which is a termination of tenancy action. In such an action, you have certain rights. As a defendant in a landlord-tenant proceeding, you have certain legal rights, including the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And normally a legal aid attorney will join in with us here by Zoom, hopefully in a few minutes. They're not available every day, but I think they're going to be here today. You have a right to have the case heard here in St. Joseph County where the property is located. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at this first court appearance and be prepared to pay the $50 jury demand fee, or file the jury demand in writing. Use the Michigan Court Form 22 jury demand form. And again, be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. You may be able to reach an agreement with the landlord by going through mediation. That has never happened yet, but someday maybe it will. If both parties are interested, the court will assist with that referral. And you may be able to reach an agreement with the landlord that means the case would be dismissed, in which case there would be the filing of a conditional order of dismissal. Let me make some notes here. Was here on Friday. The defendant was not. And a default judgment entered in that case.
Okay. I kind of suspected that that may have been the case.
Oh, nobody came. We made a record.
Thank you for updating me. I hadn't heard anything since we were last there, so.
Nikki Behringer may be your manager.
She is.
All right, then let's go ahead. This is entitled Sturgis Housing Commission versus Reuben Haywood and Ava Haywood. This is a tenancy at Nottawa Street, apartment 213. The plaintiffs are asking to terminate your tenancy. They want you to move for what they entitle multiple lease violations. And because of those, they want you to vacate. What's your position?
I didn't know I had any violations besides the ones I first started off in that place. I only got certain ones. They never came.
Just a moment, sir.
And they never
Wait. Thank you. I'm sorry, go ahead.
But they never came and told me any of my violations. I didn't know anything like this was going on. I tried to talk to them. They don't even fucking, that's sorry for my language. They won't let me talk to them. They close the door. They won't answer the door. So I
don't know if it's the sound system in there. I'm having a very difficult time understanding you. They allege a number of things. As of February 12th, lease violations. On February 11th, Gecko Security entered your apartment to install new smoke alarms. As they entered your apartment, they were hit by the smell of marijuana smoke. Smoking is not permitted anywhere in the building, including apartments. All employees, residents, stop. I'm just reading you what it says. And marijuana is prohibited anywhere in Maple Tower since they're a governmental facility. Failure to follow smoke-free policy will be a violation of your lease. Notice of lease violation, October 24. That was a non-payment of rent. Moment of lease violation. Drilling screws into your door. Notice of lease violation. Pest control came to your apartment last September and found bed bugs.
I found that place.
Lease violation. Continue ignored notice of delinquency of rent. Mr. Buckland or Miss Berenger, is there a rent deficiency now also?
Nikki, can you comment on that?
Yes, there is a delinquency from rent because we can accept rent when they're in the eviction process.
Yeah, so once you start the eviction process, you can't accept rent. So beyond that, they aren't delinquent?
Right, they got all paid up.
What is their monthly rent?
One moment.
I guess I just look at the leaves.
$386.
All right, Mr. Berenger, Miss Haywood, Mr. Haywood. You have a right to have a hearing on this, but at any rate, you have the right to have the matter adjourned for at least 7 days. Now, they allege multiple lease violations. Apparently, your rent is current, so that's not an issue, but they're alleging smoking marijuana and smoking in the premises, bed bugs, some other damage, and they wish you to move. If they get what they ask for, you'd have to move 10 days from the date of the next hearing. I won't be here. Well, let's see here. Today, I won't be here next Monday. I will be here on Friday the 13th at 10:15. Mr. Buckland, will you be available at that time?
You said the 13th at 10:15.
Yes.
Let me just get my calendar over here. It's possible I could be out of the office, Judge, but if that day works, I could probably get somebody to cover it for me if need be.
I could do it earlier, like at 8:45, if that would help.
Well, see, I'm helping coach the varsity softball team here in Coldwater, so it really just depends on how well they do. They won their district, so if they keep winning, I could be
Let's
gone.
let's hope you're busy on that day, but well, we can go till the following Monday if that would not be a problem. We could go to the 16th. That's 14 days from now, but does that work?
What time would that be on that day?
It would be in the afternoon. Let's say 2:15 on Monday, the 16th.
Yeah, that would work.
Now, Mr. and Mrs. Holloway or Haywood, if they get what they ask for, you would get 10 days from June 16th to move, or you would be subject to being evicted. Legal aid did not join us today. I gave you their number on the paperwork I sent you with the summons and complaint. I would suggest that you talk to them regarding this. Say that again?
We tried, but they wouldn't answer.
They wouldn't what?
They wouldn't answer our call. We called them twice. And
all right, well, continue to call. They're very much in demand. So this is a federally subsidized apartment. and your rent is subsidized. You're not gonna find any rent for $386. And as such, they have stricter rules to terminate a tenancy than a regular landlord-tenant relationship. But they're showing multiple lease violations going back to last fall up to as recently as February. And there may be some other things that I'm not seeing. But they want you to move and you don't wish to move. There are a couple problems. There isn't anywhere to move to.
Yeah.
And you're certainly not gonna find anything to rent for $386 a month. Which is why people need to treat their tenancy like a treasure rather than a trash. At any rate, we will address this further on June 16th at 2:15. And if they get what they asked for at that time, you'd have 10 days to move. We may have to set it for a hearing, we'll see. But I would suggest that you contact legal aid, continue to try to talk with them. I hadn't heard that Meg Bauer wasn't gonna be here today, but their services are very much in demand. All right, I will see you in 2 weeks from today at 2:15. And you're welcome to come right back here to the courthouse or come in by Zoom. Do you have any questions? All right, you're good to go. Thank you. All right, next we've got Mr. Wardell. Mr. Buckland, thank you. We'll see where we go with that.
Thank you, Judge.
The next matter is Terry and Larry Richmond versus Walter Wardell and Latia Deer. Mr. Wardell is here as HMD Global. Let me give him a name. And Terry Richmond is here.
Good afternoon, sir.
Mr. Davidson, we're ready for your case. I've got several other people here.
If you have
Tiffany
somebody
Paul-
named Amit, AMIT, Beraji, he's part of this situation.
Yes, I have
Owner there.
Ali and I have Tiffany Palmer. I think Tiffany Palmer is in one of my 145 cases. Good afternoon, Miss Palmer. Which case are you here on?
That's correct, Your Honor. Good afternoon. I am here on your 145 case with defendant Bradley Roberts. I represent the plaintiff.
All right, we'll get to that in a minute. You can lurk in the background and watch you're in a beautiful boardroom there, I see. There's no board members in it, but.
I wish that it was a real courtroom.
All right, I'll be with you in a minute.
Thank you, Your Honor.
Who is Ali who's in the?
I had a 120 for today. I'm not exactly sure.
What's your last name?
Smith?
Let me look here. Well, who's your landlord?
I go through Place Property. One second, I'm so sorry.
I don't have a case that matches you. Let me look here.
Houston Moyer.
ALLIE Smith.
Oh, it's ALISSA. Sorry.
There was a case filed by Place Management LLC, and they filed a dismissal last week. And you either paid the rent or moved. It's filed 25946.
Okay, thank you.
That sound
I
right?
wasn't. Yeah, I ended up paying up. I didn't realize that they had dismissed it though.
We got a dismissal, I think, last Thursday, and the case got removed from my docket. But thank you for checking in. Stay in contact with your manager.
Okay, thank you. Bye.
I'll remove you. All right, the next matter is set for 1:30. It's 1:34. I don't expect the defendant is going to appear. This is Probir Baraji versus Arpana Gayan Kalu. Attorney Matthew Davidson is here with the plaintiff. I was familiar with this house and this defendant. And Mr. Davidson had a little more background. We believe she's living somewhere in Kalamazoo. Mr. Davidson indicated that she had vacated and perhaps left a boyfriend or somebody behind. The plaintiff is her uncle, and they wish to terminate this tenancy. Is that correct, Mr. Davidson? Your mic's on mute.
Yeah, just for the record, the purchaser was Amit Baraji, who is Probir's son, but Probir manages it for him in Three Rivers. Because we're all here in the sun. Where's your son?
New York.
New York, but he was going to try to zoom in today. So it's AMIT Baraji is his name. Just in case you cared, if you don't. He's
Well,
involved,
I
is
should
my
care
point.
because the
He's involved.
case is in the manager's name rather than the owner's name. But she's gone. Is there any property in the house?
No,
No.
we'll go ahead, speak just a moment, please.
Some pictures and other thing that which I'm anyway keeping it. Their parents' pictures
Okay.
and her pictures.
All right, I find by default, the plaintiff is subject to termination of tenancy, Arpana Gayan Kalu, and all occupants. 10 days from today is the day, and that would be June 12th. It's also the date for the appeal. No money damages are issued at this time. Mr. Davidson, you're kind of fading in and out. As I indicated, I'm familiar with this defendant. She lived there with her mother and her father, and their mother died, and then her father died. There was some estate issues in India, and frankly, I'm not sure exactly how it all played out. But apparently the house was purchased at a tax sale or something. Mr. Davidson, are you still with me? Barely. Anyway, I've signed the default judgment.
Can you hear me, Your Honor?
Yes.
Yeah, I don't know what happened to my camera. I apologize.
Well, I've signed your
Plug-in camera
default
just
judgment.
stopped.
10 days from today, June 12th. And they are related, and I think he'll try to do the best he can by her. But she's vacated the premises and there's a new owner. All right, I've signed your order and you're good to go.
Thank you very much, Your Honor. Sorry about the camera.
Thank you, sir. Thank you.
Well, I can certainly identify with technical problems. I'm still having my share. All right, our next landlord tenant case is 215. We have a couple of general civil matters starting at 145, and those are always problematic. have to shift gears from landlord tenant to general civil, and there's usually more in there that fits. But let's see what we've got. Mr. Glomsky, could you remove your hat, please? Mr. Glomsky, can you hear me?
Yeah, yes.
Take your hat off.
That worked.
All right, we're in a court proceeding. And Ms. Palmer, I don't have any defendant for you yet. And we'll wait for Mr. Conley, who's the attorney in the other two cases. They're not late yet.
Yes, we're a bit early.
I appreciate early. If that both parties are here early, I start early. I was talking with an attorney this morning from the Detroit metro area, and attorneys like you have to be in a lot of places all over the state.
Yeah.
I tried to start at the time I state. So if it says 1:45, I try to start at 1:45.
Yes, you do.
So the attorneys can plan accordingly. I don't stack people 20 cases deep. We're a little wrinkly here at 1:45, but it makes it easier for you to plan your calendar because you're probably have several other judges waiting for you now.
Yeah, well, not until 2:30, so I'm actually free until 2:30.
Well, hopefully we'll be done by then, but it's because you're so popular that you're demanded all over the state.
Right. That's one way we can look at it.
I guess so. All right, Mr. Glomsky's case, we have two Three Rivers Health cases. So what I will try to do, Ms. Palmer, depending on who shows up first, is try to resolve yours before the Three Rivers cases. Then I have another landlord tenant at 2:15, and then I have a bunch of humdinger small claims cases.
Okay, thank you, Ron.
Three more minutes. Hopefully someone will show up for one of these, either plaintiff or defendant. I also have a criminal case I have to fit in here. Hopefully I can do that before the 3 o'clock landlord tenant matters.
You have a really busy docket then.
Oh, it makes things go faster, I guess.
Yeah. Funny, this weekend I was actually watching, I think it was 2020. It was a documentary on a case from when you were a prosecutor. And so now I'm in front of you today.
Yes, I was much younger then, but I do have a long memory. I worked on that case my entire prosecutor career and didn't forget it after I came here either. It was gratifying that they finally were able to solve it.
Yes, yeah.
How did I look?
You look great then and now. I told my husband, I'm like, I know him.
What happened to then? So, all right, let's pick Mr. Conley and we'll address Mr. Glomsky's case while we wait a minute.
Okay, thank you.
Good afternoon, Mr. Conley.
Good afternoon, Judge.
We got two cases with you this afternoon, and we got Tiffany Palmer waiting for hers, but your defendant is here, so we'll jump right to it. This is Three Rivers Health versus Jared Glomsky. File number is 21894 GC. Mr. Glomsky filed a letter dated April 21st. I'll just read it. It got date stamped April 21st. It's signed March 31st. I, Jared Glomsky, am objecting to this garnishment of withholding my state of Michigan taxes in the amount of $964. This attorney withheld my 2022 taxes and got $1,200 illegally. He has never sent me a letter, nor have I received a court summons to appear in court pertaining to this debt. Robert Conley, PLLC, Portage, Michigan. An attorney cannot directly garnish your tax refund for a hospital bill without a court judgment and a subsequent writ of garnishment, unless the debt is owed to a government agency. He has never sued me in court to obtain a judgment stating I owe them money. So I'm filing an objection. Thank you, Jared Glomsky. Mr. Glomsky, does that pretty much sum up your position?
Yes.
All right, you claim that they garnished your earlier taxes illegally. Well, this garnishment was in 2022. Our file shows that you entered into a voluntary consent judgment on September 2nd of 2021.
Yes, Your Honor. And on that consent judgment, they also had a payment plan of $50 a month starting October 19th of 21. They made 5 payments and then stopped. And then I filed a wage yarn. I didn't get anywhere with that. I filed tax garns pursuant to law, and I really don't know where this is coming from.
Yeah, Mr. Glomsky, what's your position?
I've never got any paperwork stating for this court case of that 2021. I was not aware of this. I aware that I had the payment, but it should have been covered through workman's comp, and they're saying it's not. But I don't understand how it's not if they made me do the drug test and everything for workman's comp. And then Metal Technologies, even if so, they never submitted my claim to my insurance at that time either. And quote unquote, they said they didn't get it in a timely manner.
Well, it was personally served on you at the Citgo gas station on June 14th of 2021. After looking for you at some other places, Sergeant Morse was able to serve you. So you knew about the hearing. You filed an answer, as I indicated. So you obviously knew about the lawsuit because you filed an answer. Then we had consent judgment entered on 9/2 of 21 and a payment plan of $50 per month.
Yes, my mom agreed to that with him for the 510 claim, but then she said she was going to pay no more until they figured out why Metal Technologies wasn't either answering phone calls or just giving the ring around saying, oh, someone's on vacation, this person's on vacation.
Well, unfortunately, Mr. Glomsky, your challenge is without merit. There was a judgment in effect at the time. You had a payment plan. Your statement that you didn't know anything about it is just not correct. You were personally served with it. You filed an answer. So you obviously knew about it. Then we had a hearing and a judgment entered, and you were going to pay $50 a month, and you stopped paying. So, Mr., with the 2 garnishments and the $250 payment, what's the current balance?
The current balance, Your Honor, is $1,332.31.
$1,332.31.
As of today, yes. I have received the 964 from the tax garnishment, and that has been dispersed to my client. So that's after the 964 we received from the tax garnishment.
I find the objections to the garnishment are not valid. The judgment was in place. The defendant defaulted on the repayment agreement, and the garnishee shall release all garnished funds to the plaintiff's attorney. You got it greatly reduced through these garnishments. Several thousand have been paid back, but you still owe about $1,300, and they're going to garnish your taxes again this year unless you can contact them and set up some sort of payment plan. As I indicated, there was a judgment in effect, and it just is what it is. Here's my notes.
Even regardless, it should have been under workman's comp and in my insurance.
That ship sailed 4 years ago when you signed a consent judgment in the amount given. You would have had 21 days to move to set that aside, and you did not. Are you still at the Kleins Resort Road address?
Nope. Nope.
Let's see what we have for your address. 9th Street, Kalamazoo?
Yes.
All right. All right, I'm sorry, sir, but under the law, they were entitled to garnish your tax refund. What I would suggest is you try to get a payment to get the rest of this paid off and get this debt out from around your neck, but you're free to go.
Okay.
Thank you, Judge.
All right, now we've got a phone number here. We had a phone number here that's not here anymore. Your other matter, Mr. Glomsky, is TR Health versus Lisa Rundman. And I believe you supplied a certified judgment. And so that matter has been certified. I think that's going to be dismissed. I held on to it just in case. Is that your understanding?
Yeah, I did file a satisfaction of judgment and the tax garnishment release that has been sent to the state. I haven't received a disclosure or the money, so hopefully the state will refund it back to her. But most of the time, they still send it to me anyhow.
All right, well, it's en route. If you get the tax refund, you can redeem it to her.
Correct. That's what I told her.
All right, thank you.
Thank you. Have a good day.
All right, thanks. I'll see you again next time, probably soon. All right. I saw someone flash past our screen here, but I don't see them now. So let's take up Liberty Mutual versus Bradley Roberts. Make sure he's not outside here. Hi, looking for a Bradley Roberts. All right, thanks. Okay. Yeah, she tested positive for cocaine, methamphetamine, marijuana, and opioids. Yes, that's correct. Where is she? She's there. Yeah. So, oh, is she really? Yeah. Autumn brought me that note about a half hour ago. All right, thank you. All right, okay, bye. All right, that's an update from this morning's case. The young woman was positive for everything that I was afraid of.
Oh, wow.
All right, so I've got iPhone 8 and I've got somebody who's a telephone only. Who is iPhone 8?
That would be me, Your Honor. I think I'm a little bit early for my case.
What's your name?
Deanna Patterson.
In which case are you here on?
Tyler Grimes.
Okay, yeah, that's the right case. It's coming up here at 2:15, but you're in the right spot. So,
Sorry, I'm early.
well, it's okay to be early. Let me put you in the waiting room.
Okay, thank you.
All right, now I've got a telephone, but I don't know who that is.
That would be Bradley Roberts, Your Honor.
All right, Mr. Roberts, you're late for your own hearing, but you are here.
I have tried to get my stuff downloaded and had kids helping, and nothing is working. So thank God for the phone number because I don't have a ride.
All right, well, this is a court appearance and it affects a lot of money. And people really should take things more seriously than they do. But let's talk about this case. Attorney Tiffany Palmer is here on behalf of the plaintiff.
Good morning, good afternoon, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
And Mr. Bradley Roberts is here by telephone only.
Yes, sir.
All right, this is a claim by Liberty Mutual Personal Insurance Company versus Bradley Roberts. And this has had a bumpy ride. We've had a couple of previous hearings on this. We had a hearing on March. Let me go back even all the way to the beginning. We had a hearing on December 16th. Mr. Roberts appeared. He admitted there was no insurance on the vehicle at the time, and it was screwy facts. The vehicle was allegedly owned by Cindy Vandegrift. It was insured as Jessica Adams, and the driven vehicle was driven by her son or nephew, Xavier Adams. Anyway, there was an accident, and no police report was filed, and so all these facts were raised, and so they continued the matter for 90 days for additional discovery. Mr. Roberts didn't show up. We discontinued the matter to March 31st, 2025, and Mr. Thomas Duquette was here. So we adjourned the matter for 90 days for discovery, and the defendant never complied with any of the discovery. So he didn't answer any of the plaintiff's requests for discovery, and he didn't show up for the court hearing. So Mr. Duquette moved for a default judgment, $10,415 in costs. In damages, $232.13 in costs, and a $75 attorney fee. So a judgment entered by default on March 31st.
Which should have never happened. You heard me say she jumped in it and started it and put it in reverse. She took control of the vehicle. It was hers, not mine. She's using mine to go to work right now, or I'd have a ride there.
Okay. Well, you didn't show up for the hearing. That's not her fault.
And I paid someone that day. I paid someone that day, and they didn't make it to come and get me, and I walked home from work to make sure I got on the Zoom. I'm sorry, but this is making me mad. I shouldn't even be here.
Well, that's open for discussion. You think you shouldn't be here. They have a different idea about
exactly.
Well,
when someone jumps in a vehicle, they assume responsibility.
Do you have a legal citation for that? Or is this something you read on the back of a cereal box? You're under the no fault statute, and it's complicated, and you're in over your head. So you don't show up for your hearing. You don't answer any of their requests for discovery. They sent you information. Everything you've told me, none of it's under oath. This happened, it belonged to somebody, somebody told me they backed into the car. None of it's under oath. It's just what you claim to be true. So they send you a number of documents for discovery, and you don't answer.
I don't know
any.
what that means.
Well,
I don't know how to do all that. I'm not a good lawyer. I don't have any help. I couldn't hire an attorney because no one would take the case.
yes, it's a tough
I'm tired of
situation.
getting ragged on when I'm trying.
All right, well, all right. You may be trying as hard as you could. Maybe you could spend $50,000 for a lawyer and the no fault statute still applies. So anyway, you don't respond to the discovery. Everything you're telling me, this isn't how the legal system works. You show up and say, hey, judge, this is all a big mistake. Sorry, here's what really happened. Please dismiss it so I can go home.
They're doing.
Well, they filed legal pleadings.
That should have never happened.
They're prepared to provide testimony regarding the matter. In fact, we took some testimony, or at least some legal representation, on March 31st. So anyway, you don't show up on March 31st. The judgment enters a few days later, and you file a motion to set aside the default on April 14th. Which it was in 21 days of the default setting aside. So when you move to set a default aside, there's a certain standard you have to meet. You're supposed to file something called an affidavit of meritorious defense, and you're supposed to show good cause for why you did not appear for the hearing. So in your motion, which you filed on April 14th, I'll just read it. On March 31st, a person who lives with me borrowed my vehicle to look for a job. I totally forgot. Although I called the court around 8:05 and left a voice message as I was going to be late because of no ride. So I walked a couple miles, got a ride. Then when I was home and on Zoom, for some reason, my tablet would not work, the microphone, no matter what I did. I have a meritorious defense for this claim. I, Bradley Roberts, and Keith Ryan, seen Cindy Vandergriff, also who own a 2005 GMC Envoy. Cindy got in the vehicle and started it and then reversed it, which in turn slammed into the plaintiff's parked vehicle, knowing the vehicle had no insurance. Therefore, knowingly take possession of said vehicle, the plaintiff then left the scene. No police were called. And somewhere, someone later gave the plaintiff an old insurance card, which had my information on it.
Correct.
Which is different than what you told me at the hearing back in December of 24. So I'm not sure that establishes an affidavit of meritorious defense or a legitimate reason for not coming. I don't have any notes in the file that you called. I don't say that you didn't. The hearing was at 8:30. At any rate, I called the hall and checked around and you weren't here. So having laid the premises out, Ms. Palmer, what's your position here?
Our position is that the defendant has not met the statutory burden in order to set the judgment aside. As the court has indicated, the information he provided as to his failure to appear for a court-ordered hearing, it doesn't rise to the level of good cause. But obviously the court is the gatekeeper of that. But our position is that it does not rise to that level. And then the meritorious defense that was advanced, it is not necessarily consistent with what was originally indicated. And this could have been helped if the defendant had answered the discovery. So right now we're not exactly sure what the defense is. And although I know the courts are somewhat liberal as it relates to advancing a meritorious defense, this is an affidavit. So I couldn't even necessarily use this statement if the court was inclined to set aside the default judgment to impeach him or to have him basically attest to these facts. So he could theoretically change his version after this point too. So we believe that he has not met the statutory requirement to set aside default judgment at the bare minimum.
Let me see if I understand. Mr. Roberts, are you contending that this is a completely different vehicle?
No. No, it's the same vehicle. I gave them her phone number. All they got to do is call her and talk to her. I thought my stuff would be taken care of and thrown out because I shouldn't be here. She said, here's my information, and she lives with me still. You know, it's simple. Contact her and not me. I didn't do it. And they haven't contacted her at all.
All right, but one thing that you, from the beginning, failed to accept is that you're the insurance holder on the vehicle.
Yep, I was. That's what started all this, because someone got my information.
Yes.
So, Your Honor, and I'm not sure if this is the right way to do this, but I was confused in what his defense was here. I thought he was saying it was a vehicle that looked exactly the same as his vehicle that was completely separate. So he's saying that someone got into his vehicle and then drove the vehicle. Is that what this defense is here?
Yes, she got into her 2005 Envoy and yes, drove the vehicle.
That you were the insurance holder on.
Well, used to be at that moment though, and she knew there was no insurance on it because it had lapsed. I wasn't driving it. It was parked.
Your Honor, based on the defendant's statement, and I understand he's not under oath. And I misstated maybe in how I responded to the meritorious defense. But if he was the title owner, registrant, or constructive owner of the vehicle, he's still legally responsible for whoever's driving the vehicle if they had permissive use.
Yes, he doesn't understand. But his argument is.
But then when she jumped in it, yeah.
She drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandigrift is the owner. I borrowed it because she wasn't driving it. So I insured it. Then I quit driving it and it was parked. Cindy Vandigrift's still the owner. And then Cindy Vandigrift day,
all we know about that is what you're saying here, and you're not under oath. You never filed.
Right. And I'm saying call her and she'll tell you all.
That isn't how it works. They sued
Well, it should have been because I shouldn't be here getting upset. And you shouldn't have to deal with me.
Well, I wish it were true.
Yeah, I know. Okay.
All right.
I'm sorry.
So they send you a bunch of documents to ask you these questions. Who's the car registered to? Show me the title. Who is your insurance carrier? When was it insured? You didn't answer.
How would I
any
have the title if I don't own it? So I have no idea to fill this stuff out. No idea how to do it.
So all you have to do is show up and say, hey, I don't own this. I don't have any proof that I don't own it, but they're showing that you're the insurance.
I did that the first. wouldn't that be the first meeting we had when I left them her phone number and contact info? It would have been taken care of. If they would have followed through and said, okay, you're not the owner, I'm going to call this number, they would have found out who the owner was legally.
All right.
I
Anything
can get
further?
on
Ms. Paul?
Michigan website and do that.
Your Honor, just in response to defendant's last argument, obviously it's not appropriate to somehow switch the burden to the plaintiff by saying that we were supposed to call and then I guess somehow add her to the lawsuit. We don't have anything definitive to even be able to sue Cindy upon. Maybe if he answered discovery, maybe if he had sworn statements, any of those things. But he just has his versions that he is,
I see what
advancing
you're
that
saying,
we cannot rely
but I
upon.
didn't understand.
That we cannot rely upon. So that's why it was critical, and that's why the court opened discovery and allowed us to have discovery for him to answer discovery. That's why it was important. And if he didn't know the answer to a question, could say he didn't know. It's plenty of questions on here. I think 12 interrogatories, 5 requests for admissions, and a request for productions, I believe. So it's quite a few questions on here. First one being his name.
And I didn't understand how to.
Mr. Roberts, you point out a good and valid point. People get involved in a general civil lawsuit. They don't understand the rules. It's complicated. You're not in small claims court, you're in general civil court. And every day this week, including tomorrow, I have multiple people who are driving around with no insurance. And last week on Thursday, I had 7. Probably had 10 last week. I probably have 10 this week. And you point out what happens when you're driving around without insurance. You get into the weeds when you get sued by the other party's insurance company for an accident. And you're in the weeds, all right. You barely filed an answer. You didn't show up for the hearing. You didn't answer any of the interrogatories. And you haven't shown an affidavit of meritorious defense. And I'm not sure we have good cause for why you weren't here. So your motion to set aside the default is denied. Good cause and meritorious defense were not established. Now, you can sue her if you think she's more liable. She doesn't have any money either, and I doubt they're going to get any money out of you. But
when she jumped in it and started it, isn't that taking for the known possession of the vehicle back?
No, it's not.
It's not her turn. Okay.
No, it's not. All right, I'm going to send you an order denying your motion. And if you want to appeal that further, I guess you're welcome to do that. But for the reason stated, you are liable for the amount here. You can't even get to court. You have to call by telephone. And
yeah,
so,
this is why our country works great. Because Cindy's using my car. I said that.
Sorry about Cindy using his car, but that isn't going to go very well forward. But for all the reasons I stated, he didn't show up for the hearing. He didn't answer the interrogatories. He didn't show necessarily good cause for why he wasn't here. He didn't file an affidavit of meritorious defense. He filed he said 2 different things about what actually happened, none of which was under oath. And he just doesn't understand, and he'll be mad no matter what I try to say. So this is another case of it is what it is, and another abject lesson for don't drive around without any insurance on your car. And don't have somebody own it, somebody else insure it, somebody else, just nephew or son drive it. When the wheels fall off, it can be very expensive. All right, Ms. Palmer, maybe we'll hear more about that, or maybe we won't, but I've denied his motion and I've signed the order to that effect.
Thank you, Your Honor.
All right, thank you.
You have a great evening. Afternoon.
All right, it'll get better after this. I said I got 4 clunky small claims on a criminal case, so I probably got more people that won't like my rulings, but we'll just.
Well, have fun, Your Honor.
All right, thank you.
Thank you.
All right.
Thank you.
Well, no one's here yet. Ms. Patterson is here and no one else yet. So I'll put you back in the waiting room.
Sure.
I expect they'll be here any minute. And those are always problematic. I have to shift gears from landlord tenant to general civil, and there's usually more in there that fits. But let's see what we've got. Mr. Glomsky, could you remove your hat, please? Mr. Glomsky, can you hear me?
Yeah, yes.
Take your hat off.
Not working.
All right, we're in a court proceeding. And Ms. Palmer, I don't have any defendant for you yet. And we'll wait for Mr. Conley, who's the attorney in the other 2 cases. They're not late yet.
Yes, we're a bit early.
I appreciate early. If that both parties are here early all over the state.
Right. That's one way we can look at it.
I guess so. All right, Mr. Glomsky's case, we have 2 Three Rivers Health cases. So what I will try to do, Ms. Palmer, depending on who shows up first, is try to resolve yours before the Three Rivers cases. Then I have another landlord tenant at 2:15, and then I have a bunch of humdinger small claims cases.
Okay, thank you, Your Honor.
What happened to then? So, all right, let's pick Mr. Conley and we'll address Mr. Glomsky's case while we wait a minute.
Okay, thank you.
Good afternoon, Mr. Conley.
Good afternoon, Judge.
We got 2 cases with you this afternoon, and we got Tiffany Palmer waiting for hers, but your defendant is here, so we'll jump right to it. This is Three Rivers Health versus Jared Glomsky. File number is 21894 GC. Mr. Glomsky filed a letter dated April 21st. I'll just read it. It got date stamped April 21st. It's signed March 31st. I, Jared Glomsky, am objecting to this garnishment of withholding my state of Michigan taxes in the amount of $964. This attorney withheld my 2022 taxes and got $1,200 illegally. He has never sent me a letter, nor have I received a court summons to appear in court pertaining to this debt. Robert Conley, PLLC, Portage, Michigan. An attorney cannot directly garnish your tax refund for a hospital bill without a court judgment and a subsequent writ of garnishment, unless the debt is owed to a government agency. He has never sued me in court to obtain a judgment stating I owe them money. So I'm filing an objection. Thank you, Jared Glomsky. Mr. Glomsky, does that pretty much sum up your position?
Yes.
All right, you claim that they garnished your earlier taxes illegally. Well, this garnishment was in 2022. Our file shows that you entered into a voluntary consent judgment on September 2nd of 2021. In this file number 21894 GC, I entered a consent order in the amount of $3,800 $18.57 plus costs for a total amount of $3,224.73. Signed, I think we did it on a record. I can't tell from what I'm looking at, by consent. So we had a hearing and we had a judgment entered a year before he did garnish your 2022 taxes. Mr. Conley, is that your position?
Yes, Your Honor. And on that consent judgment, they also had a payment plan of $50 a month starting October 19th of 21. They made 5 payments and then stopped. And then I filed a wage yarn. I didn't get anywhere with that. I filed tax garns pursuant to law, and I really don't know where this is coming from.
Yeah, Mr. Glomsky, what's your position?
I've never got any paperwork stating for this court case of that 2021. I was not aware of this. I aware that I had the payment, but it should have been covered through workman's comp, and they're saying it's not. But I don't understand how it's not if they made me do the drug test and everything for workman's comp. And then Metal Technologies, even if so, they never submitted my claim to my insurance at that time either. And quote unquote, they said they didn't get it in a timely manner.
Well, it was personally served on you at the Citgo gas station on June 14th of 2021. After looking for you at some other places, Sergeant Morse was able to serve you. So you knew about the hearing. You filed an answer, as I indicated. So you obviously knew about the lawsuit because you filed an answer. Then we had a consent judgment entered on 9/2 of 21. And a payment plan of $50 per month.
Yes,
So
my mom agreed to that with him for the 510 claim, but then she said she was going to pay no more until they figured out why Metal Technologies wasn't either answering phone calls or just giving the ring around saying, oh, someone's on vacation, this person's on vacation.
Well, unfortunately, Mr. Glowski, your challenge is without merit. There was a judgment in effect at the time. You had a payment plan. Your statement that you didn't know anything about it is just not correct. You were personally served with it. You filed an answer. So you obviously knew about it. Then we had a hearing and a judgment entered, and you were going to pay $50 a month, and you stopped paying. So, Mr., with the 2 garnishments and the $250 payment, what's the current balance?
The current balance, John, is $1,332.31.
$1,332.31.
As of today, yes. I have received the 964 from the tax garnishment, and that has been dispersed to my client. So that's after the 964 we received from the tax garnishment.
I find the objections to the garnishment are not valid. The judgment was in place. The defendant defaulted on the repayment agreement, and the garnishee shall release all garnished funds to the plaintiff's attorney. You got it greatly reduced through these garnishments. Several thousand have been paid back, but you still owe about $1,300, and they're going to garnish your taxes again this year unless you can contact them and set up some sort of a payment plan. As I indicated, there was a judgment in effect, And it just is what it is. Here's my notes.
Even regardless, it should have been under workman's comp into my insurance.
That ship sailed 4 years ago when you signed a consent judgment in the amount given. You would have had 21 days to move to set that aside, and you did not. Are you still at the Kleins Resort Road address?
Nope. Nope.
Let's see what we have for your address. 9th Street, Kalamazoo?
Yes.
All right. All right, I'm sorry, sir, but under the law, they were entitled to garnish your tax refund. What I would suggest is you try to get a payment to get the rest of this paid off and get this debt out from around your neck, but you're free to go.
Okay.
Thank you, Judge.
All right, now, we've got a phone number here. We had a phone number here that's not here anymore. Your other matter, Mr. Glomsky, is TR Health versus Lisa Rundman. And I believe you supplied a certified judgment. And so that matter has been certified. I think that's going to be dismissed. I held on to it just by. All right, that's an update from this morning's case. The young woman was positive for everything that I was afraid of.
Oh, wow.
All right, so I've got iPhone 8 and I've got somebody who's a telephone only. Who is iPhone 8?
That would be me, Your Honor. I think I'm a little bit early for my case.
What's your name?
Deanna Patterson.
And which case are you here on?
Tyler Grimes.
Okay, yeah, that's the right case. It's coming up here at 2:15, but you're in the right spot. So,
Sorry, I'm early.
well, it's okay to be early. Let me put you in the waiting room.
Okay, thank you.
All right, now I've got a telephone, but I don't know who that is.
That would be Bradley Roberts, Your Honor.
All right, Mr. Roberts, you're late for your own hearing, but you are here.
I have tried to get my stuff downloaded and had kids helping and nothing is working. So thank God for the phone number because I don't have a ride.
It'll get better after this. I said I got 4 clunky small claims on a criminal case, so I probably got more people that won't like my rulings, but we'll just keep.
Well, have fun, Your Honor.
Thank you.
Thank you.
All right.
Thank you.
Well, no one's here yet. Ms. Patterson is here and no one else yet. So I'll put you back in the waiting room.
Sure.
I expect they'll be here any minute. I'm surprised Mr. Rognus isn't here. He's usually all over it. Well, no one's in the conference room. Michelle, you have any idea what's up with Tyler Grimm versus unoccupied occupants, or Elaine?
Elaine's not here. I'm not sure what's going on. Kim said she thought you put one of the sisters in
What?
a breakout.
I don't have anybody in there right now. I have people, I have the sister here, but
Yes.
Andy's not here, and that's very unusual.
Did you want me to call him?
I'll call him here. Let me see
No,
what.
I don't know what time it's judge.
All right, thanks. Well, I think there it is. Hi, Andy. This is Judge Middleton calling. I show Tyler Grimm versus unauthorized occupants today at 2:15. No, let's see what we got here. Set for 2:15 on Monday, June 2nd. I won't be here Friday, June 9th. All right, we'll do the best we can. Thank you. All right. All right, we'll see you in a minute. Okay. All right, but. All right, Mr. Rognus is going to join us. He's in his casual clothes, but we'll make it happen. Ms. Patterson, I called Mr. Robertson. He's going to join us here. He had it on the wrong date for his calendar. I'm not sure what we're going to do here, but we'll make some progress.
Sure.
Maybe. Are you on the patio that we had a case about?
Are you speaking to me, sir?
Yes.
No, no, sir.
Did we have a case about your pavers or something on your space?
No, sir. I'm in New Hampshire.
All right.
I'm just doing my Zoom meetings outside because we have had rain day after day after day.
Sorry to hear it. I spent some time in New Hampshire driving back and forth to.
It's so beautiful up here. I love it.
Well, I spent some time in Hanover driving back and forth to Dartmouth, but it is beautiful. I've been there in the spring and the summer. All right, Mr. Rognus is here. He's got his official Judge McManus clip-on tie on, and we're going to address the matter of Tyler Grimm versus unauthorized occupants at 403 Enterprise Street. We were here on May 19th, and we adjourned the matter till today, June 2nd at 2:15. Tyler Grimm is not here. None of the occupants are here. Deanna Patterson is here, who is the sister to Michael Harker. This matter was complicated.
No, to Michael, the deceased, the owner of the house.
Michael Christensen?
Yes.
All right, I don't know why I wrote Harker.
Well, he is the one that lives in the house, but unfortunately, he does not have a phone and access to the internet, which I just found this out this morning. If I can speak, Your Honor, my other brother, Richard, about 5 days before my other brother died, he got news from the doctor that he had 6 months to live. He is very, very ill right now. I just found out this morning that he dropped the ball on the probate, dropped the ball on everything. So I had my assistant call in to Attorney Bush regarding the contract that was amended 2021. So we're waiting for a call back from him. I am just asking for an extension.
You don't have any standing here.
I know I don't.
You're not a lawyer, and you can't represent somebody else in a legal proceeding.
I know.
So you're a bystander who can provide information, but you don't have standing to ask for anything. We had the hearing on the 19th, but I don't think anything really happened with the defendants since then. Andrew, recap again why Mr. Tyler Grimm is the owner of the property.
He purchased the property from the original owners. He had some type of an agreement, and I said land contract, but it really isn't even a land contract with the now deceased Mr. Christensen, but nobody has undertaken probate proceedings, so there is nobody for whom there are letters of authority issued to do anything with this case. I surmise that possibly there may be something that they could pursue in circuit court, but really they haven't done anything and probably aren't gonna do anything with this case. I don't know how many opportunities you give them before you say, that's enough. Nobody with the appropriate standing has stepped up to do anything in this particular case.
When we were last here, there was an outstanding utility bill of $800. Has anybody paid the utilities?
As far as I'm aware, Your Honor, no.
The occupant tried to go and pay that bill, but the utility company said because it is not in his name, they would not accept the payment. So he did try.
So the person that's actually in there is Michael Christensen?
No, that's the deceased.
No.
Michael
Parker.
Mike Parker, yes.
And no clue how he even entered the picture here.
Because he was my brother's roommate, sir.
Okay. Well,
he's the one that found my brother. So
one of the occupants.
What he's known as a tenant at sufferance. There was an occupant that had some sort of a tenancy agreement with the owner. That person died. This person is there. He's not on a lease. He's not on a sales agreement. He's not related to the people that might have a property interest in the property. And the original owner, Mr. Grimm, wants his property back. Ms. Patterson's helpful in providing some background information, but she can't represent everybody or anybody and make any legal motions. The parties are there. This notice to quit was served way back in March 19th. And now we're into June and he's there. No one's paying the rent. No one's paying the utilities, and the plaintiff wants the property back. And he's not even here. So I find by default that the plaintiff has a right to recover the property 10 days from today, which would be June 12th. No money judgment is entered. They also have to June 12th to appeal this. I'm not sure, Ms. Patterson, whether Mr. Harker even has any standing. He's just there. Someone else owns the house and he would like to have it back. So now
But
you
my
said he has.
understanding-
Go ahead.
Sorry. My understanding is my brother owned the house because he put $25,000 down cash for land in 2021. And that's where I'm waiting for Attorney Bush to call my
But
assistant.
you may have some cause of action regarding that. Mr. Harker doesn't. He's just there. So if you and your family claims that you had some possessory interest to this house, but Mr. Harker's never even appealed for anything. And if it weren't for you, I wouldn't even know this much. Meg Bauer was here and offered to consult with anybody, was willing to consult. I don't believe that they ever did. So you can fight about who owns it. I guess you probably better get on it.
Yes.
But Mr. Harker has no standing and he has 10 days to move or he's subject to being evicted unless he appeals it.
Yes, sir.
All right, thank you.
Thank you.
Thanks for. All right, Andrew.
Apologize, Your Honor. I got this down for Friday and I don't know how that happened. I suspect that probably Mr. Grimm has it down for Friday as well, so.
Well, let's see what the note, I wrote clearly this day. The notice says June 2nd at 2:15. So anyway, we got it done.
Yeah, it
So
does.
let your client know and we'll see where this goes.
Okay.
All right, thank you.
I mean, I'll look for a call from John and see what's going on.
Well, you and Mr. Bush have worked on cases for 40 years, so maybe you can find some solution to this, but Mr. Harker's in a precarious position, and at some point, they're gonna turn the lights off unless something happens. All right, thank you, sir.
Thank you.
All right, we're going to stop the live feed. I'm gonna find out what the status of arraignments with the court officer is, and